Okay. We're back on the record in case numbers 2020-00349 and 2020-00350 regarding LG&E and KU's net metering and QF rates, in addition to issues that were discussed in the Commission's 8/12 order on the company's petition for rehearing. We ended yesterday's hearing having taken the company's witnesses, Mr. Arbo, Sinclair, Wolf, and Ms. McFarland. As I understand it, we have at least 2, maybe 3 witnesses left for the company. We also took KUC and AG's witness, Mr. Barron. And I think we continue to have Cassia and the joint interveners witnesses. Mr. Riggs, it's still your case. Would you like to call your next witness?
Yes, I would, Your Honor. Before we call our next witness, please, Your Honor, I'd like to make a motion, and I will confirm it in writing, that the issue of joint account liability, the company understands the concerns and understands that there needs to be some changes. We believe that the most efficient way to address this issue is not through the formal process of the hearing room, but through an informal conference where we can have informal exchange as opposed to the formal exchange that the hearing room itself prompts. And we would propose to schedule an informal conference with Commission staff and, of course, the opportunity for all the parties to attend at a convenient time next week. We believe that that method of discussing that issue is more likely to bring about a clear resolution of that issue that is acceptable to all and address the Commission's concerns than the formal process itself in the hearing room, the back and the forth of the data requests, that type of thing. The issue is as complicated as life itself, and that is not to say that this issue cannot be resolved. It can be, but the permutations and scenarios that develop under it can quickly become varied. And so we think an informal discussion of this and with the purpose of bringing about a resolution on this that's acceptable through an informal conference is the best way this morning to address this issue. And I will, of course, make that motion in writing tomorrow with the Commission. And I will send an email to Commission staff counsel to copy the parties, proposing some availability dates and times for next week.
And I think the commission, before you go, Mr. Fitzgerald, if you don't mind, the commission, I'm sure, will entertain your motion when it's filed tomorrow. The single question that I have on this issue is that the statutory deadline for the proposed tariffs is September 24th. It's been a while since I've looked at the tariffs that were proposed and initially filed. Did the companies know if any of those tariffs explicitly change or address that and would go into effect on that statutory deadline?
I have to check, Your Honor, and I will check and follow up with you at a break on that.
And I don't know that can be waived or amended or anything like that, but it would necessarily be something I think we take in consideration when
Yeah, certainly. I mean,
deciding on this.
for the sake of the discussion, if there's a term that,
Kendrick, I don't think people can hear you
Okay.
well.
excuse me. I take your point about the tariff. I will check at a break and I'll address that at the next break, if Your Honor.
I appreciate it.
So, but I take your point on the tariff and becoming effective and maybe creating an unintended, impediment to the resolution of the problem.
Okay. Mr. Fitzgerald, did you have something you'd like to say?
Yes, Mr. Chairman. I think I'm speaking for most of the folks who are participating remotely. I heard about half of what Kendrick suggested.
That's okay.
I heard that it's suggested that there be an informal conference, but the topic of what that informal conference is supposed to address is a mystery, I think, to myself and other folks, because he was speaking from the middle of the room rather than at the microphone. So
Yeah,
if you could, please repeat what it is he's proposing.
Yeah, I'll take what I heard, Mr. Fitzgerald, and I'll repeat it for the benefit, because I still think I have the better microphone of the two of us. So I think that Mr. Riggs was proposing to file a motion today or tomorrow, proposing an informal conference next week on the issue of, let's say, agency and liability. With
Joint account liability.
Joint account
service.
as it relates to service, and I think probably at issue in this case, the net metering credits that were discussed in discovery.
Thank you, Mr. Chairman. We'll wait and review the motion.
Right, so I will update you as to the commission's inquiry on the tariff after the next break.
Okay, thank you.
Thank you.
Right, and I take Mr. Riggs, it's okay. I take, given Mr. Crosby's position, that he'll be introducing the next witness?
Yes, Your Honor. Mr. Crosby will be presenting the next three witnesses.
The next three, okay.
Yes, sir.
Thank you.
Thank you. And I apologize for the parties for not speaking more loudly or speaking into the microphone.
All right, is there anything else before we begin?
No, Your Honor.
Okay. Mr. Crosby, please call your next witness.
Yes, thank you. Mr. Chairman, the companies would call Steve Sealer.
Okay. Mr. Seeley, please raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
I do.
Please state your name and address for the record.
William Stephen Seeley, 2604 Sunningdale Place East, LaGrange, Kentucky. That's my business address.
Okay, thank you. Please have a seat. Mr. Crosby, you may ask.
Thank you, sir. Mr. Seeley, by whom are you employed and in what capacity?
I'm with Prime Group LLC. I'm the managing partner of the Prime Group.
Thank you. Did you cause to be prepared and filed in this proceeding written direct and rebuttal testimony as well as supplemental direct and rebuttal testimony?
I did.
Are you the sponsor of data requests answered by the companies in these cases?
Yes.
Do you have any corrections or updates to your pre-filed testimony or responses to your data requests?
No.
Do you adopt your pre-filed testimony and responses to data requests as your testimony today?
I do.
Mr. Seeley, consistent with the practice we have in this proceeding, could you explain to those gathered here what it is that you have available to you?
Okay, all I have is a notepad, some Kleenex, water.
And Mr. Seeley, is Mr. Lovekamp also providing to you by a screen the record of these proceedings as needed?
He has.
Okay. Mr. Chairman, he's available for cross.
Okay, thank you. You were Mr. Horn or Mr. Cook this morning? Mr. Cook. Mr. Cook, do you have any questions?
No questions, Your Honor.
Mr. Kurtz?
I do, Your Honor. Thank you. Good morning, Mr. Seeley.
Good morning, Mr. Kurtz.
Are you familiar with the FERC PURPA regulations?
Yes, I am. When I first started working in the utility industry, PURPA had just been enacted. Therefore, I've been working with PURPA in some fashion my entire career.
Okay. Did you rely, at least in part, on the FERC PURPA regulations with respect to your testimony today?
Yes, I did.
Okay. I'd like to ask you some questions about those. Chairman, if I could just hand out some documents. I don't know if they needed to be marked or not because these are the FERC PURPA regulations as well as an excerpt from a FERC order, so
Okay.
they're certainly publicly available, but maybe for ease of reference.
Yeah, I think we would like to
Okay.
mark them for the benefit of the record.
Then I guess that the big package of the FERC regulations would be AG KIUC 1. Then another FERC regulation that is separately printed out, so this would be two. And finally, third would be an excerpt from July 16, 2020, FERC order amending the FERC regulations. Okay.
Mr. Kurtz, can I ask before you get started, like you said, this is a portion of this order. Do you have a copy of the entire order or a link to the copy of the entire order you can provide parties?
It's 400 pages.
Regretfully, I know how long it is.
We can probably, if Jody's on the, and she is, she can probably send it to the park. Oh, and by the way, we have these, Jody, if you can hit the send button and send these to the people remotely, I think we can certainly find a link to the order.
I would appreciate that.
Thank you.
Yes, Mike, I'll send it around to everyone.
Thank you. Okay. Let me start with, okay, QS, Mr. Seeley. QS come in two varieties, small power production and cogeneration, is that correct?
That's correct.
Okay. Small power production can be, it's in these regulations, I don't want to walk through them, but wind, solar, hydroelectric, biomass, geothermal, and waste. Is that correct?
That's correct.
Okay. Waste can be, among other things, bituminous coal refuse, anthracite refuse, petroleum coke, tires, plastic, refinery off-gas.
Yes.
So if you burn any of those waste fuels or produce electricity, like cutting down trees and burning them, or wind or solar, that's a small power production facility. That can be.
That's one category, yes.
Cogeneration comes in two varieties, topping cycle and bottoming cycle. Is that correct?
That's it. That's correct.
So topping cycle means you use cogeneration is also known as combined heat and power.
Yes, either you're to fill it in a little bit, a topping cycle, you use the heat to generate power on the top cycle. The bottom cycle is just the reverse. You reclaim the heat. So that's a very similar concept as a combined cycle generation. With a combined cycle generation, you reclaim the heat and run a second turbine. With cogeneration, you use a heat in a process. For example, medical centers will have steam plants. They'll use the steam for their own internal purpose and then generate electricity to achieve a higher efficiency of power. Therefore, the key there was efficiency.
And the purpose behind that cogeneration is you get two useful outputs from one fuel input. Therefore, Congress wanted to encourage that activity.
That's exactly right.
So there are a lot of, my point, I guess, there are a lot of different technologies and varieties of QS. So I think we've named probably about a dozen different types of QS.
Yes, that's correct. I mean, there are obviously more small power producers that can use various renewables to generate power, but yes, it comes in various varieties.
And I know the focus of this hearing has largely been on solar, but there's more to it than solar.
Right, and some of that depends on the geography where you are, if you have hydro available. And hydro has sort of fallen out because there are other issues with it. In this part of the country, you don't have a lot of wind. You have some wind generation. What we are seeing in a lot of areas of the country is more development of solar. But yeah, there are various categories. And for example, certain types of geothermal, you have to be around volcanic activity to take advantage of that.
But there's probably a fair amount of coal waste in Kentucky
Yes.
that could be burned. Okay.
Yeah, I mean, in other areas like wood chips, that's another area. In other words, if in a sawmill operation, you can take the waste product and use it as a fuel. That was the concept. You don't see a lot of those, but I've seen some working around the country.
What about paper companies?
Paper companies do it. And another big example is like soybean operations. They will have a lot of waste, and they'll have cogeneration, like Decatur, Illinois has some huge cogeneration facilities, some of the biggest in the United States.
Okay. All right. I want to ask you about, this would be Exhibit 1, the rates for purchase, which is, it's on 18 CFR 292.304. It's towards the end of the first package.
Okay. Haven't found it yet, but give me a second. You said 304?
Yes.
This is the fat package, right?
Yes.
I'm there.
Okay. So rates for purchases shall be just and reasonable to the electric consumer and in the public interest, paraphrase a little bit, and 2, not discriminate against qualifying cogeneration small power production facilities. And then item 2, nothing in this subpart requires any electric utility to pay more than the avoided costs for purchases. Is that your general understanding?
Yes.
Let me read to you an excerpt from this FERC order, this 400-page order, which is number 3. Or if you turn to the second page in the package, it's page 12 from the order, paragraph 13.
I'm there.
Purpose section 210B sets out the standards governing the rates purchasing utilities must pay QFs. Section 210B 1 and 2 provide that rates shall be just and reasonable to the electric consumers of the electric utility and in the public interest, and shall not discriminate against qualifying cogenerators or qualifying small power producers. After establishing these standards, Congress then placed in the final sentence of 210B a cap on the level of rates utilities could be required to pay. No such rule prescribed under shall provide a rate which exceeds the incremental cost to the electric utility of our alternative electric energy. I don't want to read too much of this, but that's the avoided cost price cap.
Yes, it is.
Now, just and reasonable to consumers, not just and reasonable to QFs. That's what the law says, right?
Not just, I think, well, let's see, let me verify that. I think it's, yes, that's what it says, just and reasonable to the electric consumers in the public interest shall not discriminate against qualifying cogeneration. Therefore, yes.
All right, we'll take a quick break.
Thank you. I tried to move something because of text.
Are we off the record?
Yes, we are.
Okay. I'll ask Mr. Rhodes, can you put us on mute, turn the video off?
I'm off the record, I guess I'm going to say. Myself, Jim, trying to move the keyboard. I think it's just kind of. Sorry, Chairman.
Take your time.
Keyboard kept falling. I think this is right. Mr. Chairman. Sorry about that.
Mr. Rhodes, when you get back there, will you make sure that we're streaming? Thank you.
The last question I have, Chairman, is just and reasonable to consumers, not QFs.
I can restart.
So, Mr. Kurtz, do you mind to start back? I think you were asking Mr. Seeley about, I think, the terms of the order about just and reasonable to whom.
Correct, thank you. So the standard set up in the federal law is that the rates shall be just and reasonable to consumers, not just and reasonable to the QF project developer.
That's what it says, yes.
So there's no requirement that ratepayers make sure that an investor in a small power production or cogeneration facility earns a reasonable rate of return on their investment.
Absolutely not.
Okay.
It's not in there.
While we're still on this exhibit, can you read paragraph 14 of this FERC order?
Yeah, the upper limit on QF rates established in section 210B equal to a purchasing utility's incremental cost, commonly called avoided cost, implements Congress's intent that QF not be subsidized. It ensures that the purchasing utility cannot be required to pay more for purchased power from a QF than it would otherwise pay to generate the power itself or to purchase power from a third party.
Is that your understanding about the structure the companies are proposing? Is your proposal consistent with that?
It absolutely is. If I could add one comment, that this definition is also incorporated in the Commission's regulations, and specifically 807 KAR 5054 adopts essentially the same language. And how that came about is that states across the country had hearings and investigations as to adopting the purpose standards, which the Commission did. I participated in those in the early 80s, and that's when it was adopted in the state. Therefore, the principles are addressed in the state regulations as well.
While we're at it, are there different standards for utilities that operate in PJM, East Kentucky, Kentucky Power, Duke, and/or Big Rivers, who operates in MISO, versus the companies here who are not part of an RTO?
Absolutely, there are.
What is that general distinction?
There's major distinctions because in both of those, both PJM and MISO, they're transmission organizations. That's how they started, and then they developed capacity markets. All of the participants or the owners, transmission owners, and the participants in MISO participate both in the transmission organization that basically operates the transmission grid, makes sure that things aren't discriminatory, et cetera. And more specifically, they all operate in an energy market as well as a capacity market. And all PJM's is probably a little bit more evolved ahead of MISO in adopting certain things, but they both have capacity markets, they both have energy markets, and only the members of PJM and MISO participate in those. Outside entities they don't fit those requirements. And I'll go further and say that.
Can I stop you right there and ask?
Okay. Sorry.
So what FERC has said is if your QF is located within one of these organized energy and capacity markets, as long as you can sell your output at fair market value as established by PJM or MISO, that's it. That's all you're entitled to is the fair market value of your energy and capacity.
Subject to a minimum. there's a minimum that applies, but other than that, absolutely agree with that.
Okay, what about the companies, here who are not in PJM or MISO? Were you going to tackle that part?
How LG&E and KU operate, you mean?
Yes.
Okay, they operate with traditional planning. In other words, they may participate in an opportunity market to sell excess energy, but generally they plan their system for their own resources. None of the rates that apply to PJM members that are approved by the FERC as it relates to PJM and the membership in that organization applies to LG&E. So they do not apply to LG&E. LG&E plans its resources to meet their own native load requirements. However, they may sell energy in the opportunity market and even to PJM members, but it's purely an opportunity market that they participate in.
Okay. Well, let me go back to 292.304 B2, which is at the middle of the very first page. Subject to paragraph B3, which applies to existing capacity. A rate for purchases satisfies the requirements of paragraph A, just and reasonable to consumers, not discriminatory against QFs, and not above avoided cost. If the rate equals the avoided cost determined after consideration of the factors set forth in paragraph E. So let's go to paragraph E, which is page 4 of 6. At the bottom, factors affecting rates for purchases.
Mr. Kurtz, can we just push pause for, Mr. Seeley, were you able to find those
I just
references?
did.
Okay, I just wanna make sure
Factors
he's fine.
affecting rates for purchases.
Okay, thanks.
Now, the first part of this is dealing with energy. State regulatory authority may establish rates for purchases of energy from a QF based on the purchasing utility's locational marginal price calculated by the applicable market-defined or the purchasing electric utility's applicable competitive price. So if you're in PJM or MISO, it's LMP. If you're not, it's the competitive price.
That's the way I read this, yes.
Okay. Competitive price is defined, page 2 of 6, item 7, competitive price. Let me know when you're there.
I found it, yes.
Okay, so this is for energy only, this is not capacity. A state regulatory authority may use a competitive price as a rate for as available QF energy sales to electric utilities located outside of a market, outside of PJM MISO. A competitive price is either a market hub price or a combined cycle price for energy. What's your understanding of market hub price? What would that be applicable to LG&E and KU?
The market hub price probably doesn't have much applicability to LG&E. I mean, there are various market hubs that the companies can sell into, but I don't truly believe it has an applicability because we're not a part of a new RTO.
Wouldn't the TVA interconnection be a market hub price?
That is a market hub price as well. PJM LG&E interface is a market hub price. So,
And
yes.
the KU interface with
Right.
MISO would be a market hub price?
Right.
Okay. The combined cycle price is down below. This is similar to what you guys use with your CSR buy-through price. A formula using a published natural gas price index, proxy heat rate, variable O&M of an efficient natural gas combined cycle facility, sort of a way to calculate an energy rate.
Yes.
Okay. But that's not for capacity. That combined cycle is not for capacity. We're in the energy section. Is that correct?
That's correct.
Now, let's go back to E, so that, then it gets into energy and capacity. Again, this is on page 4-6 at the bottom, factors affecting rates for purchase. At the bottom, alternatively, a state regulatory authority may establish rates for purchase of energy and/or capacity from a QF facility based on a competitive solicitation price. Do you see that?
I do.
Okay, let's go to competitive solicitation price is page 3 of 6, item 8. Let me know when you're there.
I'm there.
Okay, again, this is for energy and/or capacity. I don't expect you to have these regulations memorized despite your long history, but essentially, is your understanding if the utility who's not in a PJM or MISO does competitive solicitations for the procurement of its capacity, as long as the QF has a non-discriminatory right to participate in that solicitation, that's one way to determine a avoided capacity price.
Yes, absolutely.
Okay, you heard Mr. Sinclair testify that the companies have historically and intend to do competitive solicitations for new capacity.
Yes,
Is there any reason to believe QS would not be allowed to participate?
they absolutely could.
Okay, and so they can, if they're the most competitive price, they're the avoided cost, and that's what they get.
That's correct.
Same as the other utilities in Kentucky, the QS get the fair market values determined by PJM or MISO.
If they're a part of PJM or MISO, yes.
Okay. You see competitive solicitation price, II at the bottom, middle towards the bottom.
Is this a different document or?
No, same page 3 of 6.
Okay, yes. Okay, I'm there.
Tell me what this means. To the extent the electric utility procures all of its capacity, including capacity resources, constructed or otherwise acquired by the utility through a competitive solicitation price process conducted pursuant to paragraph so-and-so of this section, the electric utility shall be presumed to have no avoided capacity costs unless and until it determines to acquire capacity outside of such competitive solicitation process. So there's a presumption, as long as the utility keeps doing competitive solicitations for new generation, there's a presumption that the avoided capacity cost is zero.
That's what it says.
Because if KU or LG&E stopped doing competitive solicitations and stopped allowing QS to have a fair shot at it, then there would be then the presumption of no avoided capacity cost would be over.
That's correct, and it seems reasonable too.
Why?
Because they can participate just like anybody else in a competitive process. Therefore, they being a QF. And I think since PURPA originally, that these are changes that were made subsequently to the original PURPA documents to accommodate reality in the marketplace. And as things have evolved, they're just one party, just like any other party submitting a bid in a process. And the duty of utilities, regulated utilities, is to purchase or to acquire resources at the lowest reasonable cost. And therefore, using competitive bidding and RFPs to do that ensures that the company is acquiring resources at the lowest reasonable cost. Therefore, I think that's why this was incorporated into the Commission's regulations subsequently, because it reflects reality.
Okay, let's go back to E again, which is page 4 of 6. The bottom, factors affecting rates for purchases. where we left off was the competitive solicitation price, which we just discussed. Then it goes on, to the extent that capacity rates are not set pursuant to this section, capacity rates shall be set pursuant to subsection 2. And then 2 says, to the extent the commission does not set energy and/or capacity rates pursuant to the competitive solicitation, the following factors shall, to the extent practicable, be taken into account in determining rates for purchases. So, if there's no competitive solicitation process, which is what the companies do, then we go through these factors to determine avoided costs. Is that correct?
That's my reading of it as well, yes.
And these factors would be on, let's just go through them. I, the data provided pursuant to 302B, which is this is that separate statute, availability of electric utility cost data, which is AGKIUC 2. This is essentially, well, it's the information that the utilities are required to file to let the commission determine avoided capacity and energy costs, kind of like an IRP filing. Is that your understanding?
Yeah, that's my understanding.
2, okay, the availability of capacity or energy from a QF during the system daily and seasonal peak periods, including. So let me stop there. The availability of capacity from QF during the system daily and seasonal peak periods. As to a solar facility, does the solar facility contribute to the system daily peaks in the winter?
They do not on either LG&E or KU system, no.
What about the seasonal winter peaks? Do they contribute to that?
They measure seasonal peaks, say that again. I mean, you have your winter.
Would a solar facility contribute to the company's seasonal winter peak?
Seasonal winter peaks, no, they would not. Or say that again, I'm sorry.
Would a solar be on at 7 o'clock in the morning
No,
during the
it would not.
winter peak of KU?
Yeah, I just wanted to make sure you said solar, but yes, that's correct. They would not be on during the winter peak. And if I could add one thing in that regard, KU is a winter peaking utility, okay? On a combined basis, they are a bi-peak. And both systems together have occasionally very high peaks during the winter, and where their winter peak exceeds their summer peak. That's when you get extreme weather conditions. And what happens during extreme weather conditions, you got a lot of space heating on the system that really ramps up, and the combined system peak can be in a winter for both systems, and some of the highest peaks the companies together have had are during the winter, and that's at a time when solar does not generate any power.
Let's go to A, continue down the line. The ability of the electric utility to dispatch the QF. Can the companies dispatch intermittent resources?
No, they cannot.
Could the companies dispatch cogeneration if the contract provided for it?
Yes.
So on this one factor, the intermittent resource would get a less high of a grade or a 0 grade compared to a different resource that is dispatchable.
Correct.
Okay. What about the expected or demonstrated reliability of the QF? I guess a solar is reliable. If the sun's shining, it's going to produce.
Right.
In that sense.
It depends on how you define reliability. In terms of physical reliability, typically, I mean, there can be some issues because, for example, during the winter peak, you could have a foot of snow on top of the panels, which that could be considered a reliability as opposed to availability issue. But the other issue is, particularly smaller ones, the proper maintenance may not be performed, the inverter may not be working, but that's also true of other devices as well. So reliability, they're typically reliable if if they're well maintained.
C, the terms of any contract or other legally enforceable obligation, including the duration of the obligation, termination notice requirement, and sanctions for noncompliance. That would be a QF by QF determination, depending on what the contract said.
Yes,
correct?
and what QF could live with in terms of being willing, how long of a contract the QF would be willing to sign for that.
Because the contracts associated with a major QF purchase are lengthy, aren't they?
Typically, they're 20 years or longer, but typically 20 years is a very common term for those.
So counterparty strength, penalties for non-performance, all these different covenants, assignability, all these different things, that would be contract specific, would it not be?
It would be.
To put this in perspective, how much per KW does a utility grade solar facility cost?
How much per
KW,
KW?
capital cost?
I'd have to think about that one. Off the top of my head, I wouldn't know per KW. I typically think of it in terms of kilowatt hours because it's an energy resource and
Right.
not typically a capacity resource.
I'm talking about the construction price. So how much would it cost for somebody to build a 80 megawatt solar?
Yeah, I'm not the right person to, I haven't even thought about it in those terms of how much it would cost for that. I typically look at it in terms, I've worked with it, but I just can't recall on a per KW or per panel facility. Per kilowatt hour, I can tell you.
If it was $2,000 a KW, wouldn't that be 160 million to build
Yes,
an 80 megawatt
yes,
facility?
I agree. Yes.
Did you hear Mr. Sinclair testify that the payments from consumers under an 80 megawatt cogeneration facility under the pricing he was looking at could be 240 million over 20 years?
That's exactly right.
So these are major, these can be major utility scale big deals.
Yes, they typically are, and the more efficient ones typically are.
Who typically owns, I mean, I get distributed generation, a homeowner owns it and he's located in Louisville, but who would come in and, who owns these utility scale multi-hundred million dollar solar QFs?
Generally, it's like investment groups, hedge funds, groups that can put up a portion of equity in acquired debt for project debt typically for those projects. It can be a big organization, it could be even a publicly traded company, but typically a lot of them, they do project financing and it's a larger company that backs up the equity for it. And the project financing, they will typically have, medium to high leverage on the financing. So they're typically large organizations that do it.
But based upon the provisions of the law that we've read, there's no reason or justification or requirement that consumers in Kentucky subsidize hedge funds that might own one of these big facilities, is there?
No, there's nothing like that.
D, to the extent to which scheduled outages of the QF can be usefully coordinated with scheduled outages of the electric utilities facilities, would that apply to solar?
Read it again, and where is it?
D, middle of the page, coordinating scheduled outages.
I must be on the wrong page.
Okay, page 5 of 6.
Right, and could you repeat the number again?
D is in dog.
Oh, okay, to the extent, yeah, I'm there.
So if it's a cogeneration facility, they can do their maintenance in the spring or the fall, coordinate with the utility, that type of thing.
That's exactly correct.
So without going through all these, does this lead you to believe that if you get to this section of the regulation, you're doing a project-specific avoided cost based upon the characteristics of the power plant, topping cycle, bottoming cycle, solar, hydroelectric, wind, biomass, waste coal, etc. You would do a project-specific avoided capacity price.
That's correct. They all have their advantages, and they would all take those into consideration.
So, in your opinion, a one-size-fits-all capacity price would be inappropriate under this section of the regulation?
Yeah, they're not comparable technology. They're not technologically neutral. They're different.
Let me, I think I'm done with the regulation, but I do want to ask you a little bit about, it's your position that consumers should not pay for the capacity of a QF power plant until the QF power plant is needed.
You shouldn't pay that cost until it's needed.
So if the need is 2028, consumers should not pay an avoided capacity cost until 2028.
That reflects 2028. Just to bring a little clarity to the company's position, to my position as well, is that if there's a long-term contract, say a 20-year contract, during the intervening years between 21 through up until 2028, the capacity cost is zero because there's no capacity need. Therefore, the companies should not be paying for capacity, avoided capacity cost when there is no avoided capacity cost. And there would not be a problem with a 20-year contract that incorporates 28 and beyond avoided cost if you discount them to present dollars and then levelize them over the 20-year period and put it on a level playing field with zero cost during the intervening years when there's no capacity need.
So it sounds like the choice of discount rates would be important in this process?
Absolutely it would be.
What discount rate does the company propose for that?
The company proposes the weighted cost of capital, which is a standard approach in the industry. Most jurisdictions, when they evaluate, every one that I've worked in, when they look at IRPs and they look at these types of things, they use the company's weighted cost of capital. And as Mr. Barron testified yesterday, arguments used to be made that something higher should be used. Okay, because consumers, cost of money, if you will, cost of capital is presumably higher. But over the years, I've seen that argument sort of drift away. And in most jurisdictions, Colorado, Minnesota, other jurisdictions I worked in, the company's weighted cost of capital is used for purposes of discounting.
Is there another proposed discount rate in this record?
Yes, it's essentially a risk-free rate, which I have never seen applied in IRP, in planning processes or any of these calculations. And what that would be is essentially risk-free rate would be essentially a treasury bond rate, say a 20-year treasury bond rate. That's typically in risk premium analysis, that's what's used as the risk-free component. And almost all utilities and every party besides presumably the federal government operates with some risk. That's why it's generally not used. It's inappropriate.
What is the risk-free rate treasury
It's
bond?
right now it'd be about 1.4%.
Okay, so under that 1.4% discount rate, we inverse the question I asked Mr. Barron. If a homeowner has a credit card balance she would be essentially paying for, she would be loaning money to one of these hedge fund developers at 1.4% when she's paying 18% on her credit card.
Conceivably, yes. 16, 18%, yes. In terms of a credit card debt, that it would be in that neighborhood.
But she would be loaning money to the developer at 1.4% if
Yeah,
that's
they
what
would
the
be very generous, and that's at a lower interest rate than any hedge fund could borrow at. So it would be inconceivable that they could borrow at such a low rate.
But if we use that as a discount rate, the consumer is lending to the developer at that rate.
Effectively, that's what it's doing. Yes, absolutely.
So let me go back to distributed generation. There's a 1% cap, as we know, correct?
On which one, net metering?
Yeah, the net metering, I'm sorry.
Yes, there's a 1% cap, yes.
And to the extent that the buyback rate is higher or lower than it should, it's all at least staying local, right? It's the local homeowner in Louisville or in the service territory. I know there's been a lot of argument that the payment's too high, payment's too low, but at least it's capped at 1%, and at least it's staying within the local consumers.
I agree with that. From my perspective, this is a cost of service perspective. Avoided cost is avoided cost. And the commission has articulated in its Kentucky Power Order and more specifically in the KU rate cases that avoided costs are to be used to determine the 7 cost components that we are to look at. The company was directed to submit testimony on 7 cost components that were to be based on avoided cost. Therefore, regardless of whether it stays in Louisville or not, the commission has articulated a principle that, in my view, is an appropriate principle that avoided costs should be used for both. Therefore, I don't see a difference.
Well, I want to this practical difference. There's no cap, there's no 1% cap on the amount of QF energy or capacity that must be procured at a rate that cannot exceed avoided cost.
That's a big concern, but yes.
So there's no cap, right?
Yes.
On the QFs?
That's correct.
And if a hedge fund somewhere is the owner of these, one of these utility scale QF facilities, then the money isn't staying local. To the extent that there's an overpayment, the money's not staying local within the service territory anyway.
Presumably not.
So is the QF, in terms of the rate impact, a greater concern perhaps than the net metering?
It creates a greater risk. And especially if you exceed avoided cost, if you're exceeding avoided cost for a qualifying facilities, then you're paying more than what the company could get in the market. Would not follow the lowest reasonable price principle that the company follows in running the operations. Therefore, it creates a major risk and potential cost increase to customers because there is not a limit. Ultimately, in my view, there should be a limit because you shouldn't be paying avoided capacity costs when the company doesn't need it. And if it's wide open, if there's like 200 megawatts comes on the system that the company has to pay above avoided capacity cost, then it creates a major problem for consumers, for the utilities ratepayers.
Chairman, no further questions.
Thank you, Mr. Kurtz. Regretfully, you've added a couple more questions for me, Mr. Vasili, regretfully for everybody. How did we go yesterday? So there were no questions for the Attorney General's KIUC. Mr. Spinard, do you have any questions for Mr. Seeley?
Yes, Mr. Chairman.
Okay. Please proceed.
Okay. Good morning, Mr. Seeley.
Good morning, Mr. Spinard.
And if, for whatever reason or reasons, if you don't hear me, just let me know, okay?
Okay, thank you.
Okay. With regard to your participation in these proceedings, and this is by reference to the applications that were tendered on November 25th, 2020. And I looked at your exhibit WSS-1, and this is a statement, summary of qualifications.
Yes.
And so is it fair to say that by education, training, and/or experience, you have technical or other specialized knowledge regarding rates, and your knowledge will assist the commission in understanding understanding the company's applications? You're here as an expert witness on rates, is that correct?
That's correct.
Okay. And supplemental testimony was filed into the records on July 13th, 2021 that included your testimony.
Supplemental testimony, yes.
Okay. And then supplemental rebuttal testimony was filed into the records on August 5th, 2021, and that also included your testimony.
Correct.
Part of it. Okay. Now, in terms of your supplemental testimony that was filed into the record on July 13th, if that could be made available to you, I'm looking specifically on page 13, beginning at line 14, and this is going to be PDF page 55 of 161. And can that be made available to you?
It says avoided ancillary service costs, is that where you are?
Yes,
Oh.
exactly. Section 4, avoided
I'm there.
ancillary service costs. Okay, now, beginning on page 13, line 14, continuing through page 22, line 9, you discuss avoided ancillary service costs. Is that correct?
I address ancillary service costs, yes.
Okay, now, with regard to we're going to jump back, but I just want to be clear on this point. With regard to your supplemental testimony, rebuttal testimony, you also continue the conversation regarding ancillary service costs.
I do.
Okay, so for your supplemental testimony, and I think we can do this by simply one example. You discuss KU and LG&E's open access transmission tariff. Is that correct?
Yes.
Okay. And is the OATT on file with the Federal Energy Regulatory Commission?
Yes, it was filed with the FERC.
Okay. And beginning on page 16, line 9 of your supplemental testimony, you discuss Schedule 3 of the OATT. Is that correct?
That's correct.
Okay. If I understand this, the Schedule 3, these are an ancillary service charge that applies to power that is transmitted for third parties across the company's transmission systems. Is that correct?
That's correct.
Okay. And on page 17, beginning at line 4, you identify, this is part of the answer, and please understand at any stage for completeness standpoint, if you need to add something, we're going to do that. So I'm not trying to cut you off, so to speak. Okay. But when we begin on line 4, you state, I see two alternatives, and then first you discuss, to paraphrase you, first you discuss compensation based on Schedule 3 charges set forth in the company's OATT, and then second, you state that the charge could be determined as 1% of the avoided generation capacity cost approved by the Commission in the export compensation rate for NMS2. Do you see that?
I do.
Okay, now, and this is one of the things that when you're talking about approved by the Commission on line 6, are you referring to the Kentucky Public Service Commission?
That's a good point. I meant the FERC.
Okay, all right.
Yeah, That's a good observation.
Okay.
A different commission.
Right. And and just to step back for a second, in all of the discussion that you had in your cross-examination by Mr. Kurtz, for example, in KIUC Exhibit 1, they're using state regulatory authority to distinguish. Generally, they'll use state regulatory authority. When they say commission, they mean the FERC. When they state regulatory, they mean bodies like this Kentucky State Public Service Commission. Is that generally?
Yeah, that's generally correct.
Okay, all right.
Yeah, if I could add something on the ancillary service cost, the company's view on these is not to use these two alternatives, but to use zero, because the avoided any of these schedules, particularly 3, 5, and 6, are calculated as percentages of a capacity resource. To the extent that there's an avoided capacity component included, then the ancillary services would be provided by the avoided capacity. Therefore, it's my view in the company's position that any ancillary service costs, particularly that I'm referring to now, 3, 4, 5, and 6, would be incorporated in the avoided generation capacity that's being voided. Therefore, it would be a double count, if you will, to include ancillary services. That's our view on it. And the same thing applies to Schedule 2, because Schedule 2 recovers reactive supply. Therefore, to the extent that a solar facility could provide reactive power, which is not required and is frankly without a control of the smart inverter, not even possible. But let's assume that you could, it would be included in any solar farm that would be avoided. And even if you would look at any other avoided generation facility, avoided generation facility, like a combined cycle unit or a combustion turbine or any other type of facility, they all have the ability to produce reactive power. And solar doesn't necessarily have that ability unless there's a smart inverter and the power electronics to control the frequency of the voltage. So any avoided cost would already be there, is the point, in any kind of capacity cost.
Okay. Well, and I appreciate the answer. I just want to clarify something for just going back to your testimony, lines 4 through 7 on page 17 of your supplemental testimony. I just want to clarify this. If I understand the first part, is it your testimony that the company's position is that this amount should be zero?
That's the company's, my recommendation in the company's position, yes.
Okay. But then further, the second part of it would be that even though the company's position is zero, you do identify two alternatives for setting the cost.
Yeah, if the commission in its wisdom decides that I'm incorrect and that there should be a component, then there are two alternatives. The two alternatives both look at the company's ancillary service and not something that's approved to PJM that doesn't apply to the company. And that's the important point here. It should be KU and LG&E's avoided ancillary cost, not imported from a filed rate in another jurisdiction, in another company. For example, a recommendation's been made to use Kentucky Power's ancillary service charges. KU and LG&E are not Kentucky Power. Their filed rates, Kentucky Power's filed rates do not apply to LG&E and KU. Therefore, it should not be used. If anything's should be used, it should be tied to the company's own ancillary service rates that have been filed and approved with the FERC. That's the point of this.
Okay, well, thank you for that answer. One moment, please. It's because of the comprehensiveness of the answer I can eliminate some questions. With regard to KIUC Exhibit 1, which has been presented this morning, there was, and I have several different notations in terms of when the conversation began, and at this stage the record will speak for itself, but there were, do you recall a number of hypothetical questions that were related to hedge funds and all of this very free-ranging discussion with hypotheticals?
Yeah, about who could own a solar farm, yes.
Okay. With regard to the testimony submitted with the application, with regard to the supplemental testimony that you submitted, the supplemental rebuttal testimony that you submitted, where in any of those testimonies was that the subject? Was that the subject of any of your testimonies? That all of the discussion about the hedge funds?
What was a subject of my testimony that started it down that path is the definition of avoided costs. And in my supplemental testimony, I basically quote from the FERC the same regulations that Mr. Kurtz walked me through this morning. But another relevant point is that the commission adopted those original regulations that were established by the FERC, or established by Congress through PURPA, through the adoption of PURPA, which required all the states to address it and establish standards. And the commission established the same basic definition, maybe the exact definition that was set forth in the FERC regulations.
Okay. Mr. Seeley, thank you very much. Appreciate it. And Mr. Chairman, no further questions.
Mr. Miller, do you have any questions for Mr. Seeley?
Thank you, Mr. Chairman. Just a couple few, I think. Good morning, Mr. Seeley. Coming to you from Denver, sorry I couldn't be there today. Just kind of following on that line about the QS, just for perspective, are KU and LG&E wholly owned
Your Honor,
subsidiaries?
I hate to interrupt. I don't think Mr. Seeley can hear anything Mr. Miller's saying right now.
All right, Mr. Miller, and it's a function of our prison that we've put Mr. Seeley in with the plexiglass, but I think you may need to speak up a bit in order for Mr. Seeley to hear you.
How is this?
Is that better, Mr. Seeley?
Yeah, I can hear. Good morning, Mr. Miller.
Good morning, Mr. Seeley. How are you?
Oh, I'm doing well.
Wish I could see you there in person today. Just a couple questions. I just thought I'd ask for perspective. There was some discussion about institutional investors of QFs. So just to confirm, are KU and LG&E wholly owned subsidiaries of PPL Corp?
Yes.
And does it sound about right to you that approximately 2/3 of PPL shares are institutional investors like funds and banks?
I have no idea. I have no knowledge about that.
Okay. I'll just try one more, and if you don't have knowledge, that's fine. Would you be surprised if the top 10 investors are institutional like Vanguard and BlackRock?
Vanguard's major investors in almost everything, so that wouldn't surprise me.
Okay. And as far as, QFs or PPL for that matter, building things and operating things in the Commonwealth, regardless of ownership, could those still support local jobs and bring local benefits to the Commonwealth?
The facilities that are installed,
Yes, sir.
that's hard to say. I don't know if it would create local jobs or not for QFs. They could bring them in from Ohio, for all I know, to install the facilities. So the installation of the facilities would be the largest. The cleaning the panels, I mean, they could even, they could import people on that. So that's hard to say. It depends on the expertise that is needed to install it. And I could see other areas bringing in employees, because relatively speaking, Kentucky has a smaller amount of solar than they do in many other states.
Very well. But it sounds like you're not certain about that. And would you agree that it's possible that that could be an area of growth in Kentucky?
They could develop the skill sets to do that in Kentucky, yes.
Very good. Thank you, sir. I don't think I have any other questions. I appreciate your time. You'll take care.
So, Mr. Fitzgerald, I'll just ask, I assume you have questions, but do you have questions for Mr. Seeley?
Just a couple, Mr.
Okay,
Chairman.
so, Mr. Fitzgerald, given that's the case, and given that it's 10:30, I think it may be a fine time to take a break right before your questioning of Mr. Seeley, so that we don't run over our planned break after the first hour and a half. So we'll take let's call it a 10-minute break, a little more than a 10-minute break. Before we go, I do have one thing. So we'll come back at 10:40, and Mr. Fitzgerald will be able to ask all the questions his heart desires of Mr. Seeley. Before we go, Mr. Crosby, I have one question, and Mr. The break is a good opportunity to ask it, and if it can't be answered now, that's fine. You'll have an opportunity, of course, to brief this.
Okay.
But Mr. Kurtz's questions to Mr. Seeley, and this will probably alleviate a lot of the questions I have now for Mr. Seeley, and it puts, frankly, in a tough spot since Mr. Seeley doesn't necessarily work for the company. Right? He's not an employee, he's an agent, but not an employee. The questions, I guess it's not clear now, the questions from Mr. Kurtz, whether the company's proposal with using the Roods Creek or the level 10 data is necessarily in anticipation or in compliance with the section for competitive solicitation prices for QFs under PURPA. Does that make sense?
I believe I understand that.
So
yes.
Page 3 of 6 of that final section that Mr. Kurtz was discussing lays out a very specific number of criteria that have to be satisfied in order to set an avoided cost under the competitive solicitation price. And up to this point, I think my knowledge is California is pretty much the only place that has done this previously. And it's a legal issue, not an evidentiary issue. And I guess really my question to council is that specifically what the company is proposing? Because if it's not, and there's this mix-up and that's fine, I just don't need to ask Mr. Seeley or Mr. Connery any questions about it. But if it is, it would be handy to know it now. But it is strictly a legal issue, and I have down here that I would like to make sure you all brief the issue if that's what you're proposing. But I think that maybe taking the break may be a good opportunity for you all to talk about it and come back and discuss it after the break.
And just to make sure I understand you clearly, Mr. Chairman, so the question is anything around the methodology that Mr. Sinclair proposed for QF rates intended to comply with or address the federal regulations that Mr. Kurtz talked about? Is that a fair?
Yeah, and I would say it like this: is the company intending by its proposal to implement the competitive solicitation price section of PERPA.
Okay. Okay, thank you. That's clear. Thank you,
All
Mr.
right,
Chairman.
so we'll take a break for the next 10 minutes until 10:40. Mr. Rhodes, are we? Great. Before we start, Mr. Riggs, do you have something?
Yes, sir. Mr. Chairman, at the last point of my discussion with the commission and the parties about the informal conference, the commission inquired, was there a tariff condition or term and condition that would restrict our ability to change the way the companies address closing accounts or the joint ownership of accounts, and there is not. So if the commission were to approve in its final order before September 24th, the terms and conditions of the tariff, there would not be, in doing so, create a restriction from the company being able to change the way its internal processes address the transfer of joint and several liability or service accounts or how those accounts will close.
Okay, so. Just wait a minute. So, said differently, because I want to make sure that our entering an order on September the 24th without addressing this does not preclude the issue from being taken up in this same case in a subsequent order.
The only pause I have is whether you can issue a subsequent order in this case if you've issued a final order.
Well, we have to issue an order on tariffs proposed within
Right.
10 months, but we don't have to necessarily close a docket or close a case. So, for instance, on the issues of the legal fees, right? They're not subject to the tariffs. The tariffs have already been ruled on within the 10 months, and rehearing has been issued,
Correct.
which is not, as I understand it, limited by the same 10-month statutory deadline.
That's correct, Your Honor.
And that's what I want to make sure of, because my experience has been, as I've read the statute, and I obviously can't speak on behalf of the commission itself, but that when a tariff proposal, let's just say a generic tariff, if it is not suspended and investigated, not ruled upon, if it's suspended but not ruled upon within 10 months, it goes into effect, and that's it. For that tariff, the commission then would have to initiate a separate docket in order to investigate it, create a record if they wanted to amend it. I just wanted to make sure that that wasn't necessarily implicated by this.
Your Honor, I want the company wants to cooperate completely on
Okay.
all issues, and particularly on this issue, to get to a resolution on it. My only reservation is that this issue is not an issue, that is the transfer of joint account liability is not an issue under hearing, it's an issue in this case. And my pause is only whether the commission can address this issue in a subsequent order after the commission has ruled. So give me a moment to just think about that.
After it's ruled on the tariffs.
Right.
Okay.
So the commission issues an order on before September 24th, ruling on the tariffs and these issues, and then wants to preserve the issue of the transfer of joint account liability or a subsequent order.
Yeah, and I think it's probably, I think what you and I may be discussing is an issue of form as much as anything.
Form and procedure.
Because I think that at a worst case scenario, the commission could address it however it does in the September 24th order and enter a separate docket, incorporate the record of this case, make anybody who wants to be a party, and we can deal with that very specifically narrow issue in that separate docket.
Yes.
That's a backstop to the entire conversation. So if you could just ruminate on that topic.
Yeah, I would agree with that backstop completely.
Okay.
I would share the general interest of all concerned of not opening one more case.
We appreciate that too. But please think about that
Yeah. Okay.
single issue and how it implicates our September 24th order, because there's certainly a lot of work that all the parties have to do, but including the commission, between now and September the 24th.
Thank you.
Okay, thank you. All right, Mr. Crosby?
Yes, Mr. Chairman. With respect to the question that you put to me before we took the break, the company's response is certainly the methodology that Mr. Sinclair proposed in his supplemental testimony does not reflect in any way intentionally anything around the federal regulations that Mr. Kurtz discussed with Mr. Seeley. And the companies are not requesting in any way that the federal regulations be applied to them in any way differently. The company's view is, and I believe it's the commission's view, is that the Kentucky regulations concerning QFs are what apply to the companies and their conduct concerning QFs. So we are not requesting a change in that regard at all.
Okay, so just to make sure that I'm clear, you're not,
Yes,
the companies aren't proposing to use that solicitation process as a way of setting the avoided cost. You're just proposing that the otherwise purchase, that might be a paraphrase, but the otherwise purchase portion of the Kentucky regulations, you're using proxy is probably the wrong term, but you're using the Rouge Creek or the Level 10 as an input saying that's what we think we would otherwise purchase. Is that fair?
I think that's accurate.
Okay.
Just to say, the standard is in Kentucky and has always been, to my knowledge, avoided cost. And this is the company's attempt to put before the commission, here's a methodology for calculating avoided costs. But we're not asking to have regulations changed or applied differently, same construct. It's just a proposal about how you would calculate such costs for your consideration.
And I appreciate that, because this is a whole new game, the competitive solicitation price. So I wanted to make sure that that wasn't necessarily what was being proposed. So thank you for that.
We'll brief whether or not the state has to follow the federal regulation on this issue.
And on which parts? Yeah, and I do have notes for a couple of things that I'd like brief on that, particularly the applicability of the different proposals, the company's proposals, the intervener proposals, and how they comply or don't comply with the state and federal, the state regulations, statutes, and the federal CFRs. Thank you. So thank you very much for
Certainly.
spending your your short 10-minute break on getting an answer to that. Mr. Fitzgerald, do you have questions for Mr. Seeley?
I do.
Okay, please proceed.
Mr. Seeley, can you hear me?
I can, but it's low. I'm in the cone of shame, so.
Okay, well, I'll try to be Maxwell smart, and you can be the chief. Can you hear me better now?
I can, yes.
Okay, well, if I fade there and you can't hear me, please let me know, okay?
Okay.
Do you know how many utility scale QFs there are in Kentucky?
Are there utility scales? I believe there are. I'm not the best person to answer that question, Mr. Fitzgerald, but I believe there are. So you froze.
Okay, do you know if there are in LG&E or KU service areas?
I missed that. Could you repeat the question, Mr. Fitzgerald?
Yeah, do you know how many, if any, utility scale QFs there are in LG&E or KU service area?
I do not know. I'm the wrong person.
Okay,
Mr.
so I
Sinclair
assume that
would have been the best person.
Okay, I assume then, okay, well, it's just you and Mr. Kurtz had a lengthy conversation regarding the ownership of QFs, and I was just curious, do you know who the owners or investors are of any of the QFs in Kentucky?
No, I do not.
Okay, so I assume from that despite Mr. Kurtz's implication that they are owned by hedge funds, you have no knowledge of whether they are or are not.
My knowledge is more general, working in other jurisdictions and working with other utilities. I know that many of those that operate with other utilities, because I have dealt with them on negotiations, are owned by a hedge fund. My knowledge did not, I wasn't mentioning specifically the ones operating behind utilities in Kentucky, but in general, based upon my general knowledge.
Okay, well, I'd like to move on from hypotheticals that have no basis in the record in this proceeding to ask you a couple of questions regarding PURPA and the Federal Power Act. Are you comfortable answering those questions?
Yes, I've worked with it for a long time.
Okay, and you seem to have familiarity with the purposes and the scope of PURPA. Do you also have familiarity with the scope of and the purposes, the regulation jurisdiction under the Federal Power Act?
Which regulation? I don't know them by number, but if you could be more specific on what regulations we're talking about.
Certainly. Let me ask it in this way. Is it your testimony that this commission is limited in defining which costs may be avoided or reduced by introducing fed-in power from net metering customers, that the commission is limited to using the definition of, quote, avoided cost, end quote, that arises under PURPA and is codified at 18 CFR 292-101?
The commission, in its Kentucky Power order and in LG&E's order, directed the company to use avoided cost. The company's, or the commission's regulations define avoided cost. Therefore, I don't think necessarily the statute requires that for net metering customers, but by the commission's own order in both the Kentucky Power case and the LG&E case, the commission identified 7, quote, avoided cost components that are to be considered in developing the rate. Avoided costs are defined in the company's own statutes. Therefore, the definition should rationally, as well as from a regulatory perspective, it seems to me, be consistent. Therefore, I think it's more by the commission's order as opposed to the statute. The commission has ordered avoided costs to be used.
Okay. You say the commission has ordered avoided costs to be used. Are you saying that they've ordered that the definition of avoided cost that is in 807 KAR 5054 is to be used?
Well, that defines avoided cost. It's a reasonable definition of avoided cost, but what I'm saying is on page 35 of the commission's order in these proceedings, the commission said that the company is to look at 7 avoided costs. Therefore, the commission's own regulations define avoided costs. Furthermore, there's no logical reason that the avoided cost, particularly, take for example, capacity component for solar should be any different than the capacity component of a qualifying facility. Avoided cost or avoided cost. Therefore, they should be the same. There's no rational basis for using something different.
Yet the commission order in the Kentucky Power case used set out a series of principles and also set out a number of specific cost components that are not in the definition of avoided cost that was created by FERC under PURPA. Is that correct?
That is correct, but 2 of them are the same.
Okay.
Specifically, if I could elaborate on that, avoided energy costs are in PURPA. Avoided generation capacity costs are in PURPA. Therefore, 2 of the 7 are clearly in PURPA, clearly in the commission's own regulations regarding QFs. Therefore,
right.
Avoided cost or avoided cost.
I'm sorry, go ahead.
I say that avoided cost or avoided cost. You know, you can't
right.
rationally create a new definition of avoided cost to suit a particular purpose. You should use the one that's well established.
And one that by law is not applicable to the relationship between a retail customer and a utility under net metering. Is that not correct?
It's not in the statute, if that's what you're asking. It's in the commission's order. The commission ordered avoided costs to be investigated. And it
we'll let the commission order speak for itself. Mr. Seale, I understand. We'll let the commission's order speak for itself. Are you familiar with a group that called itself the New England Ratepayers Association?
That sounds familiar. I can't remember.
Okay. Are you familiar with a petition that was filed by the New England Ratepayers Association with the Federal Energy Regulatory Commission seeking a declaratory order that FERC had exclusive jurisdiction over wholesale energy rates from generation sources on the customer side of the meter, and that those rates had to be priced in accordance with the Federal Power Act and PURPA?
That's a federal jurisdiction issue. It sounds vaguely familiar, Mr. Fitzgerald.
Okay. Are you aware that by a unanimous FERC order issued on July 16th, 2020, in docket number EL20-42-000, FERC denied that request and declined to issue a declaratory order that the rates set by public service commissions for net metering between a utility and a retail customer are in any way constrained by the Federal Power Act or PURPA?
I agree, and I'm not saying that they are.
Okay, I just want to make sure that we're clear that nothing in federal law and nothing in federal regulation limits the ability of this commission to define what are the cost components or the benefits that should be considered in determining the appropriate.
Go ahead.
I'm sorry
for cutting you off. Go ahead.
That's fine. I can repeat it. I just want to make clear that you are not suggesting that this commission is in any way constrained by federal law or federal regulation in defining what costs are avoided or what benefits accrue from fed-in energy from net metering customers, or in how that compensatory rate should be set.
I will answer it this way. I think the commission has to operate by its own regulations. So I agree with you there. Let me add, though, that certainly the commission could be informed. Certainly the commission could be informed by other FERC orders, FERC regulations, but I think there's a statute on QF and there's a statute on net metering. That's what the commission must follow, and it should follow its own precedent and its own orders, I suppose, in declaring that it's based upon avoided costs. And that's my point, is the commission issued an order that it's on, that these cost components should be based on avoided cost, and by consistency, by logic, avoided generation costs. There's not a difference, really. There could be term differences, there could be characteristic differences, but both of them should follow the definition of avoided costs that is set forth in the commission's own regulations.
Okay, and are you familiar with whether there is a commission regulation defining avoided cost in the context of net metering?
As I spoke to a minute ago, it was the commission who has established the principle that net metering should be based upon avoided cost.
That wasn't the
commission's
question.
own orders in these proceedings.
Yeah, I'm sorry, the question I asked was, do you know whether the commission has adopted a definition of avoided costs or cost relative to net metering?
Well, they use the word avoided cost, and for the life of me, I can't see why it would be any different. Avoided cost is a very basic principle and has a very basic definition. Therefore, there's a definition established in the commission's own regulations for avoided cost. I don't see why logically there should be any difference, or from a regulatory principle that they should be any different.
Okay, let me just make sure I'm understanding, and then we can kind of wrap this up. You agreed with me earlier that the cost components that the commission in the Kentucky Power Order indicated should be considered in determining what is the cost of service and the appropriate compensatory rate for fed-in solar, that the commission adopted a broader set of cost components that should be evaluated than appears in the definition of avoided cost under PURPA. Is that accurate?
Yeah, they added 5 additional components. There's 7 components that the commission identified. 2 of them are identified specifically in PURPA and the commission's own regulations regarding QFs. That's avoided energy cost and avoided capacity cost, but they added ancillary services, they've added transmission cost, distribution cost, et cetera. So, yes, the commission specifically identified 7 components.
Okay, all right. So, all right, well, I think that's all I have, Mr. Seeley. Thanks very much. Again, just for purposes of the record, the FERC order that I referred to is docket number EL 20-42-000. And, Mr. Chairman, if there's no objection, I would ask that it be, that reference be included in the record. It is a published order appearing at 172 FERC, paragraph 61,042.
Is there any objection to the introduction into the record of the NERA declaratory order request?
No objection, Your Honor.
Okay.
Thank you, Mr. Chairman. Thank you very much. I have no further questions.
So, Mr. Fitzgerald, I'd ask one request, if you could send a copy of that to Ms. Vinsel, and we will
Absolutely.
we'll enter that into the hearing log as joint interveners number 1.
Absolutely. I'll send a copy to everybody else as well.
And Mr. Curtis, before we go to Ms. Vinsel, I'll come back to you. You marked your AGKIUC 1, 2, and 3. I've made a request that 3 be supplemented with the 491-page version, just so we have the entirety of it for the record. But would you like to move to introduce these?
Thank you, Chairman. Yes, I would.
Okay. Is there any objection?
No objection.
Okay. So we'll have these marked as AGKIUC 1, 2, and 3, and we'll later supplement 3 with the entire order. All right. Ms. Vinsel, do you have any questions for Mr. Seeley?
Yes, I do. Thank you very much, Chairman. Good morning, Mr. Seeley.
Good morning.
Please let me know if you ever can't hear what I'm asking.
Okay, thank you.
I want to circle back to one thing that you said. I believe it was in Mr. Spinard's cross-examination, but I could be wrong. You said that solar without inverter does not support reactive power, correct?
No, that's not what I said. I
Okay.
said that solar without smart inverters typically cannot provide and respond to reactive power needs. And if I could
I wanna-
elaborate, smart inverters will have the power electronics to control reactive power that's supplied to the grid.
Can I ask you to look at LG&E or KU's, either one, response to staff's 7th request, item 36?
Ms. Vinsel, who's the witness on that?
And that's Mr. Wolf.
Okay,
It is not your response,
okay.
but I want to follow up.
Ms. Vinsel, is that in the packet that you provided?
This one may be in there, yes.
What is
Let's
it
see
again?
here. It is staff's 7th request, item 36.
It is. Thank you.
I'm there.
You there? Okay, thank you. I'm going to read, I'm going to give you the chance to look at it, but I'm going to read the part of the response to item 36A. The first sentence is, although not called out specifically as smart inverters, the companies do require that all inverter-based generation comply with all applicable standards and are certified to comply with UL 1741/UL 1741 SA. Going down to the last sentence. This certification verifies that each inverter is capable of smart functions such as real or reactive power, response to voltage, and ride-through capabilities for grid distribution in voltage or frequency. So it appears to me that that LG&E KU require that all inverters have those smart functions.
Yeah, I see that now.
Okay.
The traditional inverters did not have it. It's a fairly recent requirement for utilities to adopt or require new facilities to have smarter inverters, or so they can supply reactive power.
And right now, I would like to follow up on the previous cross-examinations regarding avoided cost definitions.
Okay.
And I would like to introduce, I've got printed copies of, take this down, it's Kentucky Revised Statute 278-465, which are the definitions that are applicable to the net metering statutes, and KRS 278-466, which has a good part of the net metering statute in it. I'm going to distribute this. I would ask that these be marked as staff exhibits 5 and 6. May I approach the witness?
Yes, thank you. May. So 278-465 would be staff 5,
Yes.
and 278-466 would be staff 6.
Yes, that's correct. Thank you very much. Okay, to begin with, Mr. Seeley, are you offering your opinion that the definition of avoided cost in the commission regulation regarding small cogeneration facilities?
That's where the definition is established, is in the,
Yes, well,
that part of the
I'll finish my question.
Oh, okay.
Are you offering that opinion as a lay opinion or as a legal opinion?
obviously, based upon my experience working as in the rate and regulatory field for 40 years, but it's from that professional opinion, not as a lawyer, but as someone who's dealt with this for 40 years.
So as a lay opinion, would you agree?
It's, I don't know if I agree with the word lay opinion, but in terms of non-lawyer, if that's what you mean by lay, I'm not a lawyer.
Okay, that's what I mean. Did you go to law school?
No, I did not go to
And you
law
didn't
school.
pass any bar, thinking of California?
No, I'm not a lawyer. I've just worked around lawyers all my career.
Okay, so I want to ask you this then, relying upon your lay opinion. Are you familiar with either of these statutes?
Yes, I've read them extensively.
then can you point to me where in any of these statutes, the legislature said that the commission is to apply an avoided cost definition that's set forth in the cogeneration regulation?
I think I addressed that with Mr.
I
Fitzgerald.
know you did, and I'm sorry to
I'll reiterate
interrupt.
the answer. It's not in the regulation, it's in the commission's order where it's established that.
Yes,
It's not
so-
in the statute, which you've given me here as a statute, but it's not in the statute, it's in the commission's order. And that's how we were ordered, or the commission, or the companies were ordered to address avoided cost. That's what the companies did. That's what we calculated. The commission indicated that in the Kentucky Power case that it was based upon avoided cost. Therefore, my opinion here is based upon my reading of the commission's order, not these statutes. I agree that the word avoided cost is not used in these statutes.
So I want to make sure that I'm clear and I'm not putting words in your mouth. You are not saying that the commission is limited to considering only avoided energy and avoided capacity in calculating avoided costs in the net metering export rate?
Perhaps not, but the commission has established principles. So the commission can change its principles, I suppose, and can reverse course and use something different. But the commission clearly established the principles that we were to address in this proceeding, which was based upon avoided cost. And the commission in the Kentucky Power case said that avoided cost should be used. In fact, the Kentucky Power was chastised for not using avoided cost in a couple cases. And so it seems to me that the commission has established avoided cost as the principles for establishing these 7 rate components. That's what it said.
And again, I don't want to put words in your mouth. I want to make sure I'm understanding what you're saying. That the commission established the principles for calculating net metering export rate as set forth in case number 2020-00174, the Kentucky Power rate case.
Yes, but I
Okay.
was referring more specifically to our direction in this rate case.
And also, just to follow up, also in that order, in this case, the June 30th order, that also included what components would be an avoided cost, correct?
Correct.
Okay, I just want to make sure that I'm
Yeah.
clear.
I mean, there were 7 components that the commission asked, 7 avoided cost components that the commission had directed the companies to address and to develop. The companies did.
And also, again, based upon your lay understanding, if I were to read to you in all of commission regulations, we have to list the statutory authority for why we're enacting that particular regulation. And if I would like to read to you what it says for the statutory authority for the small power production and cogeneration regulation, which is, just for the record, 807 KAR 5:054. The statutory authority is KRS 278-040, subpart 3. 18 CFR, I won't read all of those, and those are the only statutory authorities. So the net metering statutes are not referenced as part of the statutory authority for example, developing a definition of avoided costs. As a lay, strictly a lay opinion, in line of what your previous testimony was, would you agree?
As a lay opinion, as a person who's worked in regulation for years, I agree.
Thank you. We're going to move on. We're going to move on to something else. And I'm going to put a side note in here. When I was in my former career as a librarian, I used to refer people to books, whatever topic, for dummies. They were extremely well written, and they were great overall introduction. So I'm going to ask you to do the version of net metering and billing periods for dummies.
Net metering and what?
Net metering billing period for dummies.
I'm missing the last word. Net metering?
Net metering billing periods for dummies.
For dummies. Net metering billing periods for-
I'm not saying you're a dummy, I'm saying you can provide education on this.
on what a net metering period would be.
Yes,
Okay.
I believe it was in Casillas' very first data request to Kentucky Utilities and LG&E. Both you and Mr. Conroy provided response to a question with various scenarios.
Yeah.
And I will follow up with Mr. Conroy also, but I'd like to start out at a very high level, a very simplistic level, and build down. And that is simply, we're trying to understand what the company is proposing for the netting period and billing period. So is it fair to say that the netting frequency is different from a billing cycle in terms of the net metering under the requirements of Kentucky law?
Okay, I hate to do this, but I'm going to defer that to Mr. Conroy.
Okay, well, let me ask you.
Let me just say that he sponsored the tariffs. Those were tariff issues that I wasn't intimately involved in, so he would be the better authority on that.
Well, can we talk about rate design?
We can talk about rate design.
Okay. Well, let's get to the rate design piece of this.
Okay.
Well, let me ask, and I don't have this in anyone's packets. I will just say this in response to one of the questions in Casillas' first request, item 17E. There was a question about clarifying the duration that the net metering customer exports are measured. And there's a reference in here that the measurement interval is instantaneous. Can you describe, let's start with describing, what does that mean?
The measurement interval is instantaneous when the metering can supply, you have a bidirectional meter that can look at the energy that is supplied to the grid instantaneously. So at any given interval within the tolerance of the metering equipment itself, it's instantaneous. So it's governed by the mechanics of the meter, obviously, but it's that's what instantaneous would refer to.
Okay. And again, this is a very simple, high-level question, because several of these scenarios referenced production numbers behind the meter. I think it's helpful to be very clear that when a net metering customer produces and consumes its own energy in totality, let's say produces 100 megawatts, 100 kilowatts per hour, consumes that same amount. What goes through the meter?
And that if they were using, say, 100 for their own use, and they were generating 100, then nothing would go through the meter. All of it would stay with the customer. The customer would reduce its energy and realize the savings.
Okay.
It's when they supply it to the, more than they consume at any given interval, that's when they would be compensated for the energy they supply to the grid under NMS2. But to the extent that they're using it for their own facilities to run their refrigerators, their air conditioning, then they would get the full benefit at the retail rate for that and would reduce their energy consumption.
Thank you. Again, I know that was a very simplistic piece.
Yeah.
But I think that helped to clear a few things up. Is there a difference between a netting frequency and a billing cycle?
Yeah, there could be a difference between a netting frequency and a billing cycle, because netting could be instantaneous and a billing cycle is a billing cycle. It's when the meters are read for the month. So, yes.
And again, I'm not asking you for a legal opinion, nor am I asking you about the tariffs. But to the best of your understanding, are LG and EKU requesting approval of a billing cycle and not, as we say, the netting frequency and calculating the bill credits?
So that we give very careful and accurate responses, I'm going to unfortunately defer that one to Mr. Conroy.
That's totally fine, and I appreciate your doing that. I just have one more question for you, and I promise you this, really, when I say one more question, it's one more question.
Oh, okay.
In your supplemental rebuttal testimony, you said, and we can look at it if you want, but I'm going to walk you through, because my question is, it's regarding retirements of Mill Creek 1, Mill Creek 2, and Brown Unit 3.
Right.
You said first that the 2021 business plan was based on the assumption that Mill Creek 1 would retire in 2024, and Mill Creek 2 and Brown 3 in 2028.
That's correct. That's my understanding, yes.
You also, in that testimony, you said that Mill Creek 1, Mill Creek 2, and Brown 3 retirement is uncertain, and that in the absence of stricter environmental regulation, the units would not be retired until the end of their depreciable lives.
That's particular. Brown 3 is a little bit more problematic because there's some economic reasons why it might be retired.
Okay.
Okay, the
Sure.
Mill Creek 2, that's clearly the case if there are stricter regulations, then it would have to be retired in 2028. If there's not, it could be extended. Now, Brown 3 might be still retired in 2028, but Mill Creek could have a longer life depending on what happens on the regulatory front. So if Mill Creek 2 is a large unit, that would, if it's retired in 2034, for example, the company would not need additional capacity until 2034. But if it's retired in 2028, the company will need a small amount of capacity in 2028.
Again, discussing the degree of uncertainty about, presumed upon certain amount of environmental regulations.
Yes.
Was there any consideration of more regulation and stricter regulation and that impact on the retirements and capacity for LG and EKU?
No, because I think that's so unknown as to what could happen. I mean, that's always possible, but, the view here is there's a very, very real likelihood that the regulations could apply to Mill Creek too.
Mm-hmm.
But the rest are unknown. Obviously, anything could happen, but that's nothing that there's even any basis for a knowledge of what that might be.
And staff has nothing further.
Would you like to move to introduce staff 5 and 6?
Yes, thank you.
Is there any objection?
No objection.
Okay, please mark those as staff 5 and 6. Thank you. Vice Chair, do you have any questions?
I have a few. Good, I guess it's still morning.
Yeah, it is. Good morning.
Do you consider avoided cost to be analogous to marginal cost?
They're very, very different concepts. They are, what you have in economic literature is long-term and short-term avoided cost. So if you're talking about avoided energy cost, it is typically equated to marginal energy cost, which is short-term avoided cost. And what that means is the cost of the last unit dispatched on the system. And I can't remember who mentioned it, whether it was Mr. Barron or Mr. Sinclair, but there was expression used, system lambda, that refers to the last unit that is dispatched. And that is typically what is used for both avoided energy cost and marginal energy cost. Now, avoided capacity costs, they're very similar approaches. What long-term marginal cost or avoided capacity cost refers to is the change of cost due to a change in load. Now, with avoided cost, it's typically unidirectional. In other words, you reduce the amount of energy required by the utility by energy supplied by the grid or by demand management or something like that, and it results in a avoidance of future cost. And typically how that is done is that utilities, and I've seen this all over the country, is that a company will develop an expansion plan based upon their base load. And they will calculate avoided cost as a change or a perturbation, it is called, to that resource plan. In other words, take for example, the companies have a resource need in 2028. Okay, you could conceivably avoid cost beginning in 2028, assuming stricter environmental regulations. In the absence of those environmental regulations, it would be even further out. But you can, taking more power from a QF or from a net metering customer could potentially avoid those costs down the road. But they can't avoid them today because the company doesn't have any need for additional facilities. But that's a standard approach that's used to develop avoided cost, is to determine what effect it has upon the company's planned resource generation. And in the case of LG and KU, the company has identified the need of both implementing solar as well as combined cycle if Mill Creek 2 is shut down. And if it's not shut down in 2028, that would be further out. In other words, the company would rely on solar. And resource planning is a bit of a moving target because I think there's more and more reliance on the industry of solar. So I think the future resource plans of the company will probably even show greater reliance on solar than the 2018 IRP, which already included solar. So both solar was identified as a future resource that could be avoided by solar. In other words, if you bring solar on the system, you could avoid that future solar facilities that would be installed.
That's actually really helpful for me to understand what you proposed here, because I know you've got a cost assigned on page 30, and if you want to pull this up, that might make it easier of your testimony.
This is probably my supplemental
Your
testimony.
supplemental testimony,
Okay.
yes, for the NMS
That table,
2 tariff.
is it the table?
It's the table.
Oh, okay.
I love tables, so. You can let me know when you've got it
Yeah, okay, I'm there.
up there.
Okay.
Okay, so your avoided energy cost under your recommended avoided cost for both KU and LG&E is essentially that marginal cost to generate the next kilowatt hour.
Right. That's using, how that is calculated is using what's called production cost model. In other words, they have models that basically recreate how units would be dispatched. And it uses a production cost model to calculate what that avoided energy cost would be, based upon the company's own resource mix.
And then if you go down, skipping a few lines to avoided generation capacity cost, under your recommended, you've got none, and that's because LG&E and KU don't forecast a need for any more generation in the short term.
Yeah, there's two elements of that. Number one, the company doesn't currently have a need for it, and that's absolutely correct. And there's, it's probably just as likely that they won't have a need until 2034. It just depends on regulations in Jefferson County, Kentucky, and it depends on the possibility of future federal regulations. Who knows what they may be? We have no insight into that at all. But in the absence of stricter regulations, in like a 10-year planning horizon, there would be no capacity need. That's first element. The second element is the reason we probably lead to the alternative, and it's a little bit more debatable, is whether short-term net metering without a long-term commitment provides any capacity savings. There are two elements of that. One, we've talked about the intermittency of solar. If the sun doesn't shine, if there are cloud covers, if it's in the middle of the winter, solar doesn't provide capacity. Therefore, it's not a firm commitment. Okay, that's one element of it. The other one is the need. You know, there's not a current need for it, and that relates to the term of the contract. With net metering, there is no term per se, and but under the second alternative, the maximum avoided cost, we actually calculated what the avoided cost would be, assuming that the customer had made a 20-year commitment. In other words, that a rooftop solar customer would be there. There's no guarantee that they would be, but the second one assumes that they will be. And what we did there is to take a 20-year contract look and say, okay, we need capacity beginning in 2028, which may be early. It could be as late as 2034. We discounted those costs of current dollars and then levelized them like you would a home loan. So levelizing is like a capital recovery factor that goes into calculating a home loan. So we discounted them back, ignoring the years we didn't need the capacity, discounted them back, and then levelized them as you would a loan. And we did that using the company's weighted cost of capital. And it's a standard approach in the industry for calculating a avoided cost over a term. That's the type of thing that you would get into with a customer or like a PPA. What would be the reasonable price you would pay for a PPA? If you could get it, if you can get it cheaper than that, then it might make sense to levelize it. And I hope I'm not confusing you with.
No, no, and in
with
fact,
all.
that was my next question, that leads to my next question, I think. LG&E and KU don't have any forecast generation needs or excess generation needs until 2028. But if, say, a QF or net metering, whatever, if those resources came on the market and the cost of generation was less than LG&E or KU's current cost of generation, would that be, if they purchased that at a cheaper price, would that be an avoided generation cost, even if they didn't need the excess capacity?
Yeah, and the company is proposing, that's energy we're talking about. Okay, that would not be avoided capacity cost. If it came in, if they could supply it cheaper, they would still get the avoided energy cost. So the company finds it reasonable to pay a customer for what they could avoid generation. If they can come in at a lower price, certainly the company would jump all over it. I think it's unlikely, but the company would, if they could buy it less than what they could generate, they would certainly do it.
Okay, but that's on your energy cost line
Yeah.
and not your generation.
Yeah,
cost.
generation's a little more complicated because for the next 7 years, there's no need for additional capacity. The company has sufficient capacity until 2028 at the very least, and just as likely until 2034.
And is that where we get into the discussion of the sunk cost essentially that we were discussing yesterday?
The sunk cost, now, sunk cost, obviously, all the capacity, all the capital costs that the company has invested is sunk. The company can't do anything about it. It's already spent, and there are revenue requirements associated with it, but those costs are sunk. In any kind of economic analysis, you would ignore those sunk costs. Now, the discussion we had yesterday was with embedded cost. Embedded cost is a rate-making construct that calculates the revenue requirements that go into rates. In other words, revenue requirements that include the following components. It includes depreciation. It includes a return on investment. It includes income taxes that are related to that return. It includes fixed operation and maintenance expenses if we're only talking about capacity. It includes property taxes. So those are the components that go in, those are what's referred to as embedded cost. Now, two of those are related to sunk cost. In other words, once you invest in a facility, that's investment sunk, but there's a depreciation related to it that's in revenue requirement. There's a return. Three of them are involved in it. There's depreciation, there's a return, there's income taxes. Those are not avoidable. If something comes along and makes those redundant or stranded, the costs are still there. They're called stranded costs then. And so the costs are still there. They're not avoidable.
Getting back to the chart on 30, these are, I believe, your summary of going through what I will call the Kentucky Power elements. Is that right?
Yes, that's correct. These are the 7 avoided costs. One of them, we have 1, 2, 3, 4, 5, 6, 7. I think the one that I don't consider avoided cost is jobs benefit. That's not an avoided cost. That's an externality.
Okay, so that's the one I was getting ready to ask you about.
Yeah, that's an externality. The others are clearly, I think the commission identified them correctly. I think these are the components that are potentially avoidable. But energy costs, ancillary service costs, generation, transmission, distribution, environmental, all those are potentially avoidable. That doesn't mean that there is necessarily an avoided cost. but they are all avoidable. But anyway, I hope that frames it. And what we were directed to do is to identify these 7 avoided costs and jobs benefits. And that's what we, in complying with the commission's directive, consistent with the determination in the commission's order in the Kentucky Power case, these are the avoided costs that are identified.
Okay, and on the jobs benefit line, if I'm understanding your discussion earlier with Mr. Miller and your testimony here, you've assigned 0 because you think it's an externality, and
I
you
think
didn't
it's an
do a
externality.
specific analysis on it.
And the commission has a long history of saying things like, you know, we don't regulate the environment. And I could see the commission consistent with that kind of pronouncements against externalities is I could see the commission saying, we don't regulate jobs. You know, that's not our charge. Our charge is the rates and the cost of the utility, not something that's way outside basically anybody's control and is an externality.
Yeah, but just so I'm clear, you didn't do a specific jobs benefit analysis here.
No, and again, because I think it's fundamentally an externality, shouldn't be included. So, I mean, that's my view, and that's the company's position as well.
I don't have any more questions.
Okay. I know myself well enough to know that it's probably best to go ahead and take lunch now. We'll take a lunch we'll give everybody a little extra time today. We'll probably come back at, let's come back at 5 till 1. 12:55, it's currently 11:45. We'll come back at 12:55, and Mr. Seeley, you'll be up again? No. Is there anything before we go to lunch? All right, thank you. Take a recess. right, we're back on the record in case number 2020-00349, 2020-00350, LG&E KUs, net metering, SQF, LQF, and issues left over from the petition for rehearing. Is there anything that we need to take up after lunch before we get started?
No, Your Honor.
Okay. All right, Mr. Seeley, good afternoon.
Good afternoon.
I've got a couple questions for you. You're still under oath. Is there anything that you've been watching the rest of the hearing? Is that right?
Yes, I've been here.
Is there anything objectionable that you heard from Mr. Barron yesterday? You remember anything that made you jump out of your seat?
I didn't jump out of my feet, but he made in general, our views very similar. You know, our definition of avoided cost is the same, marginal cost is the same. His view about having to take into consideration the future cost, discounting it, levelizing it, I think all of that is accurate. The one thing that he did mention that I would have emphasized a little bit more is the need to calculate avoided cost and marginal cost by looking at essentially a base case plan that the company has. And what you would typically do is to adjust your supply that's placed on the grid that would create a change in your plan system. And that would take into consideration, the base case would take into consideration planned retirements of units. So the part that I felt a little uncomfortable with is the discussion about the theoretical possibility of a retirement being considered. My view, in the real world, it's already considered. Because, for example, a coal-fired unit, they will be retired in accordance with those schedules. And I just, while it's conceivable you could have some avoided costs related to retirement, in the real world, I don't think that's already taken into consideration. I don't think it reflects reality. So theoretically, perhaps, but you know, in real world circumstances, I don't think it's relevant. So that's probably the only nuance. And I don't think I disagreed with what the words he said, you know, because he was speaking very hypothetically, and I agreed. So hypothetically, you could create a scenario where there's zero cost energy coming on, but that's not reality.
Yeah, and I'd like to ask about that because you heard my questions yesterday to Mr. Wolf, I'm sure, about the AMI CPCN, and you're, through your experience, you've been around Kentucky long enough to have dealt with your fair share of CPCNs. Mm-hmm. I think the precedent is you have to show a need for something, and then you have to show an absence of wasteful duplication. And you can show a need, not need in the reliability sense, but you can show a need in your experience based off showing, hey, what we can replace this with is significantly cheaper than what we have today. Mm-hmm. Right? Has that been your experience?
That's my experience in Kentucky and other jurisdictions as well. So, yes.
Yeah, and that's what brings me to something that I think you've said in testimony. You've certainly said it today, and I'm probably paraphrasing here because I write fairly slowly. But you said something along the lines of today that the companies or any utility shouldn't be paying avoided capacity cost when the company doesn't have a need for capacity. And when you say a need for capacity, is need in that context related to reliability?
Yes, it's based on reliability. And what I mean, probably a word that I left out, need for additional capacity. You know, you have sufficient capacity to serve your need to provide reliable service, at a reasonable, lowest reasonable cost, that's exactly what we're talking about.
Yeah, and maybe even taken to the further, there's really no, and this is kind of, it reminds me of ELCC, it's not exactly right, but that although we may get more reliability from an incremental amount of capacity, we, for planning purposes, don't determine it's necessary to have the reliability we
That's
are searching
exactly
for.
right, because, I mean, obviously, if you have 100% reserve margin, that would create a more reliability, but it really doesn't provide any, there's so much redundancy built into that it doesn't really provide any additional value. So that's all in the context of a reasonable reserve margin that the company's planning for.
Okay, and so when you talk about the need for capacity or an absence of need for capacity, in that context with related to avoided costs, you're talking about we don't have a reliability need, let me say it this way, withdraw that part. Companies are planning, even if you actually aren't, but I think you are, planning for a 1 in 10 reliability scenario, is that right?
Yeah, I think that's an element that goes into calculating the reserve margin, but I think that's correct.
I think it's the upper end of the reserve margin,
Right.
right? Using the loss of load probability determination of a loss
One
of load
loss event,
expectation,
yeah.
one event, 1 day in 10 years, is that right?
Yeah, that's on the high case scenario. That's my understanding too.
Okay. And so when you say need there, I take it as being a reliability need. We don't need anything more to meet that 1 in 10. But can need be determined, and this goes to some of the questions I was asking Mr. Barron and Mr. Sinclair, can need be determined in the sake of efficiency or cost savings? So if a going forward capital cost of the cheapest, let's just say the cheapest capacity resource that the utility has, the going forward capacity, the going forward or stay open costs, the stay open costs. So going forward capacity, annual capacity, going forward annual capital costs, and the fixed O&M expense, right, is, let's make it $5 million. That's the cheapest one. Everyone is more expensive every year. The stay open costs are all in excess of $5 million, right? And they go from 5 to 10 to 15 to 20, and you have some resource out there that every year that it stays open, you're going to have to incur an additional $20 million, $10 million in ongoing recurring capital expenses, to fix this or fix that, overhaul the boilers, whatever it may be. And then $10 million in paying people to run it, or, keeping those station power lights on, whatever the fixed O&M is, right? $20 million a year. If you can find a resource out there that can replace those resources for cheaper than those stay open costs, right? Mr. Sinclair talked about this magical resource yesterday. That's something that would be prudent to look at, right? Whether or not to replace something that you currently have with something cheaper, because going forward, it's cheaper in the long run.
A couple comments on that. I think it's unrealistically idealized scenario, because I think what you actually deal with in the real planning scenarios, the company's planning scenarios, is that you have retirements, plants that's going to retire anyway, and you have units that you need for reliability, and you have replacement of those capacities with things like solar and other facilities, that those are what you would avoid. Now, can you create a scenario where that could happen? I think this is where I don't think I disagreed with anything Mr. Barron said, but I think, can you construct as some unrealistic, idealized scenario where that could happen? Yes, I think you could, but I don't think it comports with the company's real planning horizon. What you have to do, and what is standard in the industry, I would say, as well as looking at IRPs and looking at even avoided costs, in Colorado is one that comes to mind where they do this. you look at, you have a base case, you stretch out what you're going to plan, and then you look at changes to that. And it could indeed be related to retirement of a unit, but it's typically, if there's capacity need in the future, it looks at that. Now, I don't think it's realistic that any amount of solar brought on the system can displace the need of a base load coal plant that can operate 8,760 hours a year that are base loaded. You know, that, I think that's, it, could a base load capacity that brought in, if it came in for zero, result in a retirement of a unit? Yeah, but I don't think that's comports with reality and actual planning scenarios.
Yeah, and none of the questions I'm asking are specific to any types of resources. I'm not asking, can solar displace? I'm asking purely from an economic perspective about stay open costs as they relate to whether or not the stay open costs are avoidable.
Like I said, in some idealized situation, perhaps they could be, but in normal planning, I don't think it works.
So let me
that
ask
way.
this though.
Yeah.
You have every, ignore for a second simple cycle CTs, right? So you have CTs and you have combined cycles, companies have combined cycles, and then you have, I think the vast majority, the remainder of the system, other than the hydro, are coal units, right? Boiler coal units.
And they're shrinking as they are, so.
If any of those combined cycle CTs or coal units retire, will the company avoid any costs that it otherwise would have incurred if they continue to operate?
If they retire without replacement?
If they just retire?
But the thing is, typically with a retirement, you have to replace it.
That's fine.
Especially when you're looking at a combined cycle unit that can operate and they not only can, but do operate 8,760 hours a year, you've got to replace that. And, you know, so, you know, the reality is you'd have to replace it with something else. Therefore, those quote costs that you're thinking will be avoided, they'll be replaced with something else.
Mr. Seeley, you're going way beyond the questions that I'm asking.
Okay.
You're assuming I'm asking about something else that I'm not.
Oh, okay.
I'm asking, solely looking at that single unit, when it retires, are there costs that you are not going to incur when it retires, specific to that unit, that you would have incurred had that unit stayed open?
Everything else being equal.
Okay.
The caterers paribus we talked about yesterday. There would be cost if you shut down and didn't replace it. Just shut it down. Didn't replace that capacity. There would be costs that would continue and there would be costs that disappear.
Okay. And then the calculus that the company is running, probably every year, maybe even multiple times a year, is comparing, and this is, I think, bears itself out in Mr. Bellar's study that he did in his case, determining the new retirement dates for certain generators. That cost that you just said might or would disappear upon retirement of that is then compared, that's one scenario, is then compared to other scenarios. For instance, is it cheaper to replace that retired generator? If we retire this generator, are there other supplies or are there other units or other resources that could replace it that would ultimately lead to a lower rate or a lower cost? That's the calculation you were discussing earlier, right? Okay, so I'm focusing first on the first part of that equation, not comparing it to the replacement resources, right? So what is the number that you're looking at, primarily with capacity, if you're only focusing on capacity? Let me ask you this way. Is the number you're looking at the fixed cost or the cost that you would continue to incur absent the retirement?
In that unrealistic scenario, and I'm going to pick back up on that, but let's assume that unrealistic scenario that you could replace it. And let me preface it to say that if that scenario was cost-effective, it would already be built into the base case. So, all that said, the costs that would go with that plant that, I don't want to call them avoided because that suggests that they're avoided costs, but the costs that would, quote, disappear with that would be the fixed O&M expenses.
Okay. And then would,
The rest of them are fixed, they are not avoidable, they're straight cost recovery, they'd be recovered through depreciation rates, therefore they're not avoided. Only under that, and I will say, unrealistic scenario, only the fixed O&M expenses would go away.
okay, so let me ask this, and I apologize, I don't have the entire model that is used to make the retirement decision for me. I don't think that would be, we wouldn't get very far in that conversation. So we have to make oversimplifying assumptions in order to ask questions. My experience, I've been doing this near as long as you have, Mr. Seeley. My experience with retiring generators, in my short time doing this, either they're things that are being looked at being retired or, were retired right before I started doing this. Many of them were retired because the cost of environmental compliance was higher than the replacement cost of capacity. Has that been your experience the last few years as well?
Yeah, that's a major factor, yes.
We haven't had too many generators retire because of age, or they've met their end of their useful life recently. But that is certainly a reason that generators have retired over the decades, right?
I mean, there's another reason, and I think Mr. Sinclair spoke to it, like Brown 3, it's an economic issue. And which involves both the cost of continuing to run the unit, whether environmental or otherwise, and the general efficiency of the unit and the availability of the unit, and all of that would go into play.
So can I ask about the economics of that? And that's exactly what I want to ask about. And if you take offense to my other oversimplifying questions, then maybe just talking about this real scenario would be helpful. Am I wrong in thinking of the economics of that situation in two parts? One is that the variable cost of producing electricity might be simply higher than the rest of the fleet, right? The remainder of the fleet can produce electricity at a cheaper cost, the variable cost of production of electricity. And then the fact that, boy, it would take a lot of money to overhaul the boilers, all these different things, right? Yep. To continue to invest in it is unduly costly compared to replacement capacity. Is that a fair characterization of a simple look at that kind of economic decision?
Yeah, and again, that's what the company looks at, and they build that into their base case, but yes.
And I appreciate that that's what the company's base case is, but they have to create the base case, right? The base case isn't just the base case because it's the base case. The base case has a built-in economics, and that is, the economics of the base case is then compared to alternatives. Is that correct?
I mean, the comparison of the alternatives in general, they look at optimizing.
Okay.
The optimizing the revenue, the long-run revenue requirement, if you will, is how it's typically done. And my understanding, the way it's done at LG&E as well.
Okay.
So,
and you create a base case, then you look at it on a recurring basis. It could be quarterly, it could be every 6 months, it could be every year, it could be every 5 years. But you have a base case, and then you continue to review it to determine whether there are other scenarios that maximize value or reduce costs over time, right?
In general, that's the approach. It's
Okay.
more of they screen them, and then they do a finer tune look to determine which one is the best in terms of minimizing revenue requirements. And they do it on a high case and a low case, middle base case, et cetera.
Okay. And then, hypothetically, and I assume it's less hypothetically, the Brown unit we were discussing earlier, right? The companies probably could have spent a ton of money updating it or replacing everything, basically making a brand new plant. To do so was prohibitively expensive compared to alternatives. Is that
That's
your
what it looks
understanding?
like. I mean, that
Yeah.
could change, but.
That's the economics, and maybe it's not specific to that unit, but that's kind of the old, this plant's 65, 70 years old, this is the economic scenario. Why, even in a time when the company has adequate, I think adequate capacity, or that's the flip side basically, it doesn't need capacity for liability purposes, why isn't the avoided capacity, generation capacity value, that continuing annual fixed O&M and stay open capital cost, the avoided generation capacity cost?
Because in the planning horizon, they're not avoided. Okay, if you look at, okay, you develop a planning horizon, and again, this is a standard way it's done in the United States. You develop a planning horizon, you develop a plan for it, and then you look at what will change in that plan in the future. And a change, unless it's massive, if somebody came in with 1,000 megawatts at zero cost, it will not result in avoiding fixed cost units that provide 8760. I mean, just the incremental impact on the plan just will not result in typically shutting down a plant and avoiding, those costs are still there. It's not reality, is my point.
Well, what if you retire a unit? Why then will you continue every year to incur costs to keep the doors open?
Oh, you wouldn't. when you
Okay, so you're
retire.
avoiding that cost, right? And if you retire a unit and you don't have to continue to pay those people to work at that station, that's a cost you also no longer incur,
Yeah, I
correct?
mean, but here's the thing, is in the planning horizon, you go down, okay, they built in the fact, Will built in the fact that, say, Brown 3 has retired. Okay, it's built in, it's there, it's retired. Okay, what will it avoid? It will avoid, at that point, additional capacity cost. It won't avoid in reality. And that's why I was saying what you're describing is hypothetical, idealized, not reality. Because what you will avoid, for example, it doesn't matter what kind of capacity we're dealing with, but let's say that they brought in something that could have, that can operate 8,760 hours a year. It will avoid, in that situation, a combined cycle unit. Okay, it will avoid a facility that would be in the planning horizon. It wouldn't avoid a cost. It wouldn't shut down another plant. It would avoid what's being installed. Therefore, the proper starting point is the plan, what is developed. And then what you will see is avoided cost down the road. Because, what would it take to shut down a plant today? It would take an enormous amount today. And that's, again, hypothetical, idealized, unrealistic. That's why, as a general proposition, that should not be called an avoided cost unless it's avoided in accordance.
This is great. So the company, as you understand it, is proposing that once 1,000 megawatts of QF is satisfied, the avoided generation capacity value of the QF rate should go to zero. Is that your understanding?
The avoided cost would be zero until you need to avoid capacity.
Well, for reliability purposes.
Yes.
Okay, my question is, assuming the scenario in which 100, the 1,000 megawatts is satisfied, right? The company is proposing to put the avoided generation capacity value back to zero. when you're looking at the base case scenario as to whether or not you should retire something that's not planned to be retired
Yeah.
versus a replacement generation scenario, are you comparing, as an economist, the replacement generation against the $0 or the replacement generation against the cost that you are going to avoid, the going forward stay open costs, if you retire that generator?
There's a lot of assumptions in there. I think I got lost in them. But you're saying, what I'm saying?
Yeah, I'm saying in an idealized version, I'll re-ask the question.
Oh, okay.
In an idealized version, and it's not that idealized, we go all the way back to 2017, 2018. The companies have no significant expected retirements, right? Nothing in the 15-year plan,
Right.
except for, I think, Zorn CTs, and they're,
Yeah.
you know, you could ride a bicycle.
Yeah, I mean,
They're small,
Yeah.
not compared to the
I
size
mean,
of
they
the
serve
companies.
a purpose. but-
I'm just a little tongue in cheek. So they're small, right? They're not a significant generator. No planning, no capacity additions, no capacity retirements over a 15-year planning horizon, and the reserve margin being within the planning reserve margin range, right? So it's not really an idealized version. It's kind of what we just experienced, okay? Each year, let's say the company looks at its plan and says, is it, you know, this is our base plan, this is what we have, we expect no retirements, no additions in the next 15 years. If there is replacement generation out there, forget what the cost is,
Yeah.
higher or lower or whatever, it just has a cost. And you compare that then to the company's current generating fleet. There's no need for capacity for liability purposes. What cost, we have the cost, the replacement capacity cost. What cost does the company, or should any utility in this scenario, compare that cost of replacement capacity to determine whether or not it's more effective or efficient to retire something they have and then go with this replacement
Zero
capacity?
cost, or without ignoring the cost, what should you look at? And again, I disagree that it's a realistic scenario, but it would have to first be able to take out a unit and retire it. Okay, therefore.
That's
is
a
that
fair,
an assumption?
simplifying assumption, that's fine.
Okay, therefore, it would have to have the operation characteristics would have to be very fine-tuned to take out a unit. And again, I think that's unrealistic, hypothetical, but assuming it all, it would be the fixed O&M expenses only.
Okay, so that's the fixed O&M expenses, not the annual, is it the stay open costs? Can we agree it's stay open costs? The annual capital cost, the keeping the doors open capital cost, and the fixed O&M?
Just the fixed O&M was all it would be, because the variable would be reflected in the avoided energy cost regardless. It would just be fixed O&M expenses is all.
So if a generator has $7 to $10 million in capital expenses every year, you know, to fix this and fix that, you're saying that's reflected in the fixed, or in the variable fuel cost?
No, I'm saying that's what would be considered, because the
Okay.
variables, the fuel cost is a different matter, because
Okay.
it's avoided energy costs, it's all captured anyway.
So the recurring annual fixed expenses would be avoided?
Under that unrealistic situation. I won't agree that it's a realistic hypothetical.
And that's fine.
Yeah.
That's fine, because I'm trying to ask a hypothetical to get to the economics and get to what calculation for utility planning is actually run.
Yeah.
I'm not asking, is there a magical unit? I'm not asking anything else. I'm asking, what economic calculations is the company running to determine whether any of these situations actually occur?
Yeah, and if they already do that, and that's my point in the base case.
Okay.
Because they look at it, is it a viable operation to continue? And for economic reasons, for example, Brown 3 would might not be economic, therefore it's a candidate to be retired. So it's already done.
Okay, so this brings me way forward to the second question I have. At this rate, I hope I packed a pillow with me, Mr. Seeley. We're going to be here a while. You talk about Mr. Barron discussed yesterday that embedded costs are more of an accounting principle, and avoided and marginal costs are both sort of more economic principles. Do you agree with that?
I agree with that.
Okay. And you state in your testimony that there's no relationship between avoided costs and embedded costs.
That's correct.
And I think, is the basis for that difference between one is looking at it from an economics perspective and the other is just merely an accounting of costs that have been expended?
Yeah, that's the primary difference. I mean, I think there's an issue, there's a big overlap, they're not synonymous, but sunk cost and embedded cost there's a big overlap between those two.
Right.
Because a big component of embedded cost are sunk, probably the majority are sunk. So, but embedded, there's just no nexus between the two. Between avoided costs, they're completely different concepts. Avoided costs are future costs that you can avoid. Embedded costs are, and I agree with the words Mr. Barron used, they are accounting costs that are used to establish the revenue requirement in a setting of embedded cost rates.
And embedded costs can include costs that might have been avoidable, but they were incurred, and that's all that matters. That's what makes them embedded, that they were incurred, right?
That they were in their historical, typically, I mean, they could be quasi-embedded costs by a future test year, and he got into all that, Mr. Barron did. But yeah, I didn't take any issue with any of his discussion there.
Okay, so the other front here that I'm curious about is you talk about, so there's no relationship, no correlation, I get what you're trying to say there. There's a difference, a significant difference.
There are
between
apples and oranges.
Apples and oranges. Apples and oranges, but the apples being embedded costs, some of the apples could have used to been oranges, they didn't get avoided, they became embedded. Is
That's
that fair?
very imaginative.
That's
apples turning into oranges.
But that's kind of the idea, right? They are costs, whether they're avoidable or not, they were incurred, and that's what makes them embedded.
They were incurred.
Yeah, and they're in the rear view mirror now, necessarily, not looking forward. So with marginal costs, you put a definition around marginal. It's not so much a definition as it is an explanation. Or Mr. Barron did yesterday, where he talks about it's a change in, actually it may have been you this morning, I apologize.
Yeah, we both did, I think. It's
A change in cost based on a change in demand. And that's kind of a very baseline, simple, at least in regards to utility, that's a very baseline definition of a marginal cost, right?
I mean, that's a mathematical definition of avoided cost. It's the first partial derivative of your cost curve in terms, that's in economics or mathematical economics, that's how marginal costs are defined.
Okay,
And-
so I just want to ask about it. So we could have the oversimplifying way to look at it, sort of the definition way, is that you have a linear or curvilinear chart, right? And you move along one axis being a change in demand, and you assume at that point you move along the line or the curvilinear or the tangent. Is that right? You move along the.
Yeah, the tangent is the line that, if you have a curve that is tangent to that
It's
line.
right,
And
yeah.
the
So-
first partial derivative is the tangent, that is what the marginal cost is.
So you're moving along it though. With one change, you actually can move along with one change in one variable that you move along the line. That's that's how some marginal costs may look, right? But when we start talking about things like avoided capacity costs, I was
Right.
asking this yesterday, where you may not change, there may be no change in cost based off of a single change in each unit of demand, but it may end up being a stepwise change, right? You may be able to move, I'm just going to make a certain number of units in demand before you actually do have a change in cost. Is that your understanding? Is that an economic reality or an economic possibility that you have costs and marginal costs that act like that?
Yeah, and in economic literature, they typically talk about long-run marginal cost. And when you get into capacity, they call it long-run marginal cost. And Mr. Barron addressed it. He called it lumpier or less continuous, and all of that is accurate. There's temporal elements to it. What I mean by that is you can go several years and not have any, like the situation here is that if you have sufficient capacity, then you don't have any avoided cost until down the road. Therefore, that's what I would call temporal lumpiness. But you also have lumpiness in terms of the fact that generating units are discrete quantities. Therefore, for example, to avoid a generator, if you have a 495 megawatt generator, you would have to have 495 megawatts to displace it or to displace it in the future. But in the future, you can typically look at smaller increments like 75, but nevertheless, both in quantity and time, there's a lumpiness to avoided, as there is in marginal cost.
And I want to ask about the not the temporal issue, but the units, right, in quantity. The change in demand, you may move and have a certain unit number of change, a significant change in demand before you start having that change in cost, right? And my question really is around this chicken and egg issue as I see it. In that when you're talking about not just avoided costs and the calculation of avoided costs, for economic and mathematical compliance, right? That you're not just talking about the math, but you're talking about the reality of how it occurs. Is maybe a chicken and egg price issue, right? And you say, well, we know that our next unit, our next most expensive unit, the one most likely to, the one we're comparing the cost of against replacement capacity, is 495 megawatts, right? So we would need something, to your point earlier, that looks like that, or that can give us, we need 495 megawatts is what we've determined for reliability. And a QF, and I'm just making this up for a perfect example, QF, 80 megawatts, right? So a single QF, even if it's willing to come in at a very, very cheap price, significantly less than the stay open cost, it's only going to give you 80 megawatts, right? And so that may move you along in a change in demand, but it doesn't actually give you that additional benefit that you need to retire that generator, right? You would need, shouldn't do this to myself, 7 of these 80 megawatt units, right? You would need 7 of these 80 megawatt units in order to displace, assuming they're all cheaper, assuming to displace that 495 megawatt generator. So should you continue to assign no benefit or no avoided capacity cost to these smaller increments of replacements?
No, you shouldn't.
Okay.
No, you shouldn't, nor has the company. In calculating its avoided cost, we didn't ignore, it could apply to a 10 megawatt load, and we agree with it. Our concern, two concerns, are the company's concern, my concern as well, is that, number one, you don't pay more than what you can secure it in the marketplace. If it can avoid some future generation that you shouldn't be paying more for that than you will likely have to pay when you need it. Okay, for example, purchasing from a qualifying facility, for example, solar capacity, you shouldn't pay more for solar capacity than the company will likely pay when it needs solar capacity in 2028. So in 2028, it's extremely likely that solar will be needed and installed, and therefore that's the cost, that's the market value, that's a prevailing value. That's what should be used, discounted for to reflect the time period that you need it. It's got to be discounted. And the company has not limited and said, oh, it's got to be, these solar panels, they're a lot more discreet than, say, a combined cycle unit, because there's efficiencies when you get to like a large frame, or a combined cycle unit of 500 megawatts or more. There's a big efficiency gain by having larger units. With solar panels, that's a lot more discreet. It's not, you don't need 500 megawatts of it to be effective. But but regardless, the company is not putting a cap that it has to be so large. It would apply to any megawatt, any size of qualifying facility up to the caps that are set forth in the tariffs. But our main point is you've got to take into consideration you don't need it right now. The company has sufficient capacity. Any purchase of additional capacity that reflects value in those interim years would add to the company's cost and would not adhere to the least cost principle that the company should follow.
So a couple of things on that, Mr. Seeley. If bringing forward a retirement is can bringing forward a retirement result in more savings?
Could it result in, it would have to be something that would have to be large enough. Then you're getting into discrete elements there, because these are big, large units you're talking about retiring.
I'm just asking about the economics.
Yeah.
Right, just the economics. Can it bring forward a retirement by saying that the replacement capacity in 2023 that you can be provided is cheaper than continuing to run it for these next 3, 4, 5, 8 years? That it would be cheaper to go ahead and bring forward the retirement because the replacement generation is that much cheaper. Because, and what I say is, even if you discounted what the company is proposing, discount the replacement capacity cost, if there's a replacement generator that is cheaper than the discounted present value rate of that avoided generation capacity cost, the economics then would lend itself to bringing forward that retirement. Is that fair?
In your hypothetical situation, if you say you're looking at a unit that runs 700 hours a year, okay, if you could find a unit that could displace 700 hours of the year, could you bring it forward? It would have, that's why the characteristics of what you're assuming to be brought onto the system as a resource, as a replacement resource for that, would have to match that replacement resource.
That's a fine simplifying assumption to make. I'm asking, is that, on the flip side, other than protecting customers, is that the calculus then that's used against, or the reason for, the flip side, the reliability purpose of discounting to the present value those avoided generation capacity costs in the years, the base case, in the company's current base case, the planned retirement years?
The plan, yeah, I think that's driving it, certainly. The reason that you discount during that period is because there's no need during that period. Therefore, you have to, that's the year that it would be affected, is 7 years down the road.
There's no reliability need for another 7 years.
Yeah, there's no reliability need for 7 years.
But boy, if you can give us a replacement generator for almost nothing, we'll take that today. That's like the bluegrass unit
If you
that Mr.
had
Sinclair was discussing,
again,
right?
those are base load coal units that run 8,760 hours a year. If you could bring in a unit for free or less, 8,760 hours a year, like I said, that's so idealized and hypothetical, it's unrealistic, but I'll accept it if you,
But the math is, or what I'm asking is, the math that the company will be doing is it cheaper? Is it cheaper? That's the goal of the math. And the one part of the calculation related to the current generation, as the company proposes, I understand it, the present value, the discounted present value of the avoided generation capacity cost in the outer years, in the as reflected in the company's base case.
as reflected in the company's plan and effectively based case, I would
Okay.
call it now.
Okay.
And the reason I'm hesitating on the base case, if you look at the IRP, things have changed since the last IRP. And the last IRP didn't have a need for, 15 years or more.
For the planning
So
horizon,
if
right?
you went to the current IRP, within a 10-year horizon, there would be no avoided cost, if that's your criteria. Because if you remember in the last hearing, Mr. Chairman, you went through the order that the commission issued in the purple proceedings in the early 90s, and they said that, that's sort of the criteria is the 10-year window. And under the current IRP, there wouldn't be any need, okay? Stuff's changed since then. In our view now is that it'll, it could likely be as early as 2028. It could be 2034 when there's a new capacity need. So it's a little bit of a moving target.
So earlier you said avoided cost. I think you just said avoided cost is avoided cost. That was sort of your perspective. It is.
Avoided cost has a pretty solid definition consistent with the commission's regulations.
And you've done a couple of cases I'm aware of at the commission, probably more than a couple, just a couple that I participated in around demand side management programs, right?
Yeah, yes, I have.
And so
It's been a while for LG&E, but yes.
I think the last one I remember was Columbia, the last
Yeah,
one I
Columbia.
remember participating in. And so, but in your experience with demand side management programs, avoided energy and avoided generation capacity for electric utilities is a significant input into the determination of the effectiveness of programs, right?
Of the effectiveness, yeah, it basically gets to what's called the RIM test, so yes.
Okay. And, if the avoided cost from the company's perspective or from your perspective is the same, whether we're talking about an SP, a small QF, a large QF, 640 megawatt combined cycle plant, if it's the same avoided energy cost, if the companies have a avoided energy cost and an avoided generation capacity cost, is it your experience that if the companies are using it for things like QF, those two determinations, they're going to use it for things like whether demand response programs or energy efficiency programs or weatherization programs are cost effective?
Prospectively, yes, and prospectively, that's exactly what the commission ordered in the last rate case. Not last rate case, last DSM case. The company, for that very reason, decided to basically halt new customers under demand side management. Now, they continued on with existing ones, basically a legacy issue, and I think that's analogous to the net metering one. They're grandfathered in because you sort of offer this to a customer, you continued on, but the reason that the companies terminated their demand side management programs direct flow control in particular that had the significant avoided capacity component was the cost of the IRP and the lack of need for capacity. So that's what the company did, and it is, the mechanism is similar, and the test that you would do on DSM is essentially a RIM test, which seemed to be the one often favored by the commission in particular over the years, went back and forth, was the avoided cost test. They're the same.
And for maybe something similar to the reason Congress set out PURPA the way it did,
Yeah.
is that, as Mr. Barron said yesterday, an avoided utility cost is a system benefit.
Right.
Right.
I mean, PURPA, I think the logic was very sound. The economist behind a lot of PURPA was, you know, like a Nobel Prize winner too.
So I want to go back to something you said earlier, and I just want to make sure I understand it. The company's position is to discount in the case of having avoided generation capacity cost in outer years, discount it to a present value for purposes of determining a capacity value today, right? A payment for avoided capacity costs. Is that right?
Yes.
But the company is not proposing to discount increments short of being able to actually avoid those large chunks of capacity, like we talked about earlier.
We're assuming that they're not necessarily large chunks, and that was probably a point that I didn't make, is because solar panels that are built into that avoided cost need, because they will be there, are not necessarily huge chunks. They're probably bigger than a rooftop solar, obviously, but they're not like necessarily, they can be smaller increments. You know, the size of a solar farm is a lot more variable than, say, an efficient combined cycle, which is generally, to get an efficiency, has to be quite large. Solar
Yeah, and
farms can be much
I
larger.
apologize if I spoke specifically to solar, but I didn't intend to.
Yeah.
Okay. Very specific to just avoided generation capacity costs being discounted.
Yeah.
Because you know, I think Mr. Kurtz thankfully went through the list of, I think he used the term dozen or so different types of resources that can provide can provide capacity, right? You know, there was wind, there was solar, there were, you know, CHP, there was hydro, there were a lot of different options, right? And then on the flip side, when we're just talking about the company's use of avoided generation capacity costs, it's an input into all those demand response programs as well, right?
Yes.
Okay. But just to be clear, the companies in any of their proposals that you're aware of in this case have been discounting the avoided generation capacity values, right, based off of the inability of a particular generator, no matter how big it is, to offset a full chunk of demand or a full chunk of capacity.
With respect to what we've done in the past on demand side management, is that what you're referring to? Or
Across the board with avoided generation capacity
I
value.
mean, not even in the proposal here have we required the same size chunk, if that's what you're referring to.
Well, and the reason I ask is we've been talking about avoided generation capacity value this entire time. But avoided generation capacity value isn't the only thing that may look, the marginal cost chart that may look like it's in a stepwise manner, right? That would probably be the case for most of the other avoided capacity values. Would you agree?
Just walking through them, energy is the one that is essentially continuous. You know,
That's fair.
it's a curve, but it's continuous. Now, ancillary services, for example, they're all built in and associated and related to the generation capacity to start with. Therefore, they're related to generation capacity. Theoretically, if you really could look at it, avoiding cost on there, they're built into the generation capacity cost, therefore they're equally chunky. Now, transmission and distribution is a lot more complicated.
Would you agree that transmission to distribution is what I'd like to talk about? That they're chunky, but they're just very different? That there may be significant?
They're probably less chunky, but very, very different.
Okay. And just the fact that they are presented a marginal, charting out their marginal cost, right? Maybe still in a stepwise manner. That doesn't necessarily discount the contribution they're able to provide, does it?
What is providing?
Well, so avoiding upgrades, right? Avoiding the change in size of replacement. So the companies, this is a great conversation with Mr. Seeley. So you've done a number of cost of service studies for the companies, right?
Yeah, I've probably done most of them.
So I think I remember there's been a couple sets of testimony where you talked about the minimum size study.
Minimum intercept, is that what we're talking
Well,
about?
there's a zero intercept. There's two ways to do the allocation of certain distribution plant, right? You can either use the minimum size, I think it's for the customer portion
Right.
of distribution plant. You can either do a minimum size or zero intercept.
Right.
And the minimum size is way simpler than the zero intercept, as I understand it.
Well, one of them's statistical, the other one statistical in nature, the other one's an engineering study. It's always been my preference that the zero intercept should be used. The commission has agreed with me on that, and, or not necessarily, I agree with the commission maybe. But in any event, the commission has a long-standing practice of adopting the zero intercept methodology. I think it's a more sound methodology than the minimum system approach.
And the minimum system basically says, and I'm way oversimplifying, the neighborhood manual says what it says, but the minimum system study specifically basically says, look, this is the smallest transformer we use, right? This is the cost of that transformer. This is the smallest distribution conductoring we use, right? That's it. This is the smallest or whatever, the shortest pole we use. Not that there isn't smaller transformers out there available that a company can buy, or not that there are smaller poles or smaller conductoring they could buy. But for sake of efficiency, the company says, we're just going to go ahead and stick with this conductoring, right? We can get a deal if we buy this size pole, even if we could get away on occasion of buying a smaller pole. And the same thing with transformers. Is that your understanding?
Yes.
Okay. Not that a smaller transformer might not work on any of their particular systems or any of their particular circuits. It's just we carry a certain size for a number of reasons.
Yeah, I mean, typically, we're to fine tune that. Take a customer that is very rare nowadays, but you have a couple customers that don't have air conditioning. You could go with a smaller transformer. It may not be cost effective to go with that smaller transformer because it may not be any less expensive because it would be a specialized transformer.
Right.
In other words, there's more standard transformers. Yeah, but I agree with your general proposition.
So then you also run into the situation, by that example, we know there are different size transformers, right? Distribution, transmission, but also different sizes even for the distribution system. You can have a circuit that has a certain size transformer on it because that's the size that circuit needed, right? The company has smaller ones, but they've determined for engineering purposes.
Yeah, they could go with smaller ones, but it may add to the cost.
It might, but I'm just saying, say they have two in stock, a bigger one and a smaller one.
Yeah.
They go with the bigger one because they think that's what's needed. Then over time, that circuit, maybe there's, for a number of reasons, maybe there's a tornado that regretfully takes out some of the houses, they're rebuilt, they're much more energy efficient. They may have had people leave and the houses be torn down, but that circuit loses over time, 10, 20, 30 years, a significant amount of that load, right? And then engineering comes back and says, well, this transformer is at the end of its life, we need to go ahead and retire it, we're going to replace it. but they replace it with the smaller transformer the next time because the larger one isn't needed, right? And the smaller one's cheaper.
It may not be, it may be more expensive.
It may not,
Yeah.
but the replacement is cheaper. That's a system benefit by
That's an
not
assumption,
having
right.
to go with the more expensive one, right?
If that's the case, but what I'm saying is it may not even be the case. So,
I appreciate that. What I'm asking from this scenario, and I'm truly trying to understand as it relates to the distribution system and distribution planning and the economics of it. How does a utility look at that calculation and make determinations as to whether it may or may not be cost effective like a DSM program to say, hey, actually if we gave $5,000 to this house to get a new air conditioner or to weatherize their home, in a couple of years when we replace that transformer, we're going to save customers $100,000, right? How does a utility calculate that? Like what internally, for planning purposes and the economics of it, what is the calculus for making that determination as to whether it's as to what the most efficient, lowest reasonable cost plan moving forward would be in those types of scenarios?
Yeah, let's talk through the scenario a little bit. You have what a utility in terms of sizing transformers. There may be a single transformer for a customer, or there could be a transformer for two customers. But what they will size the transformer around is their maximum demand, the customer's maximum demand. And they would look at the needs in general of the expected maximum demands of those customers, okay? Not to anticipate your question, but let's say that they had some behind-the-meter generation. I think that's where you're going with it. And they would still have an air conditioner that they're operating that they have to size that transformer to meet. Okay, they have to take, for example, you had indicated that you have electric space heating at your house in the last case, Mr. Chandler. You would have to size, space heating is a good example because it requires often about 20 kW as far as an air conditioner will take about 3. So space heating is a lot more significant. They will still have to size the transformer for the 20 kW for the space heating customers on KU. And KU has a significant number of space heating customers. And so the calculus that would go into it is they would look at the maximum demand that's needed to serve that customer. And if a customer conserves, let's put it that, say that a new technology comes in and you no longer use, which is unlikely, but no longer use 20 kW, you use 15 kW, you could go with a smaller transformer in that situation. But space heating is like 20, air conditioning is like 3 or 4 kW. And like generation resources won't alleviate, solar in particular won't alleviate that transformer for you. If you put solar in, you'll still have to have space heating. You may be able to avoid some energy cost in the summer, but you still have space heating requirements that solar will not put a dent in. So it's very customer specific. And if you have a summer customer, you may be able to shave a little bit, but probably not even then, because you get the situation like in California where their peak demands occur like at 9 o'clock at night. Okay, they spring back. You still have to put in the same basic capacity to serve that peak in the afternoon. So, if you conserve around the clock and don't spike back up on the system late in the afternoon like you do in the summer, if you could conserve across the clock all the time, like for example, if you put in a battery along with solar, and you could flatten it out and use it all the time to reduce your demand, then then the utility could avoid the transformer.
Yeah, and I wasn't anticipating this. This is not where I was going to go, but I think that you've given enough of a scenario that I can get back on where I'm going. If you have found that an alternative, right? To your point earlier, I'm just asking about internally as the company does its calculations. Forget a customer owning that DER. Let's say the company has in the back of a truck solar panels and a battery, right? And they're looking at a place to maybe do this on their own distributed energy resource, right? I'm asking about the economics of the situation.
Yeah.
What
Yeah,
are
I
you
mean-
comparing the cost to versus what's the costs that you are saving? Right? That's where I'm trying to ask for
Yeah, I
avoided
mean-
distribution capacity costs.
Yeah, if you,
Let me just finish, sorry. You
Yeah,
would
I'm sorry.
assume
Yeah.
that the company, there may be some circuit, and I know Mr. Wolf talked about this the other day, for the calculation of avoided capacity cost, right? That there may be some circuit out there where this investment is less than the cost we'd otherwise incur, right? And as I understand it, the cost you would otherwise incur that you wouldn't incur if you made this investment is, in this type of scenario, DER, battery, is almost by definition an avoided avoided distribution capacity cost. And my question is, how are the companies calculating that value, that base case to compare to, for their own internal planning today?
yeah, I can address it up to a point.
Okay.
Okay, because of my extensive conversations with the distribution folks. But they do analyze their planning by circuit basis. And they look at the capacity needs on circuits. For distribution, transmission is a little different because they rely more on short circuit analysis on transmission, but what they look at is capacity sizing more so on the distribution level. And so they do look at the maximum demands that are coming across various components of their circuits. And there was a data request that delved into this in the 8th round. I think it may be 12 or 14. Maybe Duncan can help with this. But there was an analysis, I may have written it down, I don't know. There was analysis that the distribution group did where they analyzed the loads on each circuit. And they actually looked in the context of net metering to see what if on that circuit they took net metering up to the 15% cap that's set forth in the tariff and the 1% cap overall. Would it have any impact on the circuits? And the answer was none. It did not result in any avoided cost on any circuit that they looked at. And they looked at both on KU and LG&E on all the circuits. And a lot of the circuits, there was no opportunity at all to even impact it whatsoever. But on some, it had a minor impact, but it didn't result in any of the costs. So the way they do it, to answer your question, is they do it by circuit analysis.
So two things. The first is, isn't what you just said analogous to your conclusion earlier about avoided generation capacity? Is that just because each megawatt of a QF or a net metering customer, or a group of net metering customers, can't in and of itself avoid a 495 megawatt generator, it doesn't mean it doesn't deserve or isn't providing that avoided capacity value to the companies. But that calculation and that study you're saying is because in that instance they didn't actually avoid any costs in that singular incident, that they're not providing avoided distribution capacity value. How are those two things not the same?
It's not avoided cost. I mean, what our direction was in this proceeding was to calculate avoided cost. We didn't, wasn't directed to calculate some kind of hypothetical value. I mean, from my perspective, unless there is avoided cost, there is no value. But that was our direction, to look at avoided costs. So from a avoided cost perspective, and if it doesn't avoid some cost, there is no avoided cost.
So hold on a second. QFs are maximum 80 megawatts. They're paid an avoided energy and an avoided capacity cost.
Right.
Under the scenario you just laid out, unless they actually avoid the next generator, you're saying they shouldn't be paid avoided capacity value.
That's not exactly what I was saying.
Okay.
The analogies breaks down when you go from generation to distribution. Distribution is 80 megawatts doesn't even make sense on a distribution system. We're talking about, hundreds of KW or,
Yeah.
more than that in many cases, but we're talking about KWs versus megawatts.
Okay.
And there's hundreds and hundreds of circuits that they look at on the distribution side.
But if avoided cost is avoided cost.
Yeah, but
And we're
once
talking
you
about
have that facility in, and make another point.
Go ahead.
That you gotta keep in mind. On KU in particular, KU is not a growing system, okay? There are certain areas that it grows, that is growing, but if you look at the forecasted demand for KU, both in the winter and the summer, the demands are shrinking. So what that means is that the distribution capacity that you have out there is adequate. And if you shrink the demand that's being placed on those circuits, the circuits are still adequate. Therefore, you're not having to increase the capacity on the circuits now. What happens when you're throwing more power to the grid, it just shrinks the demand on that, and you have more capacity availability. On KU, that is, because they're shrinking, it frees up capacity. Therefore, it's unlikely throughout the system for there to be very many opportunities for any avoided costs. The only exception to that are things, maybe in the Georgetown area of the KU system, or one I'm more familiar with because I'm native of Louisville, is the Norton's Commons area out there that's growing. That's a growing area. There could be some opportunities there, but even on those circuits, it didn't put a dent on them.
So aggregate demand reduces over time. The companies retire a unit because it's old, it's expensive to keep up, and actually retiring it doesn't necessitate a replacement, right? Retiring it still keeps them in the reserve margin target. I think that may even be the case in 2028.
40, 50, 60 years down the road, because
Yeah. No,
what
I'm
you're
just saying
talking about with conductor, they're 60-year life equipment. So they're even longer than a power plant.
And that's what I was trying to ask, is that chunkiness. It's different, but it doesn't mean it doesn't exist, right? All customers would benefit if after a certain number of years of reduction, a power plant is retired without having to incur the system cost of replacing it, without any reduction in reliability. Would you agree? It's an avoidance of a cost.
Way down the road. I think I agree with that, as long as you're looking down the road. And I was still focused on like conductor that will last for 60, 70 years. And, when you get around to replacing that, 60 years hence, the discounted value of that is so small that, it'd be negligible.
So, and I guess, Mr. Seeley, I don't know whether to be more interested or concerned, right? Because if we're just saying that, oh, we're just engineering to whatever people use, whatever they use, that's what we're gonna build the system to, and not take into account, gosh, if we could pay people $1 to not use power in the peak periods, we'd save the whole system, every customer $2, right? But my understanding is the companies have always tried to do
And
the latter.
They do,
Right?
yeah.
Okay, and so I'm asking, from a distribution perspective, that $2 value, how is it being determined today?
They plan the system to deliver the power to the customers, okay? How that's being determined is based upon the most cost-effective way to do that. Now, would they take in consideration installing and managing solar in such a way that they could reduce that? Most utilities are just beginning to give that some consideration. But I think the company will definitely take that in consideration. You know, that to the extent that it's out there, but they can't control which customer puts it on. And the assumption there is that you can.
Mr. Shea, with all due respect, you're moving straight on to net metering.
Yeah.
And I'm still trying to find out how to calculate avoided distribution capacity value.
Yeah, I know. The definition of avoided distribution is complicated, and because it's so localized. And a typical approach for that is, okay, let's just not deal with all the locational issues and do what they did in Minnesota. And it's a standard approach, by the way, is to look at increased cost in total versus for load growth, increased cost for load growth divided by increased demand. Okay, when you go to do that for LG&E, you don't have increased demand, you have decreased demand. Therefore, if you apply, say, the Minnesota approach to KU, you get negative avoided cost. It results in a negative, which is probably accurate in a sense, because if you're putting more power on the grid and compensating them for that, then you create excess capacity. But in KU's case, you can't apply the formula because the demands are going down. And LG&E, depending on, is either flat or declining itself, so less so than KU. But KU, it's pretty dramatic. You cannot apply that formula because you get a negative avoided cost.
Right, so this is a standard formula for assuming there's growth, right, to avoid
It works
the
for
additional
growth.
capital
Yeah.
costs.
The Minnesota formula works for growth, it breaks down.
And I can appreciate that, and I guess where the company situation is, where that $2 I talked about, right, you spend $1 to avoid the 2. I just want to make sure that that you're not saying the company's approach is to assume that demand is sunk, that customers are going to use what customers are going to use.
Yeah.
So on the flip side of that is, how do you determine the calculus? How do you determine the base amount, the base cost, versus alternatives in trying to reduce those capacity costs upon the retirement or replacement of the current assets?
Yeah, and
And you're saying that's complicated.
Yeah, I mean, it's a very complicated scenario, but the companies do that because they will look at the load on circuits and which could change over time. To give you an example, KU has shrunk not because of, probably some conservation involved, but loss of customers in certain regions. but
Wycliffe and the far east, the far west in
yeah,
particular.
that sort of thing.
Yeah.
But also, conservation plays into it too, because people are, as time goes by, they're more conservative with their usage, therefore it comes into play. And you see saw the same thing with gas years ago that we're seeing with electric. And, but the engineering group, distribution, John Wolf would have been a better person to delve into some of these matters, but they do look at it by circuit, and they do plan, if there needs to be a major retirement of that or replacement of it, they will redesign it based upon current loads. If the major section is failing, if their small transformer fails, they can't do that because they got to replace it. But, but if, a major section of the system needs dire need of being replaced, they will look at it based upon current loads and forecast of those loads on that circuit. Therefore, they do circuit by circuit analysis for planning purposes.
And so they forecast those loads, what the replacement cost is going to be, and that's the base case in which they can compare alternatives to. Is that what you're saying?
Yeah, they look at the best, least cost method of serving that load based upon those forecasts.
Okay.
Now, the company putting in, it's more hypothetical, and it could come about, like you could have substations with, and you see a little bit of it now, but substations with solar panels, for example, or some other alternative. I think that's something that will be looked at, but that's sort of cutting edge stuff.
And this is what I want to get to. I haven't tried to bring in any of the other, the net metering, the QF, any of that necessarily. But this is the point now. When engineering is looking at it and saying, well, based off current demands, we think that the demand on that circuit is going to be X when we think we're going to have to retire and replace it in 5 years. Right? We know what the cost is today based off those estimates. We'll, escalate them a little bit for 5 years out. But that's our base case. That's what our anticipate. Let's look at alternatives, right? And you're saying that the study looked at certain circuits. Okay, even if everybody that was taking net metering that could, it hit the 15% peak on the particular circuit or circuits that were studied, we didn't determine that anything was going to be actually avoided. Right. I think is the outcome of that study. But that's looking exclusively at net metering. Mm-hmm. And net metering is, in and of itself, not necessarily the only thing that can reduce the habit.
Yeah, it's not exclusively net metering, because they take into consideration the forecast of the load on the circuits.
And that's fine. And what I'm saying is, when you look at alternatives, right, that doesn't say, well, if we put a battery out there, we could, serve load on the other end of that circuit and wouldn't have to necessarily have this size transformer, right? We own the battery, right? Or, if we had a demand response program that in and of itself looked at the ability, or was it a demand response program or an energy efficiency program, that might have these other effects that we can avoid this cost or that cost or that cost. And what it comes down to, what my question really comes down to, is it the company's position that net metering in and of itself is not going to avoid any costs as anticipated? Or is it the company's position that distribution capacity costs are in and of themselves across the board, with the exception of growth, forget growth for a second, unavoidable?
No, I think it's more the former, that they've looked at it and they don't see any opportunity for avoidance. And I don't think they believe that it's, and I truly, if the 1% cap, which is very real, if you had unlimited amounts, perhaps on a circuit, or if it have to be a fast-growing circuit, because once you have the facilities in place, they last, and it takes a lot of money to take it out and replace it for something smaller when they work just fine. Therefore, if you put in a conductor, generally the conductor, the pole is probably a 40-year life, the conductor is a 60-year life, and, or maybe 50-year life on the pole. Poles are long-lived, all of them are long-lived property. And it just does not make sense to downsize the conductor because you'd have to go out and take it out and put it in for no advantage because you wouldn't gain anything because it wouldn't give you more capacity. So to answer your question, the companies have looked at it and see no avoided cost on any of their circuits for distribution.
Okay. I appreciate that, Mr. Seeley. I do have a couple of questions about, and I say specific testimony, not as if my questions had your testimony anyways, but it's very specific parts of your testimony.
Okay.
I'm curious, I guess we'll start with it may be good in your rebuttal testimony, your supplemental rebuttal.
Okay.
This is why we shouldn't allow, a lot of states do SIR rebuttal, I'm sure you're aware. And I'm glad we don't do SIR rebuttal, but that's too many sets of testimony to remember. The supplemental rebuttal testimony, I think at page 3, well, I don't know exactly what page. But you talk about that the LOLP is inadequate for the allocation of fixed embedded costs. If it's inadequate for the allocation of fixed embedded costs, and you're talking about the June 30, 2021 order in this case, then it's equally inadequate for the allocation of avoided generation fixed costs.
Mm-hmm.
And my question was just, did Mr. Barnes use the LOLP to allocate avoided generation fixed costs?
Yes.
Okay, and how do you allocate avoided generation fixed costs?
How did he or how do I?
How did he?
The same way we did. He
Okay.
went at each hour and used the LOLP that the company developed and allocated it to each hour. He had another step and looked at total production of solar based upon the model that he used, PV watts, I think is what it's called. He simulated it based on that model, but he took each output from solar panels, rooftop solar panels, total output from the panels themselves, and assigned a value after allocating each hour based on our LOLP. Therefore, he mirrored exactly what we did in the cost service study.
Well, that's what I want to ask though. The cost of service study, the LOP as I understand it, maybe I'm incorrect, is used to allocate fixed production costs based on the contribution of certain classes to peaks in order to allocate those costs to the individual classes for cost of service
No,
purpose.
but there's a step, but that's later on.
Okay.
Okay, the first step, one of the reasons that we selected the LOLP methodology was it allocates it for each hour. Okay, therefore, all the LOLP did was to allocate production fixed cost to each hour of the year. Therefore, there's 8,760 hours a year. Therefore, we used the LOLP methodology to allocate. We calculated the LOLP that corresponded with the load during that hour to allocate fixed production cost by hour. Mr. Barnes did exactly the same thing.
And that's why I wanted to be very clear about it. We're talking upstream from the allocation of those costs to classes. You're talking about the allocation of fixed production expense to hours, all 8,760 hours. He basically, what you're saying is he's staying upstream, but he's just using the contribution of solar during those hours to allocate the avoided capacity costs.
Yeah.
Okay. That's very
First steps are the same. And
I was.
we took the second step we calculated it by hour, and then we took it to each class.
Okay.
Okay, so the first step is identical. What he did is the same as what we did in the cost of service study.
Okay. Well before the allocation of the actual fixed expenses to the individual classes. Okay.
That
That's
was
helpful.
before, and then
Way
we did
before.
that later.
Many steps before. Okay. And I just want to ask you, in your, sorry, I think it's your rebuttal, but it may be your supplemental, where you discuss the basis, you discuss about PJM Netcom, and I think that's your rebuttal testimony.
Yeah, I think it's a rebuttal.
I know it's page 9 or 10, but I don't have down exactly which testimony.
Yeah, I believe it's a rebuttal, because I don't think I talked about it in the direct, because I was
I'll let Mr.
responding to
Love get
Mr.
there.
Barnes.
Actually, maybe
I
in the
believe-
supplemental.
Yeah, for Mr. Chairman, I believe where you might be going anyway is in his supplemental rebuttal testimony. It looks like maybe starting at page 8, we start talking about net cone.
I think it is, because I also have a note here that you discussed Mill Creek 1 in your supplemental rebuttal in 9 and 10, so that would make sense. So it's your supplemental testimony, my apologies, Mr. Lufkin. Your supplemental testimony, page 8, 9, 10.
I think supplemental rebuttal, I believe.
Supplemental.
It's a rebuttal.
Supplemental rebuttal, yeah.
All right, hold on 1 second.
I believe that's right.
I've got it up on my iPad.
It's a massive record here, so.
It looks like it goes through those, at least 8 through 10 there.
All right.
I'm in the vicinity.
Okay, it is. I think on page 8, the question from the attorney is there anything wrong with this approach? And it's regarding the previous question and answer about cost of new entry from PJM. Do you see that?
Mm-hmm.
Okay, so there's a significant discussion here about netcone. And as I understand it, it's your sort of rebuttal to Mr. Barnes's proposal to use, I think it's Mr. Barnes's proposal to use netcone, the PJM determination of netcone as a proxy for a replacement capacity resource. Is that accurate? For avoided generation capacity cost?
Would you restate the question?
Yeah, that it's your rebuttal to Mr. Barnes's assertion that the commission can use the PJM netcone as a proxy unit for avoided generation capacity cost.
That's what he said in the supplemental testimony, and that's,
Okay. And you talk about how there is a problem with the approach, that neither KU nor LGE are a member of PJM, and that netcone from PJM has no bearing on the company's costs, and that netcone is a market construct developed as part of the market design for the PJM generation capacity auction.
Right.
So then you go on to say, on page 8, that netcone rarely comes into play in PJM.
right.
And so, I'm just curious what your experience is or understanding of what role netcone does play in PJM.
Okay, what, for a new entry capacity, it applies. Okay, if, in other words, you build a new generator and you want compensation, you cannot charge less, you cannot bid less than the netcone.
Okay, so what
It's a
you're
minimum.
saying, just to be clear, what you're saying is that the minimum offer price for a new entrant unit, even competitive in PJM, is this net cost of new entry. That's the cost of new entry net of energy and ancillary services revenues, right?
Net of the revenues from ancillary service rates, right.
Okay. Is there any other role that netcone that you're aware of plays in PJM?
None that I'm aware of.
Okay, so are you familiar with the VRR curve?
Vaguely.
Okay, and do you understand the VRR is the demand curve for the PJM based residual auction?
Right.
And so did you know that net cone is the anchor point in at least 2 places on the VRR curve in setting demand for the base residual auction?
Oh, okay. And, yeah, I forgot that.
Okay, so if that was the case, taking on its face that the PJM net cone is the anchor point, at least on 2 places of the VRR curve, that is the demand curve for the base residual auction, would you agree that net cone does come into play in PJM in a
I
significant
mean, in
way
that
for-
sense, but in
for capacity?
terms of a bid in determining the MOPR, it doesn't much. It does some, because there's a little bit bid on that. And the reason for that is that PJM, particularly certain regions, are flush with capacity. They have excess capacity. Therefore, that's why it doesn't come into play, is they don't have a need for new entry capacity.
So, well, taking a step back, are you saying that no new capacity is being built in PJM?
No, I didn't say that. It's
Okay.
a very small percentage. I'm just saying that in general, the capacity situation in many regions of PJM, they have sufficient capacity.
For reliability is what you're
Yes, for
saying.
reliability.
But that's not how the market works, right? The idea of the market is regardless of reliability, if new entry can push out the older, more expensive, or then they have to be older, more expensive current entrants, it's a 3-year capacity option.
Yeah, but
People can enter all the time, right?
Yeah, but they can't go below the cone. And that precludes cone coming into play because the embedded or existing facilities, cone doesn't apply to them. They operate under the avoided cost rule. All they have to do, they can't go below their avoided cost. So they can undercut cone significantly, but they can't go below their avoided cost. In neither case can they go below their avoided cost.
I'm just saying, I'd be surprised to find out that current generators can't go below net ACR because a number of generators still bid it at 0. They're called price takers.
Yeah, that's
in
for their
PJM,
own
correct?
capacity. That's for their own capacity. You can bid in at 0 to effectively keep your own capacity, is from my understanding.
As long as you're not MOPR.
Right.
Okay. And so, I guess I'm confused. Is it your understanding that combined cycle units are being built in PJM every year?
A small percentage of them built in terms of the total capacity, but yeah, I suspect that all of the types of facilities are being built. So combined cycle being one of them.
Okay. So,
Because PJM is very large. It may be a small percentage, but they're still being built.
yeah, I mean, demand can be 160,000 megawatts on any given day, right?
Because it's a major footprint.
So you talk about net cone only in here in terms of its use as a MOPR, but you're not arguing that net cone isn't used in other ways to determine the capacity
Yeah,
price
I
of
was
PJM.
responding, Mr. Barnes mentioned MOPR, so that's what I was responding to.
Okay, because you had a couple of statements in here, like that it rarely comes into play in PJM.
Yeah, I meant in terms of the bid capacity.
Well, but again, if it sets the demand, if it's an anchor point at least 2 places for the demand
For the
curve,
curve, yeah. I
Then-
see your point.
then
Yeah.
the demand curve for the VRA, it's specifically being taken into account, the clearing price, right?
Yeah, it impacts it. It impacts it. I don't disagree with that, but what I was saying is setting the MOPR price, it's only less than 1%.
Okay, and then on page 10, where you say, and sorry, I'll let you get there, it's line 17. Please let me know when you have it.
Okay, I'm there.
That there is little or no need for additional capacity at PJM, therefore, the net cone has no significance, not
Yeah.
even in PJM.
Yeah.
So I guess I'll give you an option here to clarify that. You're not talking about that net cone plays that has no significance in the PJM capacity option, right?
Yeah, that's a little,
Is that hyperbole?
that's a little
maybe?
strong, yeah,
Okay.
because I think it has very limited impact would be a better way to word that.
Okay, and then just to be clear,
I probably meant to say little or no.
on page 10 as well, on line 15, just up from that, starting on 14, you say, just as the net cone does not apply to capacity value in PJM, it does not apply for KU and LG&E. Again, you're just talking about MOPR. You're not talking about, well, you would agree that net cone does apply to capacity value
Yeah,
in PJM.
Don't disagree with that. What I was referring to is the MOPR as proposed by Mr. Barnes.
Okay,
Because he was specifically was speaking of MOPR.
okay. All right, I appreciate it, Mr. Sinclair. The rest of the questions, I had two more questions for you, but I think they'd be better for Mr. Conroy.
No, okay.
Because I want to get to the fuel adjustment
Well,
clause here for a
thank you.
second, so. I've always got your back, Mr. Do that. Any question you'd like to continue to point to Mr. Conroy, you go ahead and do so. He'll be fine. So, all right, thank you very much, Mr. Seeley. Mr. Crosby, do you have any redirect, or would you like to take a break before you redirect?
If we could take a break, I'd appreciate it.
That'd be
I
great.
have a few redirect questions.
So it is currently 2:45. Would you like to take a break until 3?
That's fine. If that's convenient for the commission, that's fine, sure.
Okay. Does anybody have any objection to taking that long of a break? I see all red on the screen. All right, we will take a short recess until 3 o'clock. Great, we're back on the record in case numbers 2020-349 and 2020-350. Mr. Crosby, do you have any redirect for Mr. Seeley?
Briefly, yes, sir. Thank you. Mr. Seeley, do you have your supplemental direct testimony at page 17 available to you, please? And I direct your attention to lines 6 and 7. Let me know when you're there, please.
I'm there.
All right. I believe there was a question from Mr. Spinard there about to which commission you were referring on line 6 when we talk about the avoided generation capacity cost approved by the commission. Have you reviewed that again?
Yeah, I have, and what I do mean is this commission, because what the 1% amount is set forth in the company's tariff approved by the FERC, but the sentence should mean, when we're talking about the avoided generation capacity cost approved by the commission, I meant this commission. So I misspoke. when
This
I
commission
was
being the Kentucky
talking
Public
to,
Service Commission.
Mr. Spinard.
I'm sorry, you mean the Kentucky Public Service Commission?
Yes.
Okay, thank you very much. With respect to the exchange that you had recently with the chairman concerning PJM net cone, do you recall that exchange?
I do.
Mr. Seeley, is it still your testimony that PJM net cone has no bearing at all on the company's avoided generation capacity costs?
It does not.
How do the companies procure capacity when they need it?
They procure it, they analyze it with their IRP process, and they determine when they have a need, and they either install capacity or go out to the market and purchase capacity.
And as part of any of that, they would then, just to rephrase a little bit, they would go to the market, typically issuing a request for proposals, is that correct?
Yes, that's exactly what they would do.
Okay. And then typically they would look for the lowest reasonable cost alternative that meets their customers' needs,
Yes,
is that correct?
based upon, they would evaluate the RFPs and determine which one is most cost-effective and represents the lowest reasonable cost.
Okay. Do you still have your supplemental testimony available to you? Your supplemental direct, I guess?
I do.
Okay, can you go to page 30, please? I believe you had some questions there, a discussion there with the vice chairperson. Do you remember that?
Page 33, did you?
30.
30, okay.
The
Okay,
table.
I'm there, okay.
And had some discussion around the different cost components contained in this table.
Yes,
Mr. Seeley, is it your view that of the 7 avoided cost components, I think you said there were 7 avoided cost components here, how many of those would be equally well avoided by utility scale solar on a kilowatt hour for kilowatt hour basis as by, say, rooftop solar? And can you identify which cost categories those would be?
going through them now, just 1 second, avoided generation. Okay, the avoided energy cost clearly would be, the avoided ancillary service cost would be fully incorporated in the capacity component. The avoided generation capacity cost would be in the a solar PPA or any PPA, any capacity-related PPA. Avoided environmental cost would be presumably jobs benefits would as well. That one would be difficult, but in my view, they're an externality, should be considered. So I would say 5 of the 7.
Okay, thank you. And Mr. Seeley, is it your understanding that the company's recent solar PPA experience, as well as that of recent solar PPAs approved by this commission for Big Rivers Electric Corporation, indicate that utility scale solar, say in the, anywhere from the 40 megawatt, I believe, 1 moment please, 40 megawatt to 160 megawatt range can be had for roughly less than 3 cents a kilowatt hour?
Yeah, I saw one that was 1.6 cents per kilowatt hour plus, but yes, in that range.
But the recent ones approved in Kentucky are in the, a little less than 3 cents,
Yeah,
is that fair?
but, yeah,
Okay,
a
thank
little
you.
less, I
Okay.
misspoke. A little less than 3 cents, not 2 cents.
Okay, thank you. That's all I have, Mr. Chairman. Thank you.
All right, do we have any additional questions, Mr. Kurtz?
Do you mind?
I wouldn't have asked. Very quickly. I promise you, if I mind, I won't ask. Please go ahead.
Thank you. Lots of people work at coal plants, right? It's very labor intensive,
Yes.
certainly compared to combined cycle or other facilities. Okay, now, so if a coal plant was retired, and they're all union employees too, by the way, right?
Yeah, I would say 90 plus would be, yeah.
Okay, so if you retire a coal plant and you avoid or get rid of the employee costs, but the net book cost of the coal plant doesn't go away, does it?
No.
Okay. Is there any evidence in the record that it would be economic to retire a coal plant to eliminate the employee cost and replace it with something else? Is there any evidence in this record that doing that would be cheaper than status quo?
I have seen no analysis that supports that, no.
If it were less expensive, would the company do it?
Presumably, yes. I mean, if it could avoid cost, the company, I mean, that's exactly what they would look at with Brown 3, is if it's economical to shut it down for various reasons, they would retire the unit.
Thank you, Chairman.
Thank you. Mr. Cook, any questions?
No, Chairman, no questions.
Okay. Mr. Spinard, any questions?
I just want one follow-up for clarification, and I apologize for my confusion. With regard to your supplemental testimony at, that you were examined, Mr. Duncan conducted the examination on page 17. In terms of reading it out, is that in terms of your two alternatives, you could have a compensation rate based upon the FERC determined Schedule 3 charge for the oat, or alternatively, you could have a charge that is determined by the Kentucky Public Service Commission in terms of its process. That if I understand your testimony, is that those are amounts, those are alternatives that are uniquely, they're arrived at uniquely by different jurisdictional bodies.
On the first one, it's clearly the FERC, because the OATT and the ancillary services that are in Schedule 3 are FERC-approved rates. The second one is frankly, and that's what caused my confusion when I answered your question, the second one is in fact a hybrid blend of the two. And what I mean by that is built into Schedule 3 is 1% of the capacity cost that's set forth in that. 1% is of a percentage that's set forth in the Schedule 3 of the OATT. That 1% is approved by the FERC. But when I refer to avoided generation capacity cost, I was referring to any avoided generation capacity costs that might be approved by this commission, by the Kentucky Public Service Commission. So the 1% is FERC, but the avoided generation capacity cost is correctly stated approved by this commission.
Okay, and with regard to that, is it your testimony with regard to line 5 and hypothetical on this one? I know this is not your testimony, but this puts it into contrast for me. For example, in terms of your alternatives, could you have, for example, listed a different percentage amount? For example, could you have listed and said, instead, second comma, the charge could be determined as 0.75%?
No.
Okay,
You could
and-
not, because 1% is set forth in the OAT.
Okay.
It's set forth in the ancillary service. That's where I got the 1%, which is you see what they do in you take your reserve capacity, transmission capacity, you take 1% times that reserve capacity times a stated capacity value, generation capacity value in the OAT. Okay, the thing with that capacity value is that is an embedded cost. Okay, the capacity value that's set forth in the OAT is an embedded capacity. Therefore, 1 would be 1% still times an embedded capacity cost. Okay, the second alternative is the same principle, except it's based upon the avoided cost approved by this commission for capacity.
So in terms of the hybrid, the 1% is fixed, and the avoided generation capacity cost would be the variable in your example.
Yes, that's correct.
Okay, all right. Thank you, Mr. Seeley. Mr. Chairman, no further questions.
Mr. Miller, do you have any questions for Mr. Seeley? Any additional questions?
Nothing further from us, Your Honor. Thank you.
Mr. Fitzgerald, I can see you coming through the camera. Do you have a couple of questions for Mr. Seeley?
Just a couple, Mr.
Okay.
Chairman. Thank you very
Please
much.
proceed.
Mr. Seeley, can you still hear me?
I can.
Okay. I understand your testimony more than once today to be that you and the companies view the potential economic development benefits, including jobs associated with net metering, to be an externality. Is that correct?
Yes, that is my view, and I think it's the company's view as well.
Okay. In the development of the NMS2 rate and in the design of that rate, did you, or to your knowledge, anyone else on behalf of the companies, do a specific economic development or a jobs benefit analysis on the number or the types of jobs that would be created under the various net metering compensatory rates or netting periods?
We did not do, as far as I'm aware of, the company did not do a jobs analysis for net metering.
Okay, and you seem to be familiar with both the May 14th Kentucky Power Company order and the earlier order in this case that established the schedule for this supplemental proceeding and the scope of this proceeding?
Yes.
Is that correct?
Yes.
Do you recall that either of those orders said to the companies, include an analysis of economic development or jobs, but only if you think it's a good idea?
I do not think it's a good idea because I think jobs is an externality that should not be included in the rate. So.
Right, and I understand it, but that's not the question I asked you, Mr. Seeley. I said, do you recall that the order said to the companies that they could include or omit an economic development or jobs benefit analysis based on whether they thought it was a good or a bad idea to consider it?
Okay, I can't recall that, but I'll accept.
Okay, well,
That's what
we're on
it
the
says.
same page because I sure didn't see it either. Thank you, Mr. Seeley. No further questions, Mr. Chairman.
Ms. Vincent, do you have any questions for Mr. Seeley?
Just a very few. Mr. Seeley, are you aware of the RFP that the companies issued in January of this year?
I'm aware of the RFP, yes.
And in that RFP, the companies are requesting RFP for 300 megawatts to 900 megawatts energy and capacity beginning in 2025 to 2028 and potentially earlier than 2025. At the April 28th, I believe, hearing, Mr. Beller confirmed that it's possible that the companies may seek to have this additional energy and capacity before 2025. So can you reconcile your testimony today that LG&E KU do not need additional generation with this RFP?
I'm not the best person to answer that question.
Well,
I think the view currently is that the capacity isn't needed until 2028. You know, I'm not sure if the company's going to act on that RFP based upon that current view or not. But again, I'm not the best person to answer that question.
So, again, I'm not trying to drive home a point. I'm understanding that what you're saying to me is you can't reconcile the fact that this RFP was issued and your testimony that the companies do not need additional generation?
Yeah, the only thing I can, why they issued the RFP, I don't have enough information to reconcile it one way or the other.
Okay.
But, perhaps why they have not or may not act on it for a little while, there's a lead time on that, is I think the current view is that they don't need capacity until 2028. So, I'm not intimately involved in that RFP, so I'm not the best person Mr. Sinclair would be.
Okay, thank you very much. Nothing further.
Vice Chair?
Ellie?
Would Mr. Conroy be the next best person to ask the question Ms. Vinsel just asked?
Perhaps, it wouldn't be me. So I don't know if Mr. Conroy would be or not.
That's three
You
questions.
could ask him that.
Three questions you pushed off to Mr. Conroy now. Thank you, Mr. Seeley. Mr. Crosby, do you have any additional redirect?
No, Mr. Chairman, we're fine.
Okay.
Thank you.
All right, thank you very much. Mr. Seeley, can Mr. Seeley be excused?
Yes, you may.
Okay. And we'll give Mr. Seeley some time to step down, and then you may call your next witness, Mr. Crosby.
Mr. Chairman, LGDKU would call Robert Conroy.
Mr. Conroy, please raise your right hand. Do you swear or affirm the testimony you're about to give is true and correct under penalty of perjury?
I do.
Please have a seat. State your name and the address for the record.
My name is Robert M. Conroy. Address is 220 West Main Street, Louisville, Kentucky.
Mr. Seeley's having the same problem with that door that I usually have, so. Mr. Crosby, you may ask.
Thank you, Mr. Chairman. Mr. Conroy, good afternoon. By whom are you employed and in what capacity, please?
I am Vice President of State Regulation and Rates for LG&E and AU Energy.
Did you cause to be prepared and filed in this proceeding written direct and rebuttal testimony as well as supplemental direct and rebuttal testimony?
I did.
Are you the sponsor of certain data requests answered by the companies in these cases?
I am.
And do you adopt your pre-filed testimony and responses to data requests as your testimony today?
I do.
Mr. Conroy, would you please for the record state what you have available to you or with you today at the stand?
Yeah, I have available electronically everything that's in the case. I have hard copies of my testimony, supplemental and rebuttal testimony, as well as the interveners' supplemental and rebuttal testimony, responses to data requests in the 7th and 8th round that I sponsored, as well as some statutes and regulation. A notepad with a number of questions that I'm aware were deferred to me.
Okay, all right. He is available for cross, Mr. Chairman.
Thank you. Mr. Kurtz, do you have any questions?
I do, very briefly. Good afternoon, Mr. Conroy.
Good afternoon.
A QF contract up to 80 megawatts can have a large rate impact, or it could be a lot of money from consumers to the QF. Would you agree with that?
It could very well be, depending upon how it's set.
Depending on what?
Depending on how that rate is set.
Right, okay. within a large 20-year QF contract, there will also be lots of terms and conditions in terms of assignability, penalties for non-performance, security deposits, I don't know, covenants. The contract could be lengthy, could it not?
I would assume it would be very similar to any other PPA contract that we would enter into.
Okay. Assuming that you enter into a 20-year QF contract with some QF, is it your expectation that you would bring it to the commission for approval, or would you just sign it and that would be that?
It would likely be brought, with that order of magnitude, it'd likely be brought before the commission.
So you would have no objection if the commission required you to bring those contracts for approval?
I would not know.
Okay. Thank you, Chairman.
Mr. Cook?
No questions, Chairman.
Okay. Mr. Spinard, do you have any questions for Mr. Conroy?
Yes, Mr. Chairman.
Please proceed.
Thank you. Good afternoon, Mr. Conroy.
Good afternoon.
In terms of the application and the instant cases, your written testimony was submitted as part of both of the applications. Is that correct?
What do you mean?
In terms of the applications that were tendered on November 25th, 2020, specifically your volume 2 of 4 in each of the dockets, those testimonies including your pre-filed direct testimony. Is that correct?
That's correct.
Okay, and in terms of Appendix A to your written testimony, and we're looking at your qualifications, it's fair to say that that's basically, Appendix A sets forth your background, who you are and what you've done with regard to utility. Is that a fair characterization?
That's correct.
Okay, and in terms of your review of your Appendix A in your testimony, is it fair to state that by education, training, and/or experience, you have technical or other specialized knowledge regarding rates that will assist the commission in understanding the company's applications?
I have experience in the rates and regulatory area for the last 14 years with the company.
Okay, and in terms of your experience, and this is always something that we seem to walk through, and it's appropriate. In terms of your experience in rates, you're not an attorney. That's correct?
I am not an attorney.
And we're not going to ask you to give any legal opinions, but when you're asked these questions, it's asked in the context of your understanding, if you have one, in terms of your knowledge and backgrounds in rates. And again, per your appendix, that since at least April 2004, when you became manager of rates, you're fairly substantial work experience in rates. Is that correct?
I've spent probably about half my career at the company in the regulatory area, the other half in generation planning.
Okay. In terms of your supplemental testimony that was filed into the record on July 13th, among other things, beginning on page 4, line 12, you discuss job benefits component of net metering. Are you aware of that?
Yes, I am.
Okay, and also in terms of your supplemental rebuttal testimony, and this was filed into the record on page 4. Also, this one beginning at line 16, you have a discussion regarding a jobs benefit and economic development study, your commentary on that. Are you aware of that?
Yes, I am.
Okay. On the global, and I just ask that you focus on answering the question that's asked, and on the global, the big picture question. Is it the position of the companies that the commission has no authority to consider jobs benefits or economic development as part of its rate-making authority?
That's my understanding, yes.
Okay. Is it your understanding, as a person familiar with rates, not as an attorney, that the companies are required to be indifferent to job creation when designing rates.
I'm not sure what you mean by that.
Well, you've been doing rates now, I think your testimony for roughly half of your career. When you're designing rates, is it your understanding in terms of your role in helping the companies design rates to supply applications to this commission, is it your understanding that the companies are required to be indifferent to the issues of job creation when designing rates, that you're not to incorporate job creation as part of the rate design process?
I mean, the design of rates is to reflect our cost of providing service. It should be just, fair, and reasonable for all customers.
Okay, and in going from point A to point B, with the point B being the just, fair, and reasonable rates, are you allowed to take into consideration, are you allowed or not allowed to take into consideration job creation when designing those rates?
Well, again, we design our rates to reflect the cost of providing service. Job creation is not a cost of providing the service to our customers.
Okay. And in terms of your experience as rates, and I don't want to get too granular on this, but there's cost of service, and so you have a cost of service study, and then there's also rate design. Those aren't necessarily synonymous concepts, are they?
Not necessarily. I mean, rate design reflects cost of providing service, and we attempt to design rates to reflect the different components of our cost, whether it's a customer cost, a demand cost, or an energy cost.
Okay.
It's all part of the cost of service studies that Mr. Seeley does, and the allocation and classification of costs.
Okay. In terms of your understanding as a rate specialist and not as an attorney, are the companies required to be indifferent to economic development when designing rates?
Again, I'll repeat the same thing. We design our rates to recover our cost of providing service.
Okay. And in terms of the supplemental rebuttal testimonies at page 5, your supplemental rebuttal testimony at page 5, and this is footnote 10, you reference 3 orders of this commission from case number 2020-00016 in support of your testimony, and this is specifically, you reference the orders entered by the commission on May 8th, 2020, June 18th, 2020, and December 12th, 2020. I certainly hope I got those correct. Are you aware of that?
You're referring to lines 11 through 13 in the footnote 10?
Well, when I look at footnote 10, and bear with me for a second, you have the discussion in the text, lines 11 through 13, and then at the end of that discussion you reference in footnote 10, and I'm referring to, you're aware of those orders December 16th, June 18th, and May 8th, all of 2020. You reference those orders and rely upon those for the testimony that you cite. Is that correct?
Yeah, we're citing case number 2020-2000, or case number 2020-0016, and those are 3 orders that were issued in that case, yes.
Okay. And did you read each of those orders prior to filing your supplemental rebuttal testimony?
I'm very familiar with all 3 orders, yes.
Okay. And in terms of the application in 2020-0016 that you reference at page 5, footnote 11, you're familiar with the application. What's your level of, I'm sorry, I should let you answer the question. What's your level of familiarity with the application in case number 2020-00016?
I am familiar with the application in that case in total.
Okay. And does it remain your testimony today on behalf of the company that the commission may not consider, even in terms of, for any measure of assessment, jobs benefit or economic development when considering the development of net metering rates?
Yes.
Okay. Would you agree or disagree with the statement that your supplemental testimony on page 4, line 18, offers an opinion, not necessarily a legal opinion, but offers an opinion as a specialist in rates, as to the limits of the commission's jurisdiction?
And can you give me that reference again, page?
This is page 4 of your supplemental testimony, and I apologize if I've led you astray on this one. I'm looking at your supplemental testimony, page 4, line 18, and it's the discussion that begins, and I apologize, that may have been unfair. The question itself begins on line 16, or the title itself, this is subpart 3, where this section talks about the commission's jurisdiction. Do you see that?
Again, are you in Conroy supplemental testimony, page 4,
That's correct.
in the section 3, line 12, jobs benefit components?
Right, this is the jobs benefit component of net metering, and if you read down through that in your response on line 18, you stated in pertinent part, the conversation continues, to say that from the previous line that well, let's just read the previous line. The companies respectfully state that such a, quote, jobs benefit, unquote, component of a net metering compensation rate would be outside the commission's jurisdiction, comma, and then it continues. So you see that testimony?
Yes, I did.
Okay. And with regard to your testimony and your supplemental rebuttal testimony, again, you have a discussion concerning the commission's jurisdiction with regard to jobs, benefit, and economic development, and that discussion begins on page 4 at line 16 and then continues thereon into the next pages. So is it correct that at least twice in these cases you've offered your opinion as to the commission's jurisdiction with regard to jobs benefit, and also on the supplemental rebuttal testimony you've offered your opinion with regard to the commission's jurisdiction on economic development? Is that a fair characterization?
Well, let's just elaborate on jobs benefits are an externality, and based upon the many cases I've been involved in with the commission, they have indicated in orders and statements that externalities, environmental externalities and other externalities, are not within the commission's jurisdiction. That's the basis for my statements, and I believe there's several sites within numerous my testimony to where the commission has made those statements. So that's the basis of my assertion in these testimonies on jobs benefits.
Okay. Is it your opinion that the commission may not require the companies to study jobs benefits?
Well, the commission can ask us to study anything in their
Okay.
orders.
Is it your, and that would, let's follow up on that. In your opinion, may the commission mandate, enter an order that says the company shall take the action? Is it your opinion that the commission may require the companies to study economic development as it pertains to net metering rates?
Well, I mean, are you asking for a legal opinion?
No, I'm asking you for your opinion as to, I apologize if I didn't make that clear. I'm asking your opinion as someone who has twice in this proceeding offered an opinion in terms of the commission's jurisdiction, and having offered an opinion as to the commission's jurisdiction, I'm asking you whether or not the commission's, in your opinion, the commission may require the companies to study economic development as it pertains to net metering rates.
Well, I'm aware that they had statements within Kentucky Power's rate case order requesting them to study in their next rate case. I'm aware of what they stated in our order in our case.
Okay.
So, I mean, they have the ability to require within those orders.
Okay, well, and I think at that stage, I think that's about the extent of where we need to go in terms of that, of your, any further understanding, I think is a legal matter for briefing. But with that, thank you for your answers, and no further questions, Mr. Chairman.
Mr. Miller, do you have any questions for Mr. Conroy?
No questions. Thank you, Your Honor.
Mr. Fitzgerald?
Yes, Mr. Chairman, I do have some questions. Mr. Conroy, can you hear me okay?
I can.
Great, great. Let me start hopefully with something that's fairly simple. What's the duration of the billing period currently for residential customers in the LG&E and KU systems?
What's the billing cycle
Yeah,
for residential? It can range anywhere from probably 26 days to 33 or 34.
Okay, and is it different for commercial customers?
No, our billing cycles, I think, are pretty much the same. It's outlined in our tariff when we read our bills and the window for meter readers to actually read the bills.
Okay, and is that duration of the billing period, what did you say, 28 to 34 days, is that period the same for customers in either the residential or commercial class that are taking service under a net metering tariff?
Well, again, they're still taking service under standard rate schedules, RS and GS.
Right.
So yes, it's the same. It's the
Great,
same.
thank you for that clarification. And do you know, is that period, that roughly monthly period, the 28 to 34 days, is that generally the same for other PSC regulated electric utilities in Kentucky, to your knowledge?
I would assume so, that most of the utilities have similar billing cycles.
Okay, and has that changed in the LG&E and KU system since 2018?
No, it has not.
Okay, what I'd like to do is ask a couple other questions, and then I would like to, but I'd like to follow up on this whole question of economic development. Do you, in your leisure time, of which I'm sure you have none, do you ever have occasion to visit the website of the parent of LG&E and KU, PPL?
I didn't hear all that question. What was your beginning of that?
Oh, I'm sorry. I was asking, in all your spare time, do you ever have a chance to look at the PPL website?
Yes, I've looked at the corporate website, yes.
Okay, and are you on an email list to get any press releases from the company?
We don't have an email list, but I'm familiar with press releases, yes.
Okay, and specifically, are you familiar with an October 6th, 2020 press release where PPL announced that an international magazine had named LG&E and KU among the top 20 U.S. utilities in economic development success?
I have not looked at that one lately, and I assume that if it's out on the website that it's correct. But I have not read through that.
Okay, well, let me share this with you, and Mr. Chairman, if it's possible, this is a publicly available press release that is on the PPL website, and I was not intending to ask until we got into this this conversation regarding economic development, but I would like to be able to send the hard copy of this in as Joint Intervenors Exhibit 2, if there's no objection. I'm not going to mark or in any way alter the website that appears at the pplweb.mediaroom.com.
So, Mr. Fitzgerald, we'll go ahead and note it as joint interveners too. If you'll share it, let you lay the foundation for it and ask questions on it, then I'll ask the rest of the parties if they have an objection to its introduction into the record.
Okay, I appreciate that. Mr. Cabral, what I wanted to do is share with you a quote that is attributed to Eileen Saunders. Now, first, can you tell me who is Eileen Saunders?
Eileen Saunders is our Vice President of Customer Service.
Okay. She's quoted as saying, "It's an honor to be named a top utility for our company's commitment to economic development in the communities we serve. Through innovative programs and incentives, along with the tireless efforts of our business and economic development team, we're proud to help empower business growth and expansion throughout Kentucky." Now, are you familiar with the innovative programs and incentives that LG&E and KU have available for economic development?
I'm not sure what Ms. Saunders was referring to on those. We do have programs throughout the state where we are involved in attracting new businesses. We work with the state in general to bring entities into the state for growth.
Okay, and can that include incentives like rates that might be more attractive than the rates that would otherwise be available to a customer in that class?
If you're referring to our economic development rider, there are provisions within that to allow for a discounted demand rate over a period of time for growth within our service territory.
Okay, thank you. Could you do you have your supplemental rebuttal testimony available?
Supplemental rebuttal, yes.
Okay. Could you turn to, let's see, page, I think it's page 8. No, I'm sorry, page 11, lines 18 through 22. I think that's the right page.
Page 11.
Lines 18 to 22?
Yes.
Okay. Could you, just to make sure I've got the right one, could you read me your testimony from lines 18 through 22?
It says, moreover, it seems unlikely that Messrs. Barnes and Robigo would have the same position if they believed the commission would set an NMS2 compensation rate in excess of the company's retail residential energy rates.
Okay, and then go to page 12, lines 1 through 3. And read that, please.
Let me you want me to continue on with the bottom
yeah,
of page
that'd be
11?
great.
It says, in contrast to the companies, which are largely financially indifferent to NMS2 compensation rates because all customers, not the companies, will bear the cost for excess energy supplied to the grid by a customer generator. Messrs. Barnes and Robigo are employed in these proceedings by entities with direct financial ties to the installation of small-scale solar facilities.
Okay, thank you. Let me start by asking you, what evidence do you have that any of the joint intervenor organizations who sponsored the testimony of Mr. Robigo have, quote, direct financial ties to the installation of small-scale solar facilities, end quote?
Well, they represent businesses that they're testifying on behalf of businesses that have interest in promoting and developing solar generation.
And you consider that to be direct financial ties?
Well, again, they're employed as testifying experts. I would assume that they're being paid for those testimonies, so that's a financial benefit to promote.
Okay, but that's not what you stated, Mr. Conroy. I'd like to get this clear. What evidence do you have that any of the joint intervenor organizations, now that is Mountain Association, Kentuckians for the Commonwealth, the Metropolitan Housing Coalition, or the Kentucky Solar Energy Society, all of which you are aware, or should be, because we provided you the 990s for each one of these, are nonprofit 501c3 tax-exempt organizations. What evidence do you have that any of those organizations who sponsored the testimony of Mr. Robigo have direct financial ties to the installation of small-scale solar facilities?
Well, I don't recall specifically exactly what's within those. But in general, they are employed by entities that are interested in small-scale solar facilities.
I'm sorry, you say they are employed? Your suggestion here was that the joint intervenor organizations, not Mr. Robigo, have direct financial ties to the installation of small-scale solar facilities. And my question again, what evidence do you have that any of these four nonprofits have direct financial ties to the installation of small-scale solar facilities, or that they profit from the installation of small-scale solar facilities?
Again, they are interested in promoting solar. That's the point I was trying to make here, is that their interest is in the development and promotion of solar. Our interest in providing lowest cost energy to our customers. So they're two different interests in the proceeding. That's my point there that I'm making.
Is that, okay, thank you. That's somewhat different than what you actually said there. Are you suggesting that Mr. Robigo or Mr. Barnes have in any way altered their conclusions or lied or distorted their testimony for personal financial gain?
I am not saying anything like that.
Is it your position that Mr. Barnes and Mr. Robigo have skewed their testimony to benefit their sponsors?
I'm not saying anything like that either.
Is it your position that someone who hired, excuse me?
What I'm saying is, from our company's perspective, we're proposing a compensation rate that is based upon the philosophy of providing safe and reliable power to all customers at the lowest reasonable cost. Whereas I believe the joint interveners and the other witnesses are promoting the highest possible cost that will justify and benefit the installation of solar generation. Those are two different objective functions.
Now, let me ask this, and this is not to impugn your motives, the way that I believe you have for these two gentlemen who are professionals in their field, but doesn't your company have its own solar offerings to customers?
We do, yes.
Okay, and would not the company stand to gain? Well, actually, before I get to there, do you shareholders realize a rate of return on investments that your company makes in expanding your solar offerings?
I didn't hear the question, but
Do your shareholders, the shareholders of LG&E, KU, PPL, receive a rate of return on investments that your companies make in expanding solar offerings that are offered to retail customers?
if you're referring to the Solar Share program, the Solar Share program is paid for by the subscribers of Solar Share. So through the rates that they charge, or they pay, they're paying for the facilities.
And are you getting any sort of rate of return on that?
The companies are not, no.
Okay, and the shareholders are not either?
No, if you recall, in the cost of service study, there's an adjustment to ensure that all of the customers aren't paying for the investments in Solar Share.
Okay. So is it your position, Mr. Conroy, that someone who hires an expert or compensates a witness, that automatically casts doubt on the veracity of their testimony?
I'm not casting doubt on their testimony. I'm just saying their interests are different than what ours are for the company. for all customers. That's all I'm saying here.
And you're, because you believe, okay, now, have you had conversations with Mr. Robigo or Mr. Barnes about their motivations?
I have not, no.
Okay, and would it surprise you to believe that they are of the mind that the value of rooftop solar exceeds the cost?
Yes, I believe that's typically the approach that they've taken, yes.
Okay, and have you read the score of studies, and I can go through them if you need to, that have looked at the value of solar in one form or another, which are included in Mr. Robigo's testimony in reference to the SEIA.org solar cost of benefits studies? Have you reviewed those?
I have not read through all of the numerous value of solar studies. Again, as a company, our objective is to ensure that we provide safe and reliable power to all customers at the lowest reasonable cost.
Right.
It's
And-
based
and I
upon
was-
costs.
I would assume you would agree that the determination of what is reasonable is in this case is to be done consistently with the Kentucky Power Company order of May 14th, 2021, right?
Will you say that again?
I assume that you don't dispute, because I think your testimony said that so far the commission had gotten it right, but I assume you don't dispute that the boundaries of what is lowest reasonable cost have been established for rooftop net metering by the May 14th, 2021 order in the Kentucky Power case.
I think what the Kentucky Power Order was established a framework of 7
Okay.
avoided cost components that should be considered. And as Mr. Seeley previously discussed, those are valid avoided costs.
Okay.
But the rates that are determined for Kentucky Power aren't necessarily the avoided cost rates for LG&E and KU.
Right, nor did I suggest that they were. Now, do you understand that Messrs. Robigo and Barnes have asserted the position that the inclusion of solar rooftop would actually improve the value for all customers rather than impose additional cost?
Again, that may be their testimony, but I believe Mr. Sinclair, Mr. Wolf, and Ms. Farland, and Mr. Seeley have all discussed the cost associated with net metering and the value associated with each of those components.
Okay, and are any of those folks testifying for free, or are they all being compensated either for their testimony or for their employment, which is the basis for their testimony?
They are all employees of the company or a hired consultant.
Okay, and so am I to understand then that because you feel that your purpose is noble, that we're supposed to credit everything that is a matter of opinion from the company witnesses, but we are to discount Mr. Robigo and Mr. Barnes and all of the studies they cited because you don't agree that solar has value that exceeds the cost?
Now, I'm not saying that we should discredit the joint interveners' witnesses. I'm just saying in here that our objective as a company is to ensure that we provide power and energy to all customers at the lowest reasonable cost. And that's what we've set out to do.
And you would agree that the commission, in establishing what is the lowest reasonable cost, considering the factors in the framework that was laid out in the Kentucky Power case, that they should base that on not on opinions, but rather on peer-reviewed studies, and studies either conducted, cost-benefit studies either conducted by the utility, who has the burden in this case, or those conducted by other public entities?
I believe it should be based upon all the facts that the company's presented and the cost associated with the studies that we've done for our system, not on a generic study from other states. It should be based upon our cost of providing service.
Okay, and where you have failed to conduct those studies, for example, Mr. Seeley indicated that you all have not studied jobs benefits. What is the commission to do? Are they to assign a default value, or can they look to other studies, to hard data, and to proxy studies?
Well, I disagree that we haven't supported the study. I mean, there are studies and analysis in the testimony of Mr. Sinclair throughout this case. There are studies and numbers and calculations in Mr. Wolf's testimony, and Ms. Farland's testimony, and in Mr. Seeley's. So we have presented evidence, many pieces of evidence in this proceeding about the costs associated with our system.
Okay, let me wrap this up. And I appreciate your clarification, Ms. Carver, because I was deeply offended by the suggestion that either my clients or their esteemed expert were in this to try to raise costs for ratepayers or to enrich themselves in some fashion as four nonprofits who are dedicated to the public interest and have been found to be so by the Internal Revenue Service. So I appreciate your clarification. Let me ask you this. Are you aware that Mr. Robigo, who you suggested would not support billing period netting if the value of rooftop solar exceeded the credit, in fact, has cited with support numerous studies in his testimony that show a net benefit to other consumers from rooftop solar?
He has cited many studies within his testimony, yes.
Okay, and you've not read those studies, is that correct?
No.
Okay, and I assume that you also haven't read the study that was done by the Department of Energy that indicated that the cost of net metering to non-participating customers was, in their words, negligible?
I'm not sure which study you're referring to.
Okay, well, I appreciate that. Okay, I have no further questions. Mr. Chairman, I appreciate your indulgence. Mr. Comer, I appreciate your clarification.
So it is 4 o'clock. Thank you, Mr. Fitzgerald. It's 4 o'clock. I think it may behoove us to take a 5-minute break and then try to sprint the best we can towards the end of the day. Does anybody have an objection to that? Ask him. No. Okay, we will take a break until 4:05. All right,
Give me a little minute to catch up.
just let us know.
You're on, Chairman.
All right, great. Ms. Vinsel, do you, we're back on the record in case number 2022, nope, 2020-00349 and 2020-00350. Ms. Vinsel, do you have any questions for Mr. Conroy?
Yes, I do. Thank you, Chairman. Good afternoon, Mr. Conroy.
Good afternoon.
I have a little housekeeping first that's really for Mr. Crosby. I want to confirm, is Ms. Saunders available to testify? I have a few questions that she sponsored.
She is.
Mr. Riggs is coming up, I see.
Okay.
Sorry.
Yes, thank you. Yes, Ms. Saunders is here. She's physically present. She's in the conference room behind this hearing room, and she's available to testify.
Okay.
Yeah, I approached the bench or the council table in response to your question about her questions, which would be on the account, closing the accounts and joint account liability.
Actually, Mr. Riggs, the questions are directly related to her responses to data requests.
Yes.
And simply wanting to make sure that the record is clear, understanding we'll have an informal conference, but there are a few things in the record we need to get clear today.
Right, and I'm certainly willing to present her on that. On that, I wanted to try to tie that up, though, because earlier this morning, we had discussed the idea of having an informal conference. I'm certainly willing to do that. The proposition was that if we held that, that the order on this might not be then issued until after the 10-month deadline. I have said I would have to consider that. I have considered that. I am not comfortable with that procedure. That we are certainly willing to meet here early next week at an informal conference. If that doesn't suit because of the commission's obligations and responsibilities, and we understand you have many, then we ought to just go ahead and approach the issue this evening.
Yeah, if that's the case, and the real reality is what sort of position it puts us in to have a robust record in which to make a decision by September the 24th on this issue. Plenty of time to consider it and have it briefed and get an outcome. And so, I don't think that, again, I don't think that we will have any problem granting the motion to have the informal conference. What our concern is foregoing, if Ms. Vinsel does have questions for the benefit of the record for Ms. Saunders on this issue, foregoing that opportunity and subsequent conversations, informal conference be less fruitful than initially anticipated.
Right, well, then I would suggest, Your Honor, let's go forward with that examination so that opportunity for the development of that record by the commission is not lost. But I will file the motion for the informal conference tomorrow and have an email to suggest scheduling availability next week to see if we can efficiently resolve that issue for the
That would be
commission.
fine.
All right, thank you.
Thank you.
Okay, thank you. Again, good afternoon, Mr. Conroy.
Good afternoon.
I'd like to follow up on several things that we discussed earlier. One thing that is new, this is an issue on rehearing. One of the issues raised on rehearing, for which we granted rehearing to clarify, has to do with reporting requirements. The staff will be issuing a post-hearing data request to ask for greater clarification on exactly which reporting requirements present an issue and a description of what components that LG and EKU believe create the issue. In order to move this along, we thought a post-hearing data request would be far more productive. So,
Yeah, and if I may, in general, there's no issues with the reporting requirements. Some of them ask.
Sorry about that, go ahead.
Are we back on?
Yes,
We
sir.
still on? Let me just ask anybody that's remote. Can they hear us?
Yes, we can hear you now.
All right, thank you, Ms. Cohn. Please proceed, Ms. Vinsel.
Yeah, sorry, and when they state file a report at the end of a quarter or end of 6-month period, very similar to the ECR quarter reports, where I think the original order said at the end of a quarter, and we had discussions where, hey, if it can be done 30 days after the end of the quarter, then we would have a full calendar quarter. That's that's the clarification that we had talked about. So we're more than happy to respond to data request on each of the individual ones that we were thinking about.
Okay, thank you very much, I appreciate that. I'd like to follow up on my question to Mr. Seeley regarding reconciling his testimony that LG&E KU did not need additional capacity and the RFP. And I'm not going to ask you to speak to as if you are Mr. Seeley. I do have an exhibit that staff would like to introduce. This is a press release issued by LG&E KU on January 7th, 2001. I've electronically sent a copy to all council.
Ms. Vincent, can I clarify for the record, 2001 or 2020?
2021.
Okay.
Thank you, that is a big difference. This paper copy came directly from LG&E KU's website. If I may, I would like to introduce this as Staff Exhibit 1.
That's fine. Staff Exhibit 1 or
Oh,
Staff Exhibit
7.
Okay.
I'm going to give you a moment to review it, Mr. Conroy.
Okay?
I'm going to offer up first a comment that I believe the headline to be misleading in the use of the term energy, and I want to clarify that. I'm going to read a couple things and tell me if this is correct. In the headline of this press release, it says, LG&E KU request bids for energy to continue to reliably serve customers. I believe that term of the use of the term energy is not reflecting what we would talk about with energy versus capacity. So I would like to read the first paragraph of the press release. Louisville Gas and Electric Company and Kentucky Utilities Company issued a request for proposal today for generation capacity to meet a potential energy shortfall being created by the expected retirements of Mill Creek Units 1 and 2 and E.W. Brown Unit 3 later this decade. Have I accurately read that into the record?
Yes.
And is it correct that Mill Creek Unit 1 has a capacity of 300 megawatts?
Approximately, yes.
And Mill Creek Unit 2 is just a little under 300, I think it's 297?
Yes, they're roughly the same size units, give or take a megawatt or two.
And the January 7th, 2021 RFP was introduced into this record on the April 28th hearing, April 28th, 2021. Just for the record to be clear, this was Joint Intervenors Exhibit Number 1. And again, for clarity's sake about that difference between energy and capacity, I'd like to read the subject line from the RFP. It says, subject, request for proposals to sell electric capacity and energy. And also in the first paragraph of the RFP, it indicates that LG&E and KU are looking for alternatives to provide least cost, long-term supply of capacity and energy to customers.
Mm-hmm.
So all of that is a long way around to say, is it, in issuing this RFP, is it in fact LG&E KU's intention to replace potential shortfalls with the retirements of Mill Creek 1 in 2024 and acknowledging additional retirements in 2028?
First of all, I mean, this RFP was issued for a number of reasons. And it was part of our normal ongoing planning process to ensure that we have the ability to reliably serve all customers. If you recall, back in 2020, there was an ECR planned case where the whole issue of Mill Creek 1, Mill Creek 2, and Brown came up. Given the time frame of when those units may retire and the lead time for construction, given the interest in our Green Power Option 3, given the IRP that's coming up this fall, this RFP was kind of issued to look at all the options and things that may come up for the company as part of our normal planning process. So it was a process that was consistent with how we plan our system. Given the lead times, given the things we were seeing, we wanted to go out to the marketplace and see what was available, and then evaluate from there and see where to go.
So are you saying, and again, I don't want to put words in your mouth. Are you saying that Mr. Seeley is correct that LG&E KU do not need any additional capacity until after 2028?
Well, I mean, both Mr. Seeley and Mr. Sinclair were talking about in their testimony about the need for capacity, the potential retirement in 2028. There's a lot of uncertainty on what environmental regulations may come to pass. We had a lengthy discussion on what is the economic life of these units and when's their book life. So there's uncertainty. There is a lead time to get capacity, and we don't want to be caught short in not having the ability to serve customers. So that's the intent of this RFP. Today, no, we don't need additional capacity. Will we need it in the future? Possibly so, depending on what happens. We do anticipate that there will be environmental regulations that will require the retirement of Mill Creek 2 and potentially Brown 3. But if we didn't go out for the market and find out what's there, we could be caught short with not having enough capacity. It doesn't mean that we have to act upon it just because we get responses. There are many things that we could do with the RFP, and I know Mr. Sinclair is going through the evaluation now on the economics.
Is it fair to say, though, that LG&E KU are making plans for the need for capacity in 2024?
We don't have a capacity need in 2024. If Mill Creek 1 retires, we still have sufficient capacity to maintain our reliability margins.
So this press release perhaps is not entirely correct, that the generation capacity was expected to meet a expected shortfall created by these retirements, including Mill Creek Unit 1?
It depends on the economics as well, as we've talked about here. If we get bids like the magical unit that was discussed earlier, obviously we'd want to act upon that as early as we possibly could. Again, there are uncertainties about environmental regulations that could require accelerated retirement for even Mill Creek 2.
Okay, I'm ready to move on.
Okay.
I would like to revisit my discussion with Mr. Seeley where I referenced, as I said, from my past career as a librarian, the For Dummies series. Again, I'm in no way, shape, or form saying that you are that. I would consider you more somebody who would write the book on it. So I will be very clear about that from the get-go. As staff reviewed the recommendation for the billing period, the netting process, we're trying to get some clarity. And I want to make sure that I'm understanding there's a difference between the measurement period, the netting period, and the billing cycle, and how they line up. And if I'm going astray, please feel to jump in and correct me.
Okay.
So as we said, there's I'm going to call it measurement. I don't think that's the correct word. Whenever for a net metering customer, energy is either consumed, goes through the meter, and conversely, if there's energy fed back out into the grid, that's instantaneous. Are we talking about measurement?
Yeah, let me see if I can simplify this. I know there's been numerous data requests in the case about scenarios and stuff. I'm going to try to stay away from scenarios. I think one of the questions the commission had in the 8th round, question 2 that we filed Friday, kind of addresses it. When you look at the statute for net metering, there's a meter that is capable of registering flow in both directions. So that essentially measures the amount of electrons. Think of it as you have 2 dials. When electrons flow to the customer, the dial spins. When electrons flow to the system, that dial spins. And that accumulates over a period of time. And at the end of that period of time, which is the billing cycle, then we would look at, okay, what does the dial say for when electrons flow to the customer? Whatever that megawatt hour is, the customer gets billed at the retail rate as if they consumed it. The other dial, whatever that register measures, they get compensated, priced at the compensation rate determined, in this case, as a credit on their bill. So their bill will be for the flow that went to them. It's no different than any other customer that pays for the energy that they consume. For the electrons that flowed back to the grid, they get a bill credit, dollar denominated, as a credit on their bill for that month. If that bill credit is greater than their bill, then their bill will be 0, and that credit carries forward to another time period. Does that, hopefully that
I was going to
simplifies
say,
it?
you did exactly what I needed you to do, and I appreciate that.
Okay.
I just have one last question. I think you already said this. I want to make sure I'm understanding that this netting period is in fact the billing cycle.
I'm not sure what you're meaning by netting period.
I mean, I know that we're talking about, the dollar value of essentially the energy produced that goes back to the grid, the dollar value of the energy consumed.
Yeah.
But when we look to net those two, we're looking at the billing period.
On a dollar denominated basis, yes.
I think I can move through a whole lot of questions
Okay,
now.
good.
I have another issue on rehearing regarding the TS2 pipeline suppliers demand component.
Yes.
As we said in rehearing, we recognized that we had included the wrong rate, that it was lower than had been approved prior to that. What we're trying to understand is what the amount, what over or under collection occurred, and also to ask for LG&E KU's thoughts on how it can be either credited to or charged to customers. So I'm going to walk through that. Again, if I'm not clear, please let me know.
Okay.
So I'm going to walk through this slowly, and I'm going to be very clear about it because I want to make sure I'm getting the rates right. As we know, in the June 30th order, we approved a rate. It was, I'm not going to the rate right now. It was lower than that one that had been approved on May 1st, correct?
I believe it was higher.
Yeah, it was higher.
Yes.
Thank you. Is it correct that because there was a subsequent case that as of August 1st established yet another new rate for the TS2 pipeline suppliers demand component?
Yes, and if you would like, I can walk through the process.
Well, can I ask this?
Okay.
Because I want to make sure that we get this right. Are we really talking about a period July 1st, July 31st, where there was an over and under collection? Or is it a longer period than that?
Well, we're really not talking about an over and under collection.
Okay.
In the rate case, there's nothing that addresses the pipeline supplier demand charge, so there are no cost. All of that is addressed in the GSC filing, and the commission's order approved a pipeline rate that was in effect May, June, and July. Those are the rates we billed. So in essence, we billed the correct GSC rate for the month of July,
Okay.
not the rate that was not even addressed throughout the entire rate case. And then we've had a subsequent GSC proceeding where the commission approved a new pipeline supplier demand rate to be effective August, September, and October. So in essence, there is no over and under recovery. There are 9 customers that were billed. We billed them at the approved GSC rate for pipeline demand rate for May, June, and July.
Okay.
And in the month of July, that billing was less than, the difference between what the number was in the rate case and what we actually billed was about $89.
I really don't want to ask a legal question here, but I don't know how to avoid it.
Okay.
In regards to the rehearing matter, are LG and EKU essentially asking the commission to nunk the June 30th order to reflect the rate that was approved for May, June, and July? And I don't really want you to answer that. Here's what I'm going to do. I like that Mr. Crosby is looking.
Can I ask a question?
Yes.
Is there a way that the commission can enter a subsequent order and fix the problem indicated by the companies?
May I?
Is there a rate that can be implemented that fixes the problem that the company claims is there?
And I'll let, if I may, Mr. Chairman, and I'll let Mr. Conroy correct me if I get this part wrong. We are currently billing the correct rates because of the GSC proceeding. So there's no.
For the month of August.
Going forward.
Going forward, it's a non-issue.
So what has happened with respect to the difference between, I guess, what the order text had and what the companies actually billed, it was about a $90 detriment to the companies. It was a net under collection. Is that correct?
Well, let me just clarify. We billed the correct rate that was included in the GSC filing and approved by the commission in April for May, June, and July.
So the question I have is, so then you're saying correct in the mathematical sense, not necessarily the rate that was in the commission's June 30 order?
That is correct.
Sorry, Ms. Benson.
No, that gets to the heart of what the issue is then. Okay, I think I know where we need to go. So there was no over or under collection.
There was no math.
Oh, no, I'm sorry. Nope. I can use all the help I can get. I will move on from this issue because
We're okay.
we're okay.
I think we're okay.
I'm trying to circle around a couple things before we get to the joint account issue. In your supplemental testimony, I spoke to Mr. Sinclair about this yesterday. He had calculated new SQF and LQF rates. And in your supplemental testimony, you presented tariffs for that. Are you asking for the application to be amended to reflect these new tariffs?
No, we are not. We filed our original SQF and LQF tariffs in the November application. We still believe those are a methodology that is appropriate and been in place for 20-plus years, and has served all of our customers well. Throughout this proceeding, there was a lot of questions raised about methodology and the calculation of avoided cost. Mr. Sinclair looked at other methodologies and proposed a methodology. That methodology is still consistent with how we've always done SQF. It is an avoided cost rate based upon production cost models. He refined that methodology to put forth before this commission to address a number of the questions that have been raised. Within my testimony, we filed exhibits to my testimony that should the commission go down the path of adopting a different methodology, and Mr. Sinclair's proposal was a methodology, and we developed tariff rates, exhibits, illustrative of what those tariffs would look like if the commission were to adopt that methodology. But no, we've not asked for new tariffs in the application to restart anything.
Okay. Okay, thank you. That cleared up another issue.
Okay?
Okay, let's go to the joint account issue. Just as a threshold issue, is there a copy of LG&E and KU's, I'm going to call it paper application on file in this case?
You're talking about an application for service?
I'm sorry, let me be clear. An application for new residential customer service.
I'm not sure if there is a paper copy in the record.
Okay.
I think there are many ways in which customers can sign up for service through electronic means, over the phone. I assume they can come into the business office, and yes, I would assume that there is a paper application.
So what we'll ask for in a post-hearing data request are copies, whether in paper format or electronic, of both LG&E and KU's for residential customers, new service.
Okay.
I'd note that, without going too far into evidence not in record yet, if I look at the online option to start service with LG&E or KU, what's listed is a primary account holder. There's no option for a joint account. Are you familiar with that?
Not directly, no.
Would Ms. Saunders be the better person to talk to?
She would. And I know there are many ways to set up your account with, as we mentioned in the record, there are joint accounts, there are contact-only names throughout the, I don't know the process in detail on that.
I ask because when I look online, there is no way to set up a joint account. There is a way to set up an authorized party, and that's the term used.
Mm-hmm.
But there's still a sense that there is one person who's the primary account holder. So I will, and this may be better for Ms. Saunders, I'm new to town, I'm filling that out. How am I going to know that in the case of my husband and I, we want a joint account, and it appears to me I can't establish one? How will I know the implication for service from LG&E or KU based on what information I can glean from that online application?
I mean, there are a lot of scenarios that could be set up, whether it's specific online. I can't answer that.
Okay.
I know in correspondence with the customer service reps, I think there's questions that are asked. I've been through the same setup for myself when I moved, as well as our daughter here in Lexington. So there are various ways. Your specific question, I can't really answer.
I'll ask Ms. Saunders.
Okay.
I have exactly 2 more questions for you.
Okay.
Now, in your supplemental testimony, you reference the commission regulation that limits a QF's right to sell power in periods when the purchases from the QF would result in a cost greater than those that LG&E or KU would incur if it generated an equivalent amount of energy. And I'm referring, in your supplemental testimony, it's page 2, lines 19 through 22.
Yes.
So my first question is, in regard to whether the QF price is above the cost to LG&E and KU to generate, what is the benchmark for that determination? And I'm just going to throw my second question in first. How does that benchmark align with LG&E and KU's fuel adjustment clause, FAC determination regarding economic or non-economic power, in which the benchmark is LG&E KU's highest cost unit calculation?
Let me go back to the first. Can you state the first question again?
Okay. It is essentially, what is the benchmark that LG&E and KU use to determine whether the cost to purchase from a QF is higher than what LG&E or KU could generate or would generate?
Okay. First of all, I would say we've never had to address this issue because the level of QFs and the LQF and SQF tariffs we've had in place for many years is essentially our avoided cost of generation. The LQF is tied to our actual cost of generation. So we've never had a situation where the QF pricing is above our avoided cost. I would speculate that we would use a similar process to looking at our AFB process and our fuel adjustment clause process. Very similar to the lengthy discussions we had in the Roods Creek proceeding on the economics of whether buying power from a solar facility at 2.7 cents was going to displace lower cost generation. That was a significant concern of this commission and the Attorney General in that proceeding. So 2.7 cents was on average in line with our fuel cost. And in that case, the REC prices would have even lowered that price. So we got to the conclusion that it was going to be economic under the FAC. I would speculate if we ever get to a point where we have QF rates that are significantly above our variable cost of generation, that's when we would probably implement this type of provision within the QF regulation. Again, we haven't been to that point, but I know there's a lot of numbers presented in this case for QF rates that are well in excess of what we could generate it for or buy it from Roods Creek. So that is a concern going forward if those rates get to a point where they're significantly higher than 3 cents. Second part of that was about the highest cost unit method.
Yes.
I'm not saying that's what we would use. It could be used. That's kind of where we ended up in the Roods Creek proceeding. That may be a benchmark, or it could be our highest cost unit through our fuel adjustment clause as well.
If you'll excuse me, I need to look and make sure the team doesn't have any more questions.
Okay?
Staff has no further questions.
Vice Chair?
No questions.
So I'd like to pick up where Ms. Bensel left off.
Okay?
So, company's highest cost unit in a month, variable cost of energy is 10 cents. Great. Anything less than 10 cents, this is under the FAC, the orders from 2002. Anything less than 10 cents is by definition, if the company goes out, buys it from the PJM South, we've heard about this South Node, or from TVA, or wheel it in from, I don't know, Missouri, right? If it's less than 10 cents, by definition, it's economic. Is that your understanding?
The 10 cents is not set in stone. Our highest cost unit for each company can change. Right now, I believe the highest cost unit for KU is probably around 6 cents. And for LG&E, it's close to 4.5 cents. I would expect that number to continue to decline as our highest cost units retire. But in general, if a purchase price is less than our highest cost unit that's available for that month, then it's deemed to be economic.
Right, so that's the determining factor, made up 10 cents. But as long as it's less than the highest cost, the variable cost of energy from the highest cost unit available to that utility in that month, all purchases are deemed to be economic if it's under that threshold. Is that
That's
correct?
correct.
Okay. So, I get that it may not have come up yet, because that's what it said, it's the first thing. But, Rouge Creek is 27.5 cents, or
2.78 cents.
Sorry, yeah, 2.7 cents a kilowatt hour. And I think Mr. Sinclair, you'll have to bear with me here, because I think we do have this in the record. And I hate to talk about something in the abstract when we have it in the record. Can I ask Mr. Lovekamp to bring up, I think it's Mr. Golly, I think it's Mr. Seeley's testimony at 25.
And, Mr. Chairman, which piece of testimony? Sorry.
Good question.
Yeah.
Mr. Seeley's supplemental rebuttal testimony.
Supplemental, thank you.
I think it's Mr. Seeley's portion, just based off the. And I'll wait for Mr. Lovekamp to bring it up, but I'll actually share for the benefit of everybody else.
Was there a specific page?
I think page 25.
25, okay.
I said rebuttal, didn't I?
You did, yes, sir.
Okay. So it's, what is Seeley here? This is the Seeley supplemental rebuttal. I'll go down to page 25 of that. There we go. Do you see the screen now? And I'll zoom in for your benefit.
Yes.
The question is, for the 12 months ended December 31st, 2020, how did the company's actual marginal energy prices compare to the prices at the LG&E PJM interface? Do you see that?
Yes.
Okay, and so it says the answer is the company's average hourly marginal energy price was $18.02 per megawatt hour during 2020. And that the average hourly price at the LG&E PJM interface was $20.30 during 2020. Is that what it says?
That's what it says.
Okay, so Rouge Creek is 2.7 cents a kilowatt hour. Would that be equivalent then for $18.02 per megawatt hour? Is that equivalent to 1.8 cents?
Yeah, $18 is 1.8 cents, but let me clarify, the Roots
ahead.
Creek, energy price is 2.7, but we also get the RECs.
Right,
And
net of
we
whatever
intend
the
to
RECs
sell the RECs, that will reduce the energy price.
That's absolutely right. It may be $7, it may be $5, it may be $17 someday.
Absolutely.
Right, but that's a market price for the regs, but the purchase price that the companies are under, you get the energy, the recs, and you pay you pay $27 or 2.7 cents and change. Is that right
Yes,
for kilowatt hour?
fixed price for 20 years.
Right, and there's a minimum and a maximum of energy that I provide, lots of other terms, but that's at a very high level, that's the economics of it. Okay. So the FAC says as long as that's under, and the commission's orders, say as long as that's under that highest unit cost calculation, it's economic for recovery through the fuel adjustment clause. Is that your understanding?
Yes.
Okay. So per the regulation, you discussed the regulation 807 KAR 5054, I don't know which subsection, but I think you have it near you or somewhere close. You discuss it in your testimony about this, you lose the obligation to pay, right? Or the obligation ceases or something like that. Is that correct?
That's correct.
Okay. And so I guess my question is, and maybe it's just to the point you said earlier, you just haven't dealt with it yet. Does the company have a position as to whether or not it is a determination of once it becomes not economic to purchase from that QF, that's when it ceases? Or when it hits your hourly or 15-minute or one-day trailing or 1 month trailing marginal energy price?
I guess first of all, and so his determination of the marginal energy cost, I'm not sure how that was calculated.
Okay.
So the I'm not sure about the 1.8 cents. I do know our average FAC has been around 2.3, 2.4 cents for fuel costs through the FAC. And I don't have a sense or commitment on how we would determine once we reach or once we get to an avoided cost comparison with a QF. We've not had pricing for QFs that were that significant. So we haven't really considered it. It is a concern that if we're obligated to buy power at a significantly higher price than our avoided cost, that could be detrimental to customers.
Right, but let's take a step back. Let's say the commission just enters an order tomorrow setting the avoided energy cost for QFs at the all-in price for Rouge Creek, 22.7 cents.
Mm-hmm.
That's in excess of your entire 2020 year's marginal energy price per Mr. Seeley. So does that run afoul of the regulation provision that you were discussing in your testimony?
Again, I'm not sure how the 1.8 cent marginal energy cost was calculated. Again, we have not looked at how would we determine when the QF pricing is greater than our average avoided energy cost.
Well, no, but even what you just said is that even for your FAC purposes, the Rouge Creek is higher than your ordinary FAC filing. So forget that $18.02 that Mr. Seeley talks about. It's higher than what you're filing each quarter.
It's a monthly filing, and again, the sale of RECs will reduce the cost of the Rouge Creek through the FAC. So it could likely be lower than.
It can, but what I'm saying is you're proposing that 2.7 cents Rouge Creek price, if that is the QF avoided energy rate, right? Those won't have RECs, correct? Not that the company is able to get and sell. Is that your understanding? If it's a QF?
If it's QF, that's correct, yeah.
Okay, so that would be at this Rouge Creek price, which is in excess of what Mr. Seeley says the 2020 price was, and what you're saying the FACs ordinarily are, yet you're also pointing to a provision in the tariff or in the regulation that says that our obligation to purchase it ends when it's no longer, and there's a technical term in there, and I apologize that I don't have it in front of me, but there's a point in which we no longer have to purchase this. And so I guess I'm kind of asking, has the company looked at whether its own proposal would then immediately turn around for a QF and make it so that even though you're paying an avoided cost, that avoided cost is at the time of implementation going to run afoul of this regulation, and then the company comes back in and says, well, never mind, we don't actually have an obligation to pay that because the regulation says we don't have to.
Well, I would say our avoided QF proposal in the case is what we filed back in November. That's what we believe should still be in place. And those voided costs for SQF are in the 2.2, 2.3 cents. LQF is based upon the average cost over generation. So that's what we've filed in the case. These alternatives have different scenarios that are set up, and I do not believe, based upon what Mr. Sinclair had put forth, on an as-available basis, it's in the 2.2, 2.3 cents, which is consistent with our previous filing.
Yeah, and I guess
as options.
So let's go with your 2.3, right? The as-filed position, whatever that is, but we'll just assume for a second it's 2.3, right? That's it. And then a QF comes in, starts producing electricity in October, in a shoulder month, and for the entire month that it shows up October 1st, we're ready to give you as available energy, right? And it's at your set of avoided costs that the commission has approved. Is it your testimony that if the company's the cost in which the company would generate the equivalent amount of energy is lower than that, even that avoided cost rate that entity would get, that QF would get, that is it your testimony in this section of your testimony that you would then curtail that entity?
I don't think it would be reasonable to look at it on an hour-by-hour basis.
Okay.
As we've talked about in the past with the fuel adjustment clause, with the AFB process that we have. It would be reasonable to look at it over an annual period. What is our annual cost? So, again, we have not hit that scenario. We haven't factored through all the nuances associated with what it would truly mean. My testimony was just pointing out that there are provisions within that, that if our QF rates are set at higher than our avoided cost, it raises concerns for us.
Okay, so let me take a step back.
Yeah.
You were more bringing it to the commission's attention that this regulation exists and that a rate that, we'll just say, wildly exceeds anything, even the highest unit that the companies have had for the X number of years, just a heads up, if you set it at that rate, this regulation exists. Is that, I don't want to characterize.
Yes, in essence, that's kind of what Mr. Sinclair was saying as their rebuttal testimony. If you set the prices at a rate that, even though under LQF, the rates that are set in the tariff are only a proxy for negotiations. That's going to set an expectation from a QF. And as you mentioned, for a qualifying facility under 80 megawatts.
Okay.
And as you mentioned yesterday, businesses are going to take into economics. And if a rate is set at a price that is that much higher than what you can buy for in the market, from a business standpoint, we will see a lot of QFs in our service territory, and that will only drive up the price for all customers. That was the point with these.
And I could ask, if Mr. Lovecamp has, I have another question about Mr. Seeley's supplemental rebuttal testimony. The reality is, I could have asked Mr. Seeley this question, but he would have said, Mr. Connor was the person to ask about this. So, on page 24 of Mr. Seeley's supplemental rebuttal testimony,
Okay, 24.
24, and I'm trying to, well, I'm on a new tab here, so I'll stop sharing. Let's see, it goes from 23 to 24. So at the bottom of 23, do you see it, the sentence starting, the companies will make?
Yes.
Okay, so the sentence says, the companies will make economic purchases on the interface only, and this is the, I think this is going back to that PJM interface or interfaces with other utilities, on the interface only when the price at the interface is lower than the company's marginal running cost, which is rare. So that marginal running cost, however Mr. Seeley may define it, is probably different than that highest unit cost calculation. So is Mr. Seeley necessarily in a position to speak for the company on this issue, or is the company's position still that the FAC rules dictate what is or isn't economic, and the company understands those rules and will act, do whatever it decides to do?
I would say that under what he's talking about here is more real-time dispatch decision-making from our dispatch desk. So they're going to look at what units are online and the marginal cost of the generation, and can they buy it in the marketplace at that interface at a price less than the units are on. So it's more of a real-time decision-making that Mr. Sinclair actually operates under. So it really doesn't, I don't think it's apples to apples.
What I want to make sure of is that he's not saying that the company has changed the way it looks at off-system purchases.
No, he is not. No, I mean, it is a real-time dispatch decision process, and if in the hourly market they can make a purchase at a lower cost than under the scenario with what's online, that they will likely do so within a margin.
And that the company's position is not that the economic purchases are by definition lower than the company's marginal running costs?
No.
Okay. Okay, you still have the, I think it is 054, so we were talking about 05462 earlier, about the, the obligation for the companies falling away. The next section, I think, is 054 section 7, factors affecting rates for purchase for all QFs. Do you have that?
Yes.
Okay, perfect. So, so in your supplemental testimony, I have a quote down. It's your supplemental testimony at page 2, line 8, that talking about this regulation, quote, addresses itself only to avoided electric energy and generating capacity costs, not to other potentially avoided costs. You remember that?
I believe so.
So the regulation here, and specifically down towards 7 and then sub 5, specifically speaks to a couple of other things. Like one, it talks about a reduction of fossil fuel use, I think in 5 sub 6. Do you see that?
Part B, ability of the electric utility to avoid costs due to deferral, cancellation, and downsizing of capacity additions and reduction of fossil fuel use.
That's right. That's right. Does what you just read in your estimation, in your position, for 7.5 sub B there, is that taken into account in totality in the company's proposal for avoided energy and avoided capacity costs?
I believe so, under the methodologies that we've historically used, as well as under the methodology Mr. Sinclair put forth. It looks at the production cost models of our system and how the units are going to function and operate, and whether we have a need for capacity, which addresses the deferral, cancellation, downsizing of capacity and additions. I think those are factored into kind of the methodology for determining avoided cost rates, avoided energy, and avoided generation capacity costs.
Okay.
Now, where I think this section comes into play is if you have an LQF, large qualifying facility, where it's actually a negotiation and discussion based upon all the operating parameters of that type of QF. I know you've had some discussion with I think Mr. Kurtz did, with Mr. Seeley on what types of units are QFs. And when you get into a QF, you've got all kinds of, more than just solar, you've got wind, you've got other types of generation that may have different operating parameters. All of those can be taken into consideration when negotiating and setting the rate for an LQF.
Okay. The regulation in the very next section, after B, for C, discusses line losses. Do you see that? I think it's 5054, section 7, sub 5, C. I think is what it is. No, I'm wrong.
Yes.
Section 7, sub 5, C.
Sub C, savings or costs resulting from line losses that would not have existed in the absence of purchases from a quality facility.
Okay, so going back to your quote from your direct, only avoided energy, avoided capacity. Do the companies believe that they've appropriately included line losses that would not have existed in the absence of purchases from QFs in their initial proposal?
When you say initial proposal, are you saying what's in?
What is in front of the commission in the tariffs?
I would have to go back and look at that, but I believe so. I know we've answered some data request on the methodology that has been used over the last 20 years. I can't recall whether specific line losses are discussed in that or not.
And I don't, some of these questions may have been better for Mr. Sinclair, but I only ask you because you're the one that specifically discussed. Otherwise it's gonna be an objection. So I gotta ask the person who talked about the regulation. Okay. My last question is on netting. Last set of questions is on netting.
Did you say last question or last
set of questions. Last set of questions. Doesn't really matter. Like Mr. Kurtz's question there. It doesn't really. Can't hold me to it. So. Have you read the final? So there's a couple of orders, lots of orders in all these cases. The Kentucky Power case. There's the initial final order on the rates, right? Then there's a subsequent final order on the net metering, and I think even some of the SQF, LQF rates. And then there was rehearing was sought on the net metering rates, and then there was an order denying the rehearing. Have you read the order that was put out in June denying the rehearing?
I've at some point have read through those orders.
Okay.
And many other orders.
And the reason I ask is this, Mr. Conrad. There's a part of that order that specifically discusses the commission's position on what the law requires as to the netting under net metering.
Yes,
And you've read that portion.
yes, I've read through that order.
Okay. And are you aware, even at a very high level, of any differences between what the company's proposal for netting is in this case versus what the commission clarified in that June order in 2020-174?
Without having that order in front of me, I know Kentucky Power's original proposal was different than the company's because of the way they metered their customers. We have meters that measure flow in both directions.
Okay. And at least Kentucky Power initially proposed 2 netting periods. Do you remember that?
I do, because of the fact that they didn't have meters, and that was the only way they could implement a netting.
Okay. So, so here's a copy of that order at page 14. And we'll just walk through this so that we're sort of on level, we both understand what it says, so we can discuss how it compares and contrasts to what the company's proposal is. So first, Kentucky Power does recover costs to serve all residential customers, including NMS2, which is the same as your all's NEM2. It's a successor to net metering, traditional net metering. NMS2 residential customers through the residential customer charge. In fact, as of January 15, 2021, because the commission approved a 25% increase in the customer charge from $14 to $17.50, fixed cost recovery through a fixed amount increased. As a result, a larger portion of fixed costs are recovered through the customer charge rather than through the energy charge for all customers, including NMS2 customers. Second, the commission expressly rejected Kentucky Power's cost of service methodology for overstating certain costs and never made a finding of fact that the average cost to serve residential customers is $35. We acknowledge that Kentucky Power filed testimony that the cost to serve residential customers was $38.31 using a minimum system method, or $35 using a marginal cost study. However, merely filing testimony into the record does not mean that the utility met its burden of proof. Here, the commission expressed concerns that Kentucky Power's cost of service methodology, quote, produces a larger customer component, end quote, and require Kentucky Power to file a zero-intercept cost of service study in its next base rate case because the commission has greater confidence in the results of a zero-intercept study. So it's not just Mr. Seeley's zero-intercept study, commission. Appreciate it. Third, Kentucky Power misapplied KRS 278-465 and KRS 278-466 in its sample calculations and included the customer charge in the netting calculation so that the residential customer charge and energy charge are both netted against energy exported. KRS 278-465 sub 4 states that, this is the statute, net metering means the difference between the A, dollar value of all electricity generated by an eligible customer generator that is fed back to the electric grid over a billing period and priced as prescribed in KRS 278-466, and B, the dollar value of all electricity consumed by the eligible customer generator over the same billing period and priced using the applicable tariff of the retail electric supplier. And the commission added that little emphasis. The legislature doesn't do both. Because the energy charge, but not the customer charge, is based upon electricity consumed, only the energy charge, along with any riders that are based on a per kWh charge, should be netted against energy exported pursuant to KRS, and we're going to have to do a knock on this, 278-465-4. Thus, Kentucky Power overstated the impact of the export value on the total customer bill in netting examples. Because Kentucky Power will recover the entirety of the fixed customer charge from each customer, an amount determined by the commission to be reflective of the fixed customer-related expenses, Kentucky Power did not meet its burden of proof and is incorrect as to any assertions regarding a purported $35 cost to serve NMS2 customers. So my question is the company's proposal regarding the implementation of this all electricity consumed and all electricity fed back consistent with this order?
I mean, I can't speak to all the nuances in the Kentucky Power order. I know this was on rehearing. I know Kentucky Power made a lot of different arguments on the cost to serve. And I can't speak to whether our interpretation meets everything that's in there. I can speak to how we interpret the net metering statute. And as I explained to Ms. Vinsel, the definition of net metering is a dollar-denominated difference. There, in the other section, it talks about meters measuring flow in both directions. We can measure flow in both directions in accordance to that. The dollar-denominated bill credit is applied to the bill. There's nothing in the statute that says anything about customer charge. I'm just reading through this, and that's how it reads to me and how it applies. As I explained it to Ms. Vinsel, the meters are going to measure the flow in both directions. The dollar-denominated bill credit is whatever the compensation rate determined in this case, multiplied times the energy, and that's the dollar-denominated credit. The customer's bill, they're going to be billed at the standard retail rates for all the energy they consumed.
Okay, so a couple of questions.
Okay.
You have some billing line items that are based on the amount of electricity consumed for the residential and commercial classes, correct?
Yes.
Okay, so is like school tax, is that based off the KWH?
School tax, I believe, is a percentage.
Percentage of total bill?
Yes.
That's a great, okay, we'll start with percentage of total bill, right? So, somebody uses somebody's a net metering customer, right? They use 500 kW. That 500 kW is charged at the retail rate that's in the tariff, correct?
Yes.
Okay. They also, throughout the month, used, forget how much they actually used, but it's a bill credit worth $300, okay? Just $300.
Yep.
So is the company proposing to then apply that 500 kWh to all of the riders in which are based off of KWH?
The way the company reads it is, and what we stated, the customer, net metering customer actually plays two roles. They are a customer that is being served under a standard rate. For all of the energy that they consume, that flows through the meter to them, they're going to be billed on that standard rate. If it's a residential customer, they're going to be billed the customer charge, they're going to be billed the energy charge, whatever riders for that energy that they consume. So that's one portion of their bill. Under net metering, for all the kilowatt hours that flows back to the company, they're going to be compensated at the rate determined for NMS2. That's another component of their bill. You sum the two, and if it's negative, then their bill is zero. And that credit would carry forward to, that's the way I read through, and that's how we propose to implement.
Okay, but what I'm asking is, before you sum the two, right, are you calculating the either percentage of bill, or you wouldn't do the percentage of bill, are you calculating the riders in which are based off of usage?
Yes, for all the energy that they consume as a customer over the billing period.
So can I be just, maybe an important nuance, all the energy they consume, all the energy they purchase from the company?
Yes.
Okay.
Again, we go back to the meter example with the dials.
Yeah.
So one dial that registers what flows from the company to the customer. Forget about their own generation. Whatever flows from the company to the customer, we will bill them at the standard rate that they're on.
So we have other line items that are fixed amounts based off usage, percentage of riders, right? Mm-hmm. And for any classes that can do net metering, are there any demand related other billing items that are based on demand? Or is everything those three?
I think everything, all of our riders are either a percentage or a per kilowatt hour or a dollar amount.
Okay, all right. So the fixed amounts are the fixed amounts. The KWH ones are based off of the KWH purchased from the company during that billing cycle, over the period of that billing cycle. And the percentage of revenue ones are based off of what?
They, subject to check, they will be billed based upon the net metering customer as a customer being served under the standard rate.
Okay, so just so that I'm clear, you say we're gonna come up with your bill based off what you bought from us. You come up with the bill. And then after that is completely done, then you go over and you take the KWH they sold you times the rate that the commission set for that compensation, and then you sum that versus what their bill would otherwise be from that first part of the calculation.
Yes, that is the way we've interpreted what the statute requires.
Okay, and that would be done once a billing cycle. It'd be done, assuming about 12 times a year, approximately every month, as a bill is ordinarily done today.
That's correct.
Okay, and that's when the accumulation of those credits is determined. That's the frequency in which those accumulation of credits over a time period are determined. The same time the meter is read for billing purposes.
Yes.
Okay, all right. I really appreciate it, Mr. Conrad.
Okay.
Thank you. Those are all the questions I have. Do you have any redirect, Mr. Crosby?
Mr. Chairman, we do not.
Okay. So, just very quickly, Mr. Kurtz, you have no more questions?
question.
Okay. Mr. Cook, Mr. Horn, any questions?
No questions.
Any more questions, Mr. Spinard? Mr. Miller still with us? Maybe Mr. Childers took over. Mr. Miller, do you have any questions?
None, thank you. I'm still here, none, thank you.
Okay. Mr. Fitzgerald?
Nothing further. Thank you, Chair.
Ms. Vincel?
Nothing further.
Vice Chair? All right. Thank you very much, Mr. Conrad.
Thank you. May I be excused?
Yes. You may be excused. As I understand it, Mr. Crosby, you have no further witness, is that correct?
We have one further witness.
Oh, Ms. Saunders, that's right. Will you
Yes.
please call your next witness?
Yes, Mr. Chairman, we would call Eileen Saunders.
Let me take care of this first.
Yep, after the requisite procedure.
Oh, actually, I do have one more question, Mr. Conroy, or one, I do apologize. Do you have a minute?
You just got recalled.
I sincerely do, and I apologize.
Okay.
I do have an issue on rehearing that I forgot to bring up, and I have it in my notes here.
Okay.
The notification for rehearing.
Yes.
Okay, so have you dealt before with 278, 192, I think sub 2, which is the emergency rate procedures? Have you dealt with that before in your
I
time?
can't see I have.
Okay, so what do you know about the emergency rate procedures under Chapter 278, your experience?
I have not read that.
Okay, that's fine. So I'll just bring it up for a quick second. You've done plenty of, I think it's 192, no, not 192, I'm sorry, the emergency rate relief under, Ms. Vincel, I can't remember the section of the statute now. Do you remember what
I know what you're talking about. I can find it. I can quickly.
I apologize, Mr. Connery. I'm trying to limit the amount of discovery we have to conduct on this issue, and you may be able to help.
I'm going to double check. I believe it's KRS 278.190, subpart 2.
190 subpart 2. Bear with me, Mr. Conroy.
Mr. Chairman, I'm not sure this
There we
is
go.
what you found what you're looking for.
278, 192, 190
One,
sub 2.
yes, sub 2.
Okay. All right, I will bring this up for your benefit.
Oh,
There we go. So this is 278, 190, procedure when new schedule of rates filed, suspension of new rate schedule, burden of proof refund. I think 192 was the forecasted test year statute. So you're familiar generally with the statute from your,
Yeah, for filing application for a change in rates, yes.
okay. And you're aware of the settlement provision or stipulation provision regarding the, the stay out, we'll call it, the 4-year stay out from these rate cases, correct?
Correct.
Okay. And so I just want to use for the purpose of this discussion and maybe clarification, this sub 2 is the portion that allows, the first part is at least the portion that allows the commission to suspend a historic, an ordinary tariff for 5 months and a forecasted tariff for 6 months. Is that your understanding?
Yes.
Okay. All right. And this is the section that the stipulation cites for, a 4-year stay out subject to needing emergency rate relief. This is the section that's cited, correct?
Yes.
Okay. And so I'm just curious from the company's perspective, what's the process that, forget the commission's order, think about when you walked away from the day that the stipulation was filed, your all's process around if something should happen between now and the 4-year stay out, that the company would envision, the process it would go through in filing an emergency rate relief.
And I would say our process wouldn't be any different than we would follow when we file an application for a change in rates. We would give the commission 30 days notice, and then we'd file our application and all of our testimony and supporting information for that change in rate.
Okay, and just like, I think you can see it, but 1, 2, 3, 4, 5, 6. 6 from the bottom, there's a sentence that starts in the very middle, provided. Do you see that? I can zoom in. I don't want you to strain. You see it, and I'll even highlight provided.
Provided, however,
Yeah, so the sentence says, provided, however, if the commission at any time during the suspension period finds that the company's credit or operations will be materially impaired or damaged by the failure to permit the rates to become effective during the period, the commission may, after any hearing or hearings, permit all or a portion of the rates to become effective under terms and conditions as the commission may, by order, prescribe. Do you see that?
I do.
Okay, so under your scenario, the companies believe that immediate or emergency or whatever term is used in the stipulation, rate increase is necessary, right? That's what the stipulation says. Like, we need to have the rate increase, we're gonna file, it's not 4 years yet. And what you're saying is, basically just go through and file this as an ordinary rate case, because this is 190, we have to file it as an ordinary rate case. And the determination of whether it's emergency or not, or gets put into effect, is made here by the commission, right?
Okay, I have not looked at this, so I'm not sure I can respond to you
Well, let me,
on this. And it may be better to have a data request.
it may be, but I'll do my best to bring in my vice chairman Cicero just for a minute to sort of explain something, or give my perspective.
Okay.
That this just sets up filing a rate case. The determination as to whether the company's credit or operations will be materially impaired or damaged by the failure of letting the rates go into effect subject to refund while the rate case is pending is a commission determination. Right?
Correct, yeah.
So if, let's just make up a hypothetical here, the commission companies file this rate case and the commission doesn't think that the rates need to go into effect immediately subject to refund, but instead the rest of the period goes through, effectively the company just filed a rate case, right?
Yes.
Okay. And if that happens before 4 years, they just filed a rate case before 4 years, right?
Yes.
Okay. And
And I
so,
think, if I may,
please.
I think what we were seeking clarification on was if we had to give 30 days notice and then ask the commission to determine whether we can file a case, and then subsequently file a case. That's what we were looking for clarification on.
And I think it was, I took your petition as being asking whether it was one of two things. Either 30 days notice or 30 days ahead of time, ask, can we file the case?
Yes.
Or the ordinary 30-day notice before filing a case.
Yeah, 30 days notice is not an issue. We would normally give that regardless.
And that was,
Yes.
I guess, where I'm coming at with the petition for clarification. You're effectively asking, do we have to take an additional step to request to file the rate case? Or are you all just saying we follow the ordinary procedure
Yes.
under 190?
That's the
Except
clarification.
Technically, you all can ask for 20 days, but the ordinary 30-day notice. So you all are just asking clarification whether, in order to do this before 4 years, whether you should just follow the ordinary procedure like it's an ordinary rate case, or ask permission to file the rate case prior to 4 years.
Yes.
Thank you.
That's the clarification.
That's, I think that makes our job a little easier now.
Okay.
Okay. Thank you. You can be.
Can be
excused. I
excused.
appreciate it. Unless Mr. Crosby has any redirect on that issue.
No.
You can be
Thank you.
excused.
Now, Mr. Chairman, we would call Eileen Saunders.
Good evening, Ms. Saunders. When you get a second, please raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
I do.
Okay, please have a seat.
Thank you.
State your name and address for the record.
Eileen Saunders, 220 West Main Street, Louisville, Kentucky.
Thank you,
I was
Mr.
going to say
Chairman.
Mr. Riggs, but Mr. Crosby may ask.
Good evening, Ms. Saunders.
Hello.
By whom are you employed and in what capacity, please?
Louisville Gas and Electric and Kentucky Utilities. I'm the Vice President of Customer Services.
Okay. And did you cause to be prepared and filed in this proceeding written direct and rebuttal testimony, though no supplemental testimony of any kind?
That's correct.
Okay. And are you the sponsor of certain data requests answered by the companies in these cases?
I am.
Okay. Do you have any corrections or updates to your testimony or responses to data requests?
I do.
Okay. And would you clarify what those might be, please?
This would just be to PSC 7, question number 2.
Okay. And can you provide a brief description of what the corrections are?
Yes, specifically to the answers to A in that question and the answer to B. We answered in a manner that was absolute, and I would change must submit a new application for service under A to typically would submit a new application for service. and I would change B to typically an account would still be closed, et cetera.
Thank you, Ms. Saunders. With those clarifications, do you adopt your pre-filed testimony and responses to data requests as your testimony today?
I do.
Okay. And just for the record, would you please let the commission know what you have available to you today at the witness stand, please?
Sure. Other than what Mr. Lovecamp has, I just have my own copy of my answers for each of the questions that I responded to.
Okay, thank you very much. The witness is available for cross-examination.
All right, thank you, Mr. Crosby. Probably shouldn't, but does anybody, Mr. Spinard, do you have any questions for Ms. Saunders?
No, Mr. Chairman.
Mr. Warren? Mr. Cook?
No questions, Chairman.
Mr. Kurtz? No questions. Mr. Fitzgerald?
No questions, Your Honor. Thank you.
Mr. Miller?
None, thank you.
Ms. Vincent, you may ask a question, Ms. Saunders.
Thank you very much. Good evening, Ms. Saunders.
Good evening.
Do you have a copy of your response to staff's seventh request, item 2?
Yes, I do.
I'd like to ask you about the very first sentence in there, which I will just read out loud for everyone who doesn't have a copy handy. The answer says, all adults living in a residence are supposed to be included on an application for service to have an account with the company. Is there a requirement anywhere in the tariffs for an application to include all adults who reside at a residence?
I would have to look at the tariff specifically to see if that verbiage is in there. Our intent for having that is to make sure that we have a connection to anyone who has financial responsibility for paying the bills.
I just happen to have copies of the tariffs for application for service for both KU and LG&E, both the current and the proposed. They are in the packets I distributed earlier. For the commissioners, these are behind tabs 11 through 14.
Mr. Crosby, do you have a separate one for Ms. Saunders, or was there one that was provided for the witness?
Just checking.
What I will be glad to do is provide my copies.
Thank you.
Mr. Chairman, may I approach the witness?
Yes, please.
Thank you. Ms. Saunders, would you like to take a few minutes just to look
Sure.
over that?
Thank you. And may I ask, as I'm reading through this, do you need me to look at all areas of this, or is there a certain area you'd like me to concentrate on?
I think it's primarily in the, I've given you my copy.
Okay.
That first
The first
section
section?
with the application.
Okay.
The termination for service doesn't come into play with this.
Okay. Okay, I've read the first page.
So is it fair to say that there's no requirement in the tariff for an applicant to list all adults in the residence?
I would say that it does not say those words. What I would say, though, is in the first paragraph where it talks about the company may require any party applying for service to provide some or all of the following information for the party, then we would want to make sure that that is an adult. So policy-wise, that's what we would say there.
So that's a pretty wide open then piece here, that the company can decide certain things that aren't included, spelled out in the tariff. Is it fair to say that does not put a new customer on notice of what is required in an application?
I would say that the tariff itself doesn't put the customer completely on notice with every piece of the process. What we would ask is that our customers contact us and work with us, and we can help guide them through that process.
So when a customer wants to start a new service, and let me back away from that question.
Sure.
I'm going to withdraw that question. So is it the case that LG&E and KU have on their website an electronic form that can be submitted?
Yes.
For new service? And is it correct that on that form, it lists the primary account holder?
It does list the primary account, but there is also, I heard your question earlier, there is also a box that says joint application or something like that that you can check.
I will respectfully clarify, it does not say joint. It says authorized party.
Okay, I misspoke. It says authorized party, which for us means who is authorized financially to interact with us as a customer. Once you click that box, there's a drop down.
Yes.
From there. Do you want me to keep going?
No, I was going to say yes.
All right.
Yes.
That there's a drop down from that point. Once you click the box and there's a drop down, there are choices of the type of applicant you can be, and that includes spouse, roommate, or just someone for contact.
Correct.
So once, I'm sorry.
No,
I was just going to finish the
talk.
completeness of the process. So once someone completes that, then we know who is allowed to have information, and also those folks provide some of the information you see here in the tariff, such as social security number, et cetera. There's also an additional portion that says if you have any questions about what that box means about authorized, that you can send a message and be contacted to get your questions answered. And of course, that's online. But in person, we can, or on the phone, we can walk through that more thoroughly.
Again, because I don't have the online box, I'm going to ask you to speak from your memory.
Sure.
In order to pull up that pull-down menu of the different parties that might be an authorized party, one has to first click authorized party, correct?
That's correct.
And is there anything in the boxes that would say for questions, if you have question what an authorized party is, that ask us?
There is, I just don't know if it's at that point or if it's towards the end, but there is something on there that allows for that question.
But it's just a question box. It's
It is.
open-ended. It doesn't say what type.
That's correct.
So again, if I want to open a joint account and I go and I see there's just a primary account owner, maybe I don't understand what authorized party means. Would you agree with me that a customer is not fully on notice of what it would mean to establish a joint account, or that they can establish a joint account?
I would say, again, because I don't know when the box is there, that there is that option to ask a question at that point. And of course, there's always an option to, if someone does not understand, for them to reach out to our customer service reps or to stop in at the business office, whichever is most appropriate for them. We generally let our customers guide us, so if they only get to that primary part and that's the only person that they wanted is whoever filled it out, there's no obligation to do, anything else other than to fill that out.
If someone calls in, I'm sorry, I had another question first.
That's okay.
Has your business office been open to the public during COVID?
Yes, but we've not been able to have, we only had walk-in service after we were able to ascertain that it was safe to do so.
Okay. When someone calls in to establish a new account, Do your customer service representatives routinely ask if it will be a joint account or in a single name?
I don't have the exact verbiage in front of me, but once we give a greeting and we ask what it is that they would like us to do, we do have something, I believe, called a customer fact sheet that is an internal term for us, where there is a guide for what questions that they are asked, including who they want on the account. Are there others who you would like to have on the account?
As a post-hearing data request, commission staff will ask for a copy of that. I'm sorry, could you tell me again what you call it? I want to make sure I don't call it a script.
Sure, it's a customer fact sheet.
Customer fact sheet, thank you. I want to offer a scenario and ask how the company would handle this. Let's say a married couple, one spouse, the account is in one spouse's name. That spouse has established an online account to access the bill. Is there a difference between authorizing a second member of that household to authorize the bill and being a joint account with two or more people financially responsible?
I would say that being an authorized person, a joint account holder are similar. It is when you are, the third bullet point I mentioned, a contact information only, that's a difference, because that contact person may be able to receive information, but they're not allowed to call up and say, add this person or add, or do anything to the to that, but the joint account holder or the authorized person can do that.
Well, that's what another question I want to follow up
Sure.
with. So again, one spouse, it services in that spouse's name only.
Yes.
And that spouse wants to add their spouse.
Yes.
Can the primary account, I'm going to call them primary
Sure,
account
that's
holder,
fine.
just call up and say, I want you to add X person?
Yes, as long as they have, the same information, social security number, et cetera, so we can identify that person as being who they say it is. Yes.
So you don't require that second authorized person to be on the phone call?
No.
I don't want to get into anecdotes, but I would encourage you to go back and double check with your customer service representatives about that, because that is not always the case.
Okay. I will definitely check that.
Trying to think, I had a couple other questions that came to me, and I want to make sure I get them going. When you say that you would change your answer to typically in your response to PSC 7
Yes.
to A and B,
Yes.
are there guidelines that LG&E KU follow where, okay, let me take a step back. I'm going to give you a scenario. Couple's been married 30 years. Turns out the account has only been in one spouse's name. That spouse dies. The surviving spouse calls in and says, the service has been in their name, the other person's name, I want it in my name. At what point would LG&E KU consider just transferring the account over and not making it be a new account?
I'm actually glad you raised that. That running of the account of the scenarios is significant with this. And that's one of the challenges, I think, in customer services. There's a lot of, it depends. And that's not always something that is definitive as some of the other things that we present. And in checking back through some of our history and how we've responded, as long as we were able to, through various means, prove that there had been a death and the person that lived there, we discovered that we have allowed that to occur.
And is there any formal policy for that, or is that an informal policy?
I would say that, this is going to be one of those typical answers, I would say that what we try to do is take the tariff and take any statutes and take any other orders and use that as our framework. But we also try to balance the customer experience and see what would be best, which is, one thing I wanted to share is if anyone has had a customer experience that has not been stellar, that's something that we want to correct, because we strive every day to do things to the best of our ability. So I would say that there is room within those boundaries for us to make those types of decisions, and we would make that as an internal decision.
And who would be making that decision? Would it be the customer service representative? Would it be somewhere up the chain of supervision?
Generally, what I would say is that over time, if that decision had been made, then it is then conveyed to the customer service rep, and they will have authority to make certain decisions up to a particular point. And then after that, they then have to go to their supervisor, their manager, director, on up the line.
So, and again, I don't want to mischaracterize what you're saying or put words in your mouth, but does it start with basically a judgment decision or judgment call by the customer service representative?
I think it starts with training, and the weeks and months of training, running our customer service reps through various different scenarios. I think it's important to say that it starts there. In those trainings, then they are given examples of scenarios so that the judgment isn't just on a whim. I feel like I should do this. Something can click to say, this is something I learned in my training. Let me take a look and see what I'm allowed to do. And then they can always ask a question if they've got a concern, and they'll hold the customer, and then someone else can help guide them with that. So we try to make sure that our customer service reps know what their boundaries are, because we've got, and you know this, we've got millions of customers. We just can't have individuals doing individual things. So if we decide, hey, if this is the case and a customer calls in and there's been a death, then that would not just be conveyed to that person, that would be trained to everyone.
And I don't want to go over ground that we've already plowed, but I guess what my question really is it sounds from here that this is more of an informal process, and that while there may be training, there's no default. Oh, somebody called in, a spouse died, and this is what I need to do. It really does depend on the circumstances of the call and who receives the call. That may not be the case, which is why I'm going to ask the next question. Is there any documentation of training that covers that scenario, or a script or customer fact sheet that covers that kind of scenario, that a customer service rep would automatically know, this situation is presented, this is what I need to, the steps I need to take?
I would be happy to, in a post-hearing data request, I don't know if I said that right, but response, to pull whatever was applicable, including what you asked Mr. Conroy earlier about any screenshots or paper applications or electronic.
I'm writing all this down so that when I go back and draft this, I make sure that I've got what I have, what I want.
And Duncan's writing it down for me, I hope, because I'm not writing. Thank you.
We will, this will be issued in writing, and it'll come out pretty soon. I think those are all the questions that I have for right now.
Vice Chair, do you have any questions?
Just a couple.
Hi. Hello.
To the best of your knowledge, on any application form, is there any language warning a married couple that both need to be on the application in order to ensure continuity of service if one member of the couple dies?
There's nothing like that on the application.
That's my only question.
I don't have any questions. Mr. Crosby, do you have any redirect?
Just one. Ms. Saunders, do you still have available to you, and I apologize, Ms. Vincent, were we looking at the KU tear sheet, or did it matter? Doesn't matter. Okay.
Doesn't matter.
All right. I'm going to be looking at KU
That's
tear
what I
sheet
have.
number 97 under the application for service paragraph that I think you indicated you read. The second sentence, which is a lengthy one in that first paragraph, goes through a bunch of information that the company may require a party applying for service to provide. Do you see that?
Yes, I do.
Okay. And at the very end of that sentence, or it's close to the end of the sentence, there's a comma, and any other information company deems necessary for legal, business, or debt collection purposes. Do you see that?
Yes.
Could that include the names and information of other parties at that premises?
Yes.
Okay. That's all I have. Thank you, Your Honor.
Anything else, Ms. Sensel?
Yes, Chairman, I need to move into evidence 5 exhibits. PSC Exhibit 7, which was the press release, 8, 9, 10, and 11.
Just so we're clear, 8, 9, 10, and 11 are the tabs for the, well, let's just start at the beginning. 8 is PSC number 9, KU's tariff, PSC number 19, original sheet number 97, is that correct?
That's correct.
And number 9 is KU PSC number 20, original sheet number 97, is that correct?
That's correct.
And 10 is LG&E, Louisville Gas and Electric Companies, PSC electric number 12, original sheet number 97.
That's correct.
And you said 8, 9, 10, and 11. So is 11 LG&E's PSC electric number 13, original sheet number 97?
Yes, that's correct.
Is there any objection?
No objection, Your Honor.
Okay. Please mark those, Candace, as staff 7, 8, 9, 10, and 11, with 7 being that press release. Okay. Do you have any additional questions, Ms. Saunders?
I have nothing further.
Can Ms. Saunders be excused?
Yes, she may.
All right, thank you very much for bearing with us.
Thank you.
You may be excused. Mr. Crosby, anything else from the companies?
No, Your Honor. Thank you.
Can we take let's take a 4-minute break, just so that we can all stand up and know we still have legs, and we'll come back right at 6 o'clock to,
Mr. Chairman,
yes, Mr. Fitzgerald?
would it be possible to take a 10-minute break? I've got to drive somebody to an appointment, and I was wondering if we're going to plow through, if I could just have that 10 minutes in order to do that.
Yeah, that'd be fine. Well, so let's just go till 6:10. We'll be back at 6:10.
All right,
Thank you.
that's perfect. Thank you very much.
Mr. Barnes, if you could speak first, just so that the camera,
Good evening, folks.
okay, great.
Okay.
Please raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
I do.
Okay. Please state your name and address for the record.
My name is Justin R. Barnes. My business address is 1155 Kildare Farm Road, Suite 202, Cary, North Carolina.
Thank you. Mr. Spinardi, you may ask.
Thank you.
Oh, and Mr. Spinardi, before you begin, I just asked all the intervener attorneys, as they're presenting their witness, to also ask them the same question, especially now that they're all virtual, as to what documents they have in front of them.
Yes, Mr.
Thank you.
Chairman, thank you. What is the name of your employer and your job title?
My employer is EQ Research, LLC, and my job title is Director of Research.
And on whose behalf are you appearing this evening?
I'm appearing on behalf of the Kentucky Solar Industries Association.
And did you prepare supplemental testimony in these proceedings that has been filed into the record on July 13th, 2021?
Yes, I did.
And did you prepare supplemental rebuttal testimony in these proceedings that has been filed into the record on August 5th, 2021?
Yes, I did.
And during the course of these proceedings, have you prepared responses to requests for various requests for information that have been filed into the record?
Yes, I have.
Okay. And Mr. Chairman, I will note that the CASIA has made a filing into the record of an errata sheet, and this was an error of counsel. There was a portion of Mr. Barnes' resume that was fully included in docket number 2023-50, but it was only, some of it was omitted in docket number 2020-349, and so those have been filed into the record. And so at this stage, I'm going to ask Mr. Barnes, if I were to ask you the same questions in all of the testimonies that we've discussed and the request for information, would your answers be the same today?
Yes, they would.
Okay. And so you adopt and affirm those for purposes of this hearing this evening?
I do.
Okay. And also, during the course of these proceedings, one of your colleagues has entered testimony into the record and also responded to requests for information. Mr. Inskeep, are you aware of that?
I am.
And are you adopting and affirming Mr. Inskeep's testimonies and responses for purposes of your testimony this evening?
Yes, I am.
Okay, and as the chairman indicated, Mr. Barnes, can you please identify the documents that you have available in front of you this evening?
I have my supplemental testimony from July 13th and my supplemental rebuttal testimony from August 5th in paper form. I also have a window open on my computer where I can grab other stuff if, at need. Okay,
thank you so much. And Mr. Chairman, with that, at this stage, CASIA tenders Mr. Barnes for examination.
Thank you. And Mr. Riggs, before we begin, do the companies have any objection to the errata or any concern with the errata that was filed?
No objection.
Okay. All right. Mr. Riggs, at this point in the hearing, I'll just ask, would you like to go first to ask Mr. Barnes any questions, or would you like to go after the remainder of council?
I can go after I have cross, it will be of some length, so
Okay.
I can go ahead with this.
I just want to be efficient with our time. I don't want to rush, but I want to make sure that I suspect it may be more efficient to let you go last just before Ms. Vinsel, so that you can hear the questions of everybody else that may or may not clarify some of your questions or add to your questions. So
That's fine, Your Honor. I'll be
Okay.
happy to take it in that.
Okay. Mr. Kurtz,
Yes, sir, thank you.
do you have some questions,
I
Mr.
do.
Barnes? Okay.
Good evening, Mr. Barnes. Will you turn to page 6 of your August 5 testimony?
I'm there.
Okay. Line 5, this is where you're summarizing your positions. The calculation of capacity rates, which uses different methodologies for different technologies, results in discrimination of solar QS relative to wind QS or QS that employ other technology. That's your criticism of the company's approach, correct?
It's one of them.
Okay. And then your approach is, as we'll continue, the capacity rate calculation should utilize a single technology neutral methodology based on the cost of a proxy natural gas combined cycle unit based on the next hypothetical addition to the company's system in its IRP, the use of a proxy market price based on a single utility scale solar PPA fails to reflect the long-term avoided costs. So I want to talk about your single technology neutral methodology. So it's correct, isn't it, that you would apply the same avoided capacity rate to every QF that might ask for it?
In a manner of speaking, if you recall, my suggested rate design was effectively a summer on-peak rate reflecting capacity costs during certain on-peak hours. Now, that rate would be available to all QFs in the same amount, but the amount of revenue that they would generate based on that rate would, of course, differ depending on how much energy they produce during those on-peak hours. So they're it wouldn't be the same compensation; it would be the same rate.
So that single technology neutral methodology would apply to wind, solar, biomass, hydroelectric, waste coal, burning tires, topping cycle code generation, and/or bottoming cycle code generation, correct?
It would apply to any resource that qualifies as a qualifying facility.
Okay. Now, whether we look at the Commission's existing regulation on rates for purchases or the FERC new regulation, which became effective 12/31/20, and which is required to be adopted by state commissions at the end of this year, you did not take into account any of those factors in the existing state regulation or the new FERC regulation when setting rates for capacity purchases, did you?
What factors specifically are you referring to?
Okay, the state regulation, availability of capacity or energy from a qualifying facility during the system daily or seasonal peak. The utility should consider for each QF the ability to dispatch, reliability, terms of contract, duration of obligation, termination requirements, ability to coordinate scheduled outages, usefulness of energy and capacity during system emergencies, individual and aggregate value of energy and capacity, and shorter construction lead times associated with cogeneration and small power production. None of those factors are in your single technology avoided capacity rate, correct?
I disagree with that. The way I designed the on-peak rate is effectively accounting for the ability of a QF to generate during times of need on the system. So it's kind of inherently reflecting seasonal and daily needs through the use of the loss of load probability, the timing of loss of load probability, in order to define what the on-peak and off-peak periods are.
How is the ability to dispatch factored into your proposal?
That aspect is not specifically factored into the proposal, but presumably a resource that could dispatch at will, would be doing so during the on-peak period. And, that, for instance, could be, say, a solar facility that is paired with battery storage.
How is reliability, terms of contract, duration of obligation, termination requirements factored into your avoided capacity rate?
Well, reliability is implicitly factored in because, the use of loss of load probability as a reliability, standard, kind of effectively ensures that that on-peak period is aligned with the times when, the utility may experience a loss of load. Could you name the other ones again?
Terms of contract, duration of obligation, termination requirements, and the ability to coordinate scheduled outages. None of those are factored into your approach, are they?
Well, I mean, the duration of the contract is a 20-year term, which I believe, reflects the company's contention that unless you have a long-term contract, you can't count on, say, a given amount of capacity. I think, so yes, I think the use of an on-peak period under a long-term 20-year contract actually does reflect, some level of, if term is referring to the duration of the obligation, then yes, it does reflect that. And I would say that there is nothing inherent within the rate design I proposed that prevents the coordination of outages. In reality, your typical solar facility doesn't have the same kinds of forced maintenance outages that a facility that relies on mechanical means does.
Where in your
So I would say it counts for the majority of those factors, if not all.
Right. Okay, where in your testimony do you distinguish a 10-year agreement, 15-year agreement, 20-year agreement as to how it would relate to price? Is that in your testimony or your recommendation?
Well, I agree with the company's proposal to establish that kind of 2-year optional price, which does not have a capacity payment, while also offering a 20-year fixed price, which does offer a capacity payment in recognition that, the company needs to have confidence that a QF is going to continue to want to contract with it over the course of 20 years. Obviously, I did not specify different terms, but my proposal was based on, simply a modification of the company's proposals. So to the extent that the company's proposal is consistent with that particular set of rules, I would say that mine also is.
The company proposed different rates for different technologies. You proposed the same avoided capacity rate for every type of technology. Isn't that true?
That's right, but the reason the company proposed different rates for different technologies is because different technologies have a different contribution to capacity when you set a rate that's applicable to all generation. My design adjusts for that contribution to capacity needs by only providing the compensation during a defined on-peak period that's aligned with the company's needs. There's no need to differentiate based on technology for that purpose when you have a rate that's, effectively already doing the same thing.
Do you think all technologies have the same capacity value?
No.
Okay. Turn to page 19 of your testimony, please.
Mr. Kurtz, could you clarify for my benefit which testimony?
August 5.
Okay, thank you.
Are you there?
I'm there.
Okay. So what you did is you took the capacity costs of a natural gas combined cycle power plant and compressed those annual capacity costs into the June through September on-peak periods to develop the rates in your table 3, correct?
Not exactly. For clarification purposes, while I initially recommended a natural gas combined cycle unit as the proxy unit, the numbers in table 3 are actually based on the company's relation of capacity costs under the peaker method using a natural gas combustion turbine.
Well,
so, but beyond that, yes, that's kind of the basic calculation, the discounted costs divided by the number of hours within the on-peak period.
why does your testimony on page 6 say natural gas combined cycle proxy, which you repeat several places if you used a combustion turbine?
I used a combustion turbine because that's what the company proposed. I'm aware that the company has some, I guess, objections to my characterization of a combined cycle unit as the next unit. That was my interpretation of the company's IRP. When the company presented, essentially its own calculations based on a combustion turbine, I utilize those for the purposes of constructing Table 3.
I don't think you asked, Michael. Why did the words throughout your testimony say proxy natural gas combined cycle when Table 3, your numbers use a combustion turbine natural gas?
Using a natural gas combined cycle resource as the proxy unit is my recommendation. I use the numbers from the company's, I guess, supplemental testimony, because, for instance, they had already annually discounted the amounts. It was certainly just simpler than kind of building my own model of what the kind of all-in costs of a natural gas combined cycle unit are. You know, to the extent that those numbers differ for a natural gas combined cycle unit, they probably do. But again, I was kind of basing this particular illustration of my proposal on the company's own numbers. I felt that was a reasonable thing to do, given that they are the company's own numbers that they sponsored as a proxy method of determining capacity costs.
Well, why did you say combined cycle if you use CT?
I'm sorry, I thought I just explained exactly that.
No, throughout your testimony you said you use a combined cycle proxy, but apparently in Table 3 you used the CT, the costs. You think the costs are the same for a combined cycle unit as a CT?
No, they're not the same. Again, my recommendation would be for the company to perform, say, an analysis similar to what it did for a combustion turbine, because it has the information and the resources to conduct that analysis for a natural gas combined cycle unit, to the extent that the natural gas combined cycle unit is actually the next incremental unit of capacity that the company plans to add. Like I said, I'm aware that the company disagrees with my interpretation of their IRP, and for whatever reason chose to use a combustion turbine for modeling, a proxy resource using the peaker methodology.
Okay, so your recommendation is combined cycle, but your calculation is CT.
I'm willing to take the company at its word that, knowing what I know now, that a natural gas combined cycle resource may not be their next incremental unit. I think I'd probably like to see a little bit more evidence of that, but if the company says that it's going to be a natural gas combustion turbine, then I suppose I have to accept that.
Okay, so you took the capital cost, the capacity cost of a combustion turbine gas power plant, compressed those annual capacity costs into the 791 on-peak hours during the summer months of June through September, and that's how you developed these rates on Table 3? Isn't that correct?
That's right. It's the the levelized discounted cost provided for a combustion turbine, depending on the year of a contract. The year I believe its deliveries would begin under a QF contract.
So if a QF, whether it be biomass, wind, solar, topping cycle, cogen, bottoming cycle, coal, waste, if those produced, if any of those technologies only produced in the winter peak hours, they would get zero capacity credit under your proposal.
That's right. If they didn't meet the summer peak, which is when the company needs capacity, principally, then no, they wouldn't get anything.
Are you aware that
in the form of a capacity payment?
Are you aware that KU is a winter peaking utility?
I'm aware of that. I'm also aware that the company's loss of load probability study basically shows, I believe it's 98%, 98.6% of loss of load probability occurring during the summer months.
Is there any coincidence to the fact that your recommendation would provide capacity payments exactly at the precise time when solar facilities would be expected to operate at the maximum amount in the summer during the daytime? Is that pure coincidence, or is that by design?
Wait, Mr. Chairman. Mr. Kurtz did cut off the witness when the witness was giving the prior answer. I would like for the witness to be able to give a complete answer. He cut him off at the word "so," and I'd like the witness to be able to finish.
Mr. Barnes, do you have a additional portion of that answer that you'd given to Mr. Kurtz's last question?
If Mr. Kurtz could repeat the question.
Is it a pure coincidence that your proposed capacity rate would be the maximum amount possible to solar generation, the solar QF, because that's exactly when a solar QF is going to be generating electricity in the summer during the day? Is that a coincidence or is that by design?
Well, for one, it's not true. You know, solar would be operating before 11 a.m. If had I, you know, in the hypothetical where I wanted to maximize the revenue for a solar facility, I would have picked, say, a set of hours that was more inclusive of a daytime solar production profile, which would include, say, the hours from 8 or 9 a.m. to 11 a.m. I would have excluded hours that are after kind of typical sunset, you know, say 6 o'clock to 8 o'clock, in order to kind of compress that, compress those hours to produce the highest rate.
Well, you use the company.
I likely also would have, you know, extended it throughout the year because, you know, even though during the summer is the, you know, typically the best solar production months, you know, a facility might very well gain more revenue from that rate if it was, you know, made, say, daytime throughout the year. So with respect to coincidence, I think the premise of the question is a bit flawed. And I'll say that I didn't conduct the company's loss of load probability study. The on-peak period I chose was essentially designed to cover the greatest, you know, vast majority of loss of load probability hours in the company's system. It was driven by the data.
Okay, so
it just happened to work out, you know, in a way that I think is somewhat favorable, but not totally favorable to solar.
So, okay. So the 791 hours during the summer peak hours represent 9% of the hours of the year, is that correct?
I don't have a calculator on me, but that sounds approximately right.
So generation during the other 91% of the hours of the year would get zero capacity credit, correct?
That's right, because the company does not demonstrate a need for capacity during those other hours.
Again, you're aware that KU is a winter peaking utility?
I am. And I'm aware that, at least in my understanding, the companies conduct that loss of load probability study looking at their integrated system, and therefore their capacity needs are based on that integrated system, not just the needs of KU.
Okay. So do you have a calculator or do you not?
If I can find my phone, I do.
Okay. Let's figure out how much a solar QF might get in capacity payments using your 2026 rate of $146.28 a megawatt hour. Okay? So 146.28, let's use an 80 megawatt QF times 80 times the 791 hours equals 9.2 million times 20. That'll be $185 million capacity payment to an 80 megawatt solar QF, assuming it operated all 791 hours during the summer peak period. Is that math correct?
Well, it wouldn't operate at full capacity at 80 megawatts during that entire duration. I don't have the capacity, kind of the on-peak capacity factor ready at hand, but it would probably be something approaching maybe like 50% rather than 100%. So in that approximation, you know, say half of the number you said.
And in this is the capacity only. The solar QF would also get energy revenue under your proposal, would it not?
Yes, it would.
And it would get energy revenue year-round, no matter when it generated. Correct?
Under what the company proposed as kind of like the levelized energy rate, non-time differentiated, yes, it would receive energy revenue throughout the year, no matter when it generated that energy.
Couple final questions. On pages 10 and 17, you use a very peculiar phrase twice. Let's go to page 10, line 3. These incoherent results demonstrate that the company's proposed avoided cost methodology is facially discriminatory and produces, in my understanding of the terms, unjust and unreasonable rates for QFs. And then you use that same phrase, page 17, line 2, the company's methodology undervalues solar's contribution to grid reliability and produces, in my view, unjust and unreasonable rates for QS. Do you think that under federal or state law, the commission is required to set a just and reasonable rate for a QF? Or is the commission required to set just and reasonable rates for consumers?
I think those are two sides of the same coin. And by way of explanation, if you set a rate that undervalues, say a given resource solely on the basis that it's, a wind resource or a solar resource, and then you apply those prices in contracts that the company enters with a QF, in some cases what you're doing is purchasing capacity and energy that is lower value at a higher rate than you would otherwise had you developed a technologically neutral rate design that compensates based on the actual utility of the service provided rather than differentiating in somewhat arbitrary rates based on technology. Essentially, that technology neutral premise is what protects consumers from paying more than they need to for a given amount of energy and capacity.
Are you aware that under federal and state law, rates for purchases from a QS shall be just and reasonable to the electric consumer of the electric utility and in the public interest, and not discriminate against QS? You're entitled to a non-discriminatory rate, not a just and reasonable rate. But you think it's the same thing?
In my thinking, yes, non-discriminatory, from the standpoint of the objective of protecting consumers is the equivalent of just and reasonable. Whether those terms have kind of a legal meaning, I'm not an attorney, that a legal meaning that's somewhat different than that, they could. But I think from just a kind of common sense standpoint, yes, that's what I think.
Okay. So you think paying the capacity cost of a CT, combustion turbine, first of all, let me ask this. Combustion turbine is available 24/7, 365, is it not?
Well, not exactly, but it certainly has a much higher annual capacity factor. Any mechanical piece of equipment is going to have an outage rate, so it's not going to be available 24/7, 365. But
It's going to have a higher availability factor and the ability to dispatch much more than solar, which can't dispatch at all, isn't that correct?
on an annual basis, yes. To the extent that, say, forced outages take place during peak periods, which could very well happen. It's certainly happened before. You could say that at some level it's less available, but as a unit that can be kind of dispatched in theory at will, you would consider it to be to have greater availability. And of course, that combustion turbine, if it were designated as a QF, would earn a lot more revenue from that on-peak rate than a facility that isn't dispatchable directly during on-peak times.
So your recommendation that it would be fair for consumers to pay for intermittent capacity the same amount of money that they would pay for dispatchable thermal capacity that's available virtually year-round?
They wouldn't pay the same amount of money, that's my point. They would pay the same rate, but they would not pay the same amount of money because as you just, as we just talked about, that combustion turbine or, a dispatchable system that is dispatched to say 100% of its rated capacity during on-peak times would generate more revenue. So the rate is different than the revenue. And I think what consumers probably care more about is the revenue, because the revenue is what, kind of ultimately filters its way into the rates they pay.
So the revenues on page 19, table 3, or the revenues that table generates is what consumers would pay. That's 185 million over 20 years, or you say it's maybe 50% of that. That's what consumers would pay for capacity only plus energy?
Based on the kind of hypothetical, broad ballpark estimate, 50% on-peak capacity factor, which is probably not exact, but say close enough, yeah, they would pay that amount. But the reason they would pay that amount is because the solar resource is displacing a combustion turbine that also carries a cost.
And which is available year-round and is dispatchable.
Yes, but not needed in during many parts of the year.
Thank you, Mr. Barnes. Chairman, no questions, no more questions.
Mr. Cook, do you have any questions for Mr. Barnes?
No, I don't, Chairman.
Mr. Miller?
None, thank you, Mr. Chairman.
Mr. Fitzgerald?
No questions, Mr. Chairman. Thank you.
Forget anybody. Mr. Riggs?
Thank you.
Do you have any questions for Mr. Barnes?
I do.
Please proceed.
Thank you. Good evening, Mr. Barnes. Can you hear me?
I sure can.
I'd like to ask you a few questions about your qualifications identified on your curriculum vitae as Exhibit 1. So as I read your curriculum vitae, you graduated with a BS in Geography in December of 2003 from the University of Oklahoma. Is that correct?
That's correct.
Then you obtained a master's in environmental policy in August of 2006 from Michigan Tech University, correct?
That's right.
Mr. Barnes, when I looked at that degree on the Michigan Tech University website, did you accept, subject to check that that website shows that program is part of the Humanities and Social Sciences Graduate School program?
It is part of the Humanities and Social Sciences program, yes.
So, following your graduation then from Michigan Tech, you've had 8 years of experience between the North Carolina Solar Center and your current employment with EQ Research LLC and Keys, Fox, and Weedman LLP. Is that correct?
So let me think. When you say 8 years, I mean, I guess I spent 5 years at the North Carolina Solar Center approximately, and then the remainder of that time with Keys, Fox, and Weedman and EQ Research. I don't think that sums to 8. I think it's more like 12.
Okay. So is it fair to say that on your 12 years of work experience, you've worked on the renewable side?
Yeah.
Now, your current employment is with EQ Research LLC and Keys, Fox, and Weidman LLP, a law firm. What's the relationship between the two entities?
That might be just it's probably a clarification I should make. EQ Research, so when I left the North Carolina Solar Center, I was employed by Keys, Fox, and Weedman directly for a couple of years. Eventually, EQ Research spun off from Keys, Fox, and Weedman and became kind of its own fully separate entity, and I'm employed by Keys, Fox, and Weedman. The relationship currently is kind of mostly a professional relationship insofar as, we often work together on different things. And the principals of Keys, Fox, and Weedman are also the owners of EQ Research.
Okay, and I'm sorry, maybe I misheard, or maybe you misspoke, but did you say you're currently an employee of the law firm Keys, Fox, and Weedman?
No, I was an employee of the law firm Keys, Fox, and Weedman for about 2 years. I am now an exclusive employee of EQ Research.
Okay. And did I understand you correctly to say that EQ Research is owned by at least the principals or some of the lawyers from that law firm, Keys, Fox, and Weedman?
Yeah, no longer Joe Weedman, but Kevin Fox and Jason Keys.
Okay. In your relationship with EQ Research is one of employer-employee, is that correct?
Yes.
Okay. You're not trained as an engineer, are you?
No, I'm not trained as an engineer.
Okay. And so, given your experiences, it's fair to say that you've never worked as a generation system planner, transmission or distribution planning engineer, have you?
No, I haven't. I've certainly reviewed a lot of professional literature that I think is relevant to those functions, but I've never worked in those specific capacities.
Right. And you're not trained in the social science of economics, are you? You're not an economist.
I don't have a degree in economics, but again, I think it's a question of a lot of professional experience and understanding of economic principles that govern the rate-making process. I'll put it that way.
Yeah, in response to data request number 3, the company's supplemental data request, you stated that you've never performed an embedded cost of service study, correct?
That's correct. I've never performed the entire embedded cost of service study. I've certainly utilized them and modified them on numerous occasions throughout my professional career. I've also certainly read a great deal on the conduct of embedded cost of service studies, including, the seminal literature, the bond rights, the cons, the neighbor cost allocation manual, all of that stuff.
But I'm correct in understanding your last response to say that you've never performed a cost of service or an embedded cost of service study, correct?
I've never performed an entire study. I have certainly manipulated existing cost of service studies.
And in response to data request number 4, the company's supplemental data requests, you stated that you had never performed a marginal cost of service study, correct?
That's right. But again, in my capacity as a professional, I've reviewed and understand a great deal of the principles and economics that underlie the conduct of a marginal cost of service study.
So, similar question in response to question number 5 to the company's supplemental data requests. You indicated that you have never performed an avoided cost of service study, correct?
That's correct. Again, same response with respect to review of relevant literature and resources.
So is it fair to say then, Mr. Barnes, that you don't have the professional capacity, the demonstrated professional capacity to perform these types of studies, while that you review them and then you modify them, you don't have that professional demonstrated capacity to perform these kinds of studies?
I wouldn't agree with that. I think the basic requirement of being able to perform a study is to understand how it works. And I do understand how those different methodologies work and why different methodologies are sometimes chosen over others.
But you have,
So,
excuse me.
so I don't agree with that.
Excuse me, I don't mean to interrupt you. Are you finished? I'm sorry.
I'm finished.
But you have never demonstrated the ability to perform any of these types of studies, have you? You've never demonstrated it by performing any of these types of studies.
Maybe you could explain to me what's necessary to demonstrate that experience. Is it,
to perform a
for
study?
instance, you must work for a utility? I'm having trouble trying to understand what would demonstrate that experience.
How about the performance of the study?
Wouldn't that demonstrate you have the ability to do a study if you actually did one?
That's one way. I wouldn't agree that it's the only way.
But you've never, well, I've covered this point. So. Now, in response to some questions I think Mr. Kurtz asked you about your interpretation of the company's 2018 IRP, I understood you to say that you now accept the company at its word that the next next unit, the IRP does not say that it's going to install a combined cycle turbine. Is that correct?
Yeah, I believe I read a data request from staff to the company to that effect, essentially saying that they disagreed with my assertion. If the company chooses to model the next capacity resource as a combustion turbine, so be it.
And nowhere in your testimony where you asserted that this single cycle technology turbine, did you provide a support for your interpretation of the IRP? Did you? You didn't cite to any specific portion of the IRP.
I believe I did in my initial March, I believe it would have been March 5th testimony. There was a specific citation to, the place within the company's IRP where I believed I had found the answer to the question of what is the company's next capacity addition. My recollection is that it was within one of the tables of potential scenarios where the company suggested that under certain circumstances, its next additions would be solar and a natural gas combined cycle unit. So that's where that, if you have my March 5th, my I think initial direct testimony in front of you, that's where that particular interpretation comes from.
Okay. But you now accept the company's position as expressed in its data response, correct?
I think, the company knows its system better than I do, and I was operating on, off of what they published in 2018.
Okay. Would you also accept, subject to check, that the additions to the company's generation that have followed the 2000 IRP have been the solar share program and the solar PPA?
Subject to check, yes.
I'd like to ask you some questions about your position about having a technology neutral rate. Without some sort of energy storage, rooftop solar installations can't produce energy in the dark, can they?
That's right.
Again, rooftop solar facilities provide energy to the grid. KU has a peak during January at 6 a.m.
No, but nor are they necessarily needed to, given the company's existing suite of resources.
Okay. Can a combined cycle generator provide energy to the grid at 6 a.m. in January?
Of course.
Can rooftop solar facilities provide energy to the grid if KU has a peak in January at 9 p.m.?
Most likely not. Again, are those resources, that incremental capacity resource, is that needed at that particular time? And not to any great degree, according to the company's loss of load probability study.
Okay. You accept it's still dark in Kentucky at 9 p.m. in January, correct?
Yes, I think so.
And a combined cycle generator could provide energy to the grid at 6 p.m. in January, correct?
That's right.
Would you also agree with me that KU is a winter peaking utility?
That's my understanding, yes. Again, my understanding is also that the companies collectively operate their generation fleet in order to meet the needs of the combined utilities. And those peak needs are, very, very focused on the summer afternoon hours.
Would you agree or accept subject to check that KU's system peak typically occurs around 6 a.m. or 9 p.m. during January?
Subject to check, yes.
And I'm assuming, again, that you're not contending that a combined cycle combustion turbine could not operate at 6 a.m. or 6 p.m. at night in January, correct?
Provided it's not on an outage, I wouldn't disagree with that.
Therefore, operationally, at 6 a.m. or at 9 p.m. in January, you're not claiming that a rooftop solar is technologically neutral at that particular hour, are you?
I'm sorry, could you repeat that question?
Certainly. You are not contending, are you, that operationally at 6 a.m. or at 9 p.m. in January, that a rooftop solar facility is technologically neutral at either particular hour, are you?
It's technologically neutral from the standpoint of the times when the company has a danger of not being able to serve load.
You would agree that they are not technically neutral or technologically neutral from an operational standpoint at that time of day, at that month. They cannot operate at 6 a.m. or 9 p.m. in January, a solar facility.
A solar-only facility, yes, I would agree they would not be operating at those times. The question, I think, is whether or not that capacity is needed at those times.
But for purpose of your position of technologically neutral, at those particular times, they are not, correct? They are different.
Well, again, my assessment of technologically neutral is based on the timing of need, not all hours.
Okay.
So when I say technologically neutral, I'm referring to technologically neutral from the standpoint of when the company needs capacity.
You don't dispute that KU needs capacity to help meet its peak on its system in 6 a.m. or 9 p.m. in January, do you?
I don't dispute that there are peaks during the winter. My point is when the company, that incremental kind of next unit of capacity, when that incremental next unit of capacity is needed, it's during the summer afternoons according to the company's own study. This isn't suggesting that a solar resource is suitable for replacing every natural gas combined cycle unit on the company's system, but it is indicating that a solar resource provides that incremental megawatt when the company most needs it during those summer afternoon hours.
Mr. Barnes, I had distributed on Monday afternoon to the parties, including your counsel, a document marked Barnes Cross-Examination Exhibit Number 1. Do you have that? Was that provided to you by your counsel?
It was. I am looking for it. I believe I had it open, and I'm trying to find it at the moment.
Would you please try to find that? I have copies here if anyone.
Would you give me maybe 30 seconds to find it? Because I apparently managed to close it.
That's fine. Take your time. We're going to distribute it here as well in paper medium. Just one. I'm sure. I'm sure he has more than one email. If he doesn't, have you found it, Mr. Barnes?
Yes, I did. It's off on my separate screen, so if I'm looking off to the right, that's what I'm doing.
Perfectly fine. So,
Would you like to mark this before you begin, Mr. Riggs?
I would like to have this marked as KULG Barnes cross-examination, exhibit number 1, please.
Okay.
Thank you, Mr. Chairman. Now, Mr. Barnes, I've handed you a document that has 3 different scenarios, and I want to use these to explore your position. So at the first scenario, I want to ask you a series of questions, then I'll ask you a series of questions about scenario 2 and then scenario 3. Fair enough?
Sure.
Now, in scenario 1, this assumes that that there are no changes in the environmental regulations that necessitate the retirements of Mill Creek 2 and Brown 3 in 2028. And if there are no changes in environmental regulations, then KU and LG&E would not need additional capacity until at least 2034, perhaps even longer. That's the assumption, right? And we've talked about that during the course of the day. Have you heard that testimony back and forth?
Yeah, I've heard a fair amount of that. Maybe not all of it, but most of it, I think.
Sure. So under scenario 1, is there any capacity costs the company could avoid in 2022 by purchasing additional energy from QFs or net metering customer generators in 2022?
You know, given the questioning that took place, I believe, of Mr. Seeley and I believe also Mr. Sinclair, you know, it certainly seems plausible that there is a certain amount of optionality with respect to the company's existing generation units, and that kind of on a theoretical level, that kind of fixed O&M costs, you know, has the potential to be avoided. Could a unit be closed down and then replaced with a, you know, theoretically kind of lower cost unit, thereby avoiding the fixed O&M costs associated with those existing units? I think that's something that could, you know, potentially apply in 2022, but also potentially kind of beyond the time frame if, you know, a utility kind of became capacity sufficient, or if you were to look out, say, 25 years rather than 20 years.
Right, but the companies in this hypothetical do not need any capacity. They have capacity to serve their load safely and reliably. And would you not agree with me that they cannot avoid any capacity by purchasing energy from qualified facilities in 2022 under this scenario?
Well, they could avoid capacity under even if they, like in the hypothetical where they have an existing unit that has fixed O&M costs, and those, you know, fixed O&M costs can be denominated in dollars per kilowatt year or dollars per kilowatt month. And to the extent that a QF is coming online and replacing, say, the energy from that unit, there would still be, I think, an avoided capacity cost, probably relatively small, associated with that, you know, avoiding the fixed O&M that no longer occur because a unit has been shut down without the need for other additional capacity replacement.
Mr. Barnes, is your testimony that operation and maintenance costs are a fixed cost and not a variable cost?
Some O&M is fixed, some is variable.
Okay. What would be an example of a fixed operation and maintenance cost?
You could have general maintenance that kind of has to take place, you know, to maintain a unit that doesn't necessarily depend on, you know, how much you're actually using the unit. That is just kind of checking for wear and tear on parts. You know, insofar as you could, in theory, kind of have a unit being mothballed, there would probably be some cost that you still had to incur just to keep that unit ready to start up if it needed to be, basically brought out of mothballed type status. So even if it's not operating, it doesn't mean we can kind of just totally forget about it. It still has a certain level of costs. You could also say that fixed O&M costs would be associated with the labor that's necessary to simply have somebody at the plant, or more than one person, even when it's not actually operating. If you consider kind of a personnel cost, somebody who's employed on an annual basis fixed, then that would be a fixed O&M cost, because it doesn't matter how often you operate the unit, it's still going to be incurred if you want the unit to potentially be used.
Are you aware of that practice in the industry, of employees just sitting around being paid in case the unit happens to run?
I'm aware that the company's own combustion turbine study shows fixed O&M costs. The company is probably better equipped to explain exactly what those fixed O&M costs are, but if you look at Mr. Sinclair's work papers, there is a clear definition of fixed O&M costs,
Okay.
which are included as a capacity cost of the resource.
Okay. Now, to calculate the avoided costs under scenario 1 for a 20-year QF firm capacity contract that begins in 2022, wouldn't it be first necessary to calculate the present value of the avoided costs that would occur through 2034 to 2041?
Yeah, I mean, the practice that you would typically use is to, and we'll just assume, for the sake of this example, that there are no avoided capacity costs between 2022 and 2023. So from that starting point, we determine a discount rate, we discount the costs that are occurring kind of successively over the years, and then once we arrive at that number, we do a levelization practice where essentially, because we're discounting the cost that would be paid for that resource well into the future, we also have to discount the costs that if you replaced that resource with something else, we have to discount what customers would pay for, say, in the form of a capacity payment to a QF in 2022 or 2034, based on the same time horizon that we're using for the assessment of kind of the capacity need, if that makes sense. So you discount the forward-looking costs to develop a net present value, but then you levelize those costs in order to essentially discount the fact that if customers are going to pay some costs, some of those costs they're not going to pay until 2034 anyway, okay. And we discount the costs of those customers in the same way that we do the cost of the resource itself.
Okay. And to maybe kind of move this area of examination along, if you look at scenario number 2, which is a version of scenario number 1, but it shows that capacity is not needed to 2028. Do you see that?
I do.
Okay. And so if I were to ask you the same questions, would your testimony also be the same, that under that hypothetical scenario, you would agree that for the capacity that is going to be incurred from 2028 to 2041, under our hypothetical 20-year contract, you would, again, have to discount that and levelize that cost over the life of the contract?
Exactly, yeah. That's exactly what you would do.
Okay. Is it your position that current companies currently have insufficient capacity to meet the expected system peak demand?
My understanding, based on what I've heard, is that the company's representation of its capacity need is potentially in 2028, but has issued an RFP that it creates at least the implication that it has a capacity need as soon as 2025. I'm not sure how I can reconcile those two kind of, conflicting dates, but that's my understanding.
But today, currently, the companies have sufficient capacity to meet their expected system peak demand.
correct?
I guess it kind of depends on how you know, today, the companies have an expected capacity demand, say, in 2028. You can look at that in two ways. One, you can say they have no demand or need for capacity at this specific moment. Or you can say the companies do have a need that's been identified at the current time, but that need doesn't occur until 2028.
Now, didn't you base your cost on the current, what's called cost of new entry or cone from PJM?
For what I presented for as the capacity component of the NMS2 rate, yes, I based that on the current net cone for a combined cycle unit. And then if you look at my work papers, I also present in my supplemental rebuttal testimony, I also presented a calculation of what the NMS2 rate would be, essentially kind of using the combustion turbine methodology that Mr. Sinclair employed in his own peaker unit capacity calculation.
And in determining the net cone, does PJM discount the cost of generation capacity from 2034 to 2021?
I don't believe that they do. I view the PJM net cone as effectively kind of the current cost.
Okay. So the same question, in determining the net cone, does PJM discount the cost of generation capacity from 2028 to 2021?
Again, no, I don't believe that they do.
Okay.
They certainly don't pick those specific dates if they do any discounting at all.
Okay. In your present value calculations, you did not present present value calculations, and you did not consider the intervening years when the companies need no additional capacity, correct?
That's not exactly true. If you look, I did present a comparison of what the NMS2 rate would look like if it used the company's combustion turbine and levelization and discount methodology. I don't remember the table number off the top of my head. I'm looking for it right now. But ultimately, it ended up being largely the same as the value I calculated based on the current net cone. It wasn't dramatically different.
Okay.
I believe it might be table 6 or table 7. And so I essentially presented a table that used the company's kind of own analysis as a base rather than the PJM net cone current natural gas combined cycle.
Okay. But fundamentally, you do agree for the need to do a present value calculation, correct?
Yeah, for the purposes of defining, avoided costs, yes, I do. Is that necessarily, I would note that like the NMS2 statute doesn't expressly say that the compensation must be based on avoided costs. That's one way you could interpret it, but it certainly doesn't say those specific words or necessarily equate capacity avoided costs for a qualifying facility to, the value-based rate that an NMS2 customer would receive.
Do you think it's sound practice not to do a present value calculation when calculating these kinds of capacity payments over a long term?
I think, yeah, ideally, yes, you should do that particular calculation.
All right. Let me ask you a couple of questions about your testimony on the avoided transmission and distribution, okay? All right. Now, you recommended the commission use an embedded unit cost approach for calculating avoided transmission and distribution rates, correct?
Yeah, I referred to it as the embedded unit cost approach, which is essentially, inferring marginal costs from existing embedded unit costs.
Okay. And you are familiar with the term embedded cost, correct?
I am.
would you agree with me that that includes costs that represent a utility's revenue requirements, such as O&M, depreciation, return on investment, income taxes, property taxes?
Yes, all of those things influences utilities embedded costs.
Right. You're also familiar with the phrase avoided costs, correct?
That's right.
And are you familiar with the Kentucky Commission's regulation, small power production and cogeneration?
I couldn't quote them, but I would say I'm fairly familiar with them.
Okay. So are you familiar with the definition of avoided costs that has been read during the course of this hearing several times?
Like I said, I couldn't quote it, but I believe I'm pretty familiar with it. Actually, I have it up in front of me right now, so if you'd like to discuss it.
So if you have it before you, I'm not going to read it to you. Are the definitions of avoided cost as defined in that small power production and cogeneration regulation the same as embedded costs?
So under that definition, avoided cost means incremental costs to an electric utility of electric energy and capacity, or both, which if not for the purchase from the qualifying facility, the utility would generate for itself or purchase from another source. Yes, that's certainly different than the concept of, that's certainly different from the concept of, say, a value-based rate for NMS2 customers, because, the PURPA regulations are affecting the purchase of energy in capacity. They're not necessarily reflecting the full costs avoided that don't necessarily involve the purchase of energy and capacity, insofar as you can't purchase transmission capacity in the same way that you can purchase generation capacity. So I think there's a difference between kind of a full value-based rate for a net metered distributed energy resource and a QF that is purchased at the sale of energy and capacity to a utility.
But you agree with me that the definitions of avoided cost and embedded cost are not the same, correct?
Well, exactly, and I didn't suggest that QFs be provided with avoided distribution or avoided transmission costs. Again, there's a distinction between rules for QFs and net metering. Otherwise, why would we have a net metering law if all we were basing it on was QF rates?
My only question to you, sir, is that you do agree, as I understand your testimony, that the definitions of avoided cost and embedded costs are not the same.
That's correct. I thought I had answered that.
So, now, have you performed any kind of empirical studies comparing embedded costs to avoided costs for electric utilities?
I've certainly done that, some form of that analysis insofar as I've done analyses where I've looked at what I've kind of referred to as the cost of service value of a given set of solar resources. And by cost of service value, what I mean is for a given class, if you apply that solar production as a kind of as a megawatt decrement of, say, a class's peak load or maximum monthly demand or something similar that's used in the embedded cost allocation structure, there is a value that you can define that reflects, because a, say, residential net metering customer is reducing the class's overall contribution to peak load, it produces an overall reduction in the costs allocated to that class, and therefore produces what I've referred to as a cost of service value to the respective class. Now, that's certainly a different concept than looking at avoided costs or otherwise sometimes also kind of conflated with marginal costs.
Mr. Barnes, it's about 25 minutes after 7 p.m. here. And my only question to you was whether you had performed those kinds of studies. And if you have, I'd like to ask you to produce them in a post-hearing data response, please. Would you agree to do that?
Yes, I think I could certainly do that.
Now, are you aware of any studies or surveys that have compared avoided capacity transmission costs to embedded transmission costs for a panel of utilities?
I'm sorry, could you repeat that?
Certainly. Are you aware of any studies or surveys that have compared avoided capacity transmission costs to embedded transmission costs for a panel of utilities?
I guess there is a relationship insofar as when you conduct a marginal cost study, one of the ways in which you do that
I'm sorry,
is
Mr.
look
Barnes,
at.
I'm just asking you if you're aware of any studies. That's my question to you.
I'm
Are you
trying to
aware?
respond. The neighbor cost allocation manual creates a direct tie between embedded cost studies and marginal costs, under which you use embedded costs combined with load increases to determine what a utility's marginal costs or avoided costs actually are. So there's a clear relationship. The neighbor cost allocation manual has examples of that. I'm not sure if you would call those studies, but it's certainly kind of like a conceptual framework under which they define methods for arriving at marginal costs.
Other than your in view of the neighbor manual, are you aware of any such studies?
I can't think of any off the top of my head, though I suspect there probably are some.
And are you aware of any studies or surveys that have compared avoided capacity distribution costs to embedded transmission costs?
I can't think of any off the top of my head, but again, it's something that I would expect is not uncommon when, comparing, say, the results of a marginal cost of service study and an embedded cost of service study.
And would you agree with me that the difference between a marginal cost and embedded cost is that embedded fixed cost measures the cost of all the utilities plant that has been installed to date and reflects the cost of serving total demand, not incremental demand?
Yes, that sounds right to me.
Okay. Do you further agree with me that marginal cost represents the utility's marginal or incremental cost?
Yes, marginal is usually, considered pretty synonymous with incremental, the next 1 megawatt.
Typically, under what situations are marginal costs likely to be lower than embedded costs?
You often find that in kind of the construct of an entire cost of service study, that the marginal costs would not raise the same amount of revenue as is indicated based on embedded costs. And for that reason, utilities and commissions that use marginal cost studies for cost allocation, will often tend to apply, say, like a gross up factor, where the results of the marginal cost of service study are effectively kind of grossed up to equal the revenue requirement associated with the utility's embedded costs. And, the reason that those costs could differ is, simply that, technology changes over time. There are new things that become available, whether that's, you could say battery storage or RICE internal combustion engines. Things change over time. So past investments, become not necessarily the investments you would make in the future.
Okay, Mr. Barnes, I think Mr. Fitzgerald has a concern, a scheduling concern he needs to raise. I've gotten an email. Let me try to ask you one quick question so that we can take that up, because I do think Mr. Fitzgerald's issue is time sensitive. Would you agree with me that it's possible for avoided costs to be lower than embedded costs? Yes or no? It is possible.
Yes, it's certainly possible for avoided costs to be lower than embedded costs. The corollary is also true. It's certainly possible for avoided costs to be higher than embedded costs.
Okay, excuse me, Mr. Barnes, I need to address the chair on this scheduling commission. So I have an email from Mr. Fitzgerald that Mr. Owen has a firm deadline of 7:30 tonight.
Right, and Kendrick, first of all, let me thank you for your graciousness I did not mean to interrupt the flow of your cross-examination. Mr. Chairman, I checked with Duncan and with the AG and indirectly from KIUC, and I don't know that anybody has questions for Mr. Owen, but he does have a firm deadline tonight of 7:30. And so I was just going to check and see if he can be excused and just his testimony and his answers to the DRs just rest on the record that has been created.
So, Mr. Fitzgerald, I have a question. Here in Frankfurt, I think probably in Louisville too, it is 7:27. Is Mr. Owen by any chance in Central Time?
I am Central Time.
Okay, so can I just ask Mr. Owen, do you have an hour left or do you have 3 minutes left?
Well, the out is at 6:30 Central Time.
All right, I just want to make sure.
Time.
Thank you. Ms. Vinsel, do you have questions for Mr. Owen?
I know staff does not have questions for him.
Okay, and Mr. Kurtz, you don't have any questions?
Correct, no questions.
And Mr. Cook, do you have questions for Mr. Owen?
No, sir, the AG has no questions.
No,
Bernard, do you
Mr.
have
Chairman, no questions for Mr. Owen.
And Mr. Riggs, does the
No.
company have questions for Mr. Owen?
We don't have any questions for Mr.
No.
Owen.
Okay, so if there's no objection, I'm happy if there is no objection to excuse Mr. Owen right now from the hearing and let his testimony stand on the record.
Okay.
There nothing?
Mr. Chairman, again, thank you, and
Thank you.
Kendrick, thank you very much.
Thank you, everyone.
Mr. Riggs, you may proceed if you have additional questions for
I need to.
Mr. Barnes.
Checking my notes.
Take your time.
So, I think, Mr. Chairman, in light of the hour, I'm going to bring my cross-examination to a halt, but reserve the right to ask additional questions based on the commission's questions or staff's questions.
Okay. Ms. Vinsel, do you have any questions?
No, staff does not have any questions for Mr. Barnes.
Vice Chair?
No questions?
I don't have any. Mr. Spinar, would you like to conduct any redirect?
Very limited redirect, yes. We could get Mr. Barnes back.
Mr. Barnes, could you say something?
I'm here.
Okay.
Great, thank you.
Yes, with regard to and I'm only asking for your opinion, not for a legal opinion, is it your understanding that per the Kentucky Administrative Regulations that the Public Service Commission regulations include a specific definition for avoided cost with regard to QFs?
That's right. The definition of avoided cost is applicable within those regulations to QFs.
And your testimony does not suggest for the commission to substitute the concept of embedded cost for avoided cost for these purposes. Is that correct?
No, my use of embedded costs was simply a way to define an estimate of marginal costs synonymous with potentially avoidable costs.
And with regard to the net metering statutes, to your knowledge, do the net metering statutes definitional sections contain a definition for avoided cost?
Not that I'm aware of.
Okay. And frankly, with that, Mr. Chairman, I want to double check. That's all I want to ask.
Okay. Mr. Kurtz, do you have any additional questions, Mr. Barnes?
No, sir.
Okay. Mr. Fitzgerald, you didn't have any, Ms. Vinsel?
No.
Okay. Did the redirect cause you to need any additional cross-examination, Mr. Riggs?
No.
Okay. Vice Chair? Is there any reason that Mr. Barnes can't be excused for the remainder of the hearing? Thank you, Mr. Barnes.
And
Thank you, Your Honor.
Mr. Chairman, thank you so much. With that, that is the presentation of the evidence on behalf of CASIA. We do not have any additional witnesses.
Okay, thank you. And Mr. Riggs, would you like to address the exhibit?
Yes, I'd like to move the admission of LG&E KU Barnes cross-examination exhibit number 1 into the record.
Is there any objection?
No objection.
Thank you. Candace, will you please mark that as KU and LG&E Barnes cross-examination exhibit 1?
Correct.
All right. Thank you, Mr. Spinard. Do you have anything else?
No, Mr. Chairman, no, sir.
Thank you. Mr. Miller doesn't have witnesses. Mr. Fitzgerald,
Yes, Your Honor.
would you like to call your first witness? Actually, Mr.
Absolutely.
Fitzgerald.
I'll call our first and only witness, and again, appreciate everybody's indulgence. I'd like to call Mr. Carl Robigo to the stand.
Mr. Fitzgerald, can I just ask, let me first ask before I propose this. Are there questions for Mr. Robigo? Does the company have questions at this point?
Give me one moment.
Okay.
No, we do not.
Do you have any questions for Mr. Robigo?
Do not.
The Attorney General does have questions.
Does have questions. Ms. Vinsel, do you have questions, Mr. Robigo?
Yes, we have a
Okay.
few questions.
Mr. Fitzgerald, right before we call Mr. Robigo, and I know you've already called him, so it'll be easy when we get back. Let's take a couple-minute break for all of our benefit, including our reporter here. Let's come back in 10 minutes at 7:45.
Absolutely.
All right, take a
Thank you, Your
short
Honor.
recess. Thank you.
Come on. Thank you. Yes, sir, you're on now.
Okay. Mr. Fitzgerald, can you hear us?
Sure can.
Great. We're back on the record in case numbers 2020-349 and 2020-350. Mr. Fitzgerald, you may call your witness. First witness.
Thank you. I'd like to call Mr. Robigo.
Just checking my comms here. Can you hear me okay?
We can. Thank you for speaking up so that the camera targets you there. Please raise your right hand. Thank you. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
I do.
Okay. Please state your name and address for the record.
My name is Carl R. Robigo. My address is 2025 East 24th Avenue, Denver, Colorado.
Mr. Fitzgerald, you may ask.
Thank you, Mr. Chairman. Mr. Robigo, did you cause to be entered into the record of this proceeding certain testimonies and rebuttal testimonies as well as responses to certain data requests?
Yes, I did.
Okay, and do you affirm those answers and that testimony and adopt them here as your own?
Yes, I do, and yes, I do.
Okay, and if I were to ask those same questions and pose those same data requests to you today, would your response be the same?
They'd be the same or substantially the same.
Okay, and do you have any changes or corrections that you wish to make at this time?
I do not believe I do.
Okay, and for the record, what materials do you have available before you right now?
I have paper versions of my filings in this case that I happen to find, and that I have a computer screen with access to all the documents and the docket records at the commission. So, plus my files if I need to dig something up.
Okay, thank you. Your Honor, the witness is available for cross-examination.
All right, thank you, Mr. Fitzgerald. Mr. Kurtz? No questions. Mr. Cook?
You know, I'll do the cross-examination.
Oh, okay, I apologize.
No,
Mr. Horn.
that's fine.
Mr. Horn, do you have any questions?
There's, he may be having some connection difficulties.
Okay, please proceed.
Okay. Good evening, Mr. Robigo. How are you doing?
I'm just doing great, thank you.
Thank you. If you have any trouble hearing my questions, please let me know. All right?
Okay.
Is it fair to say that your work, in your line of work, that you're involved with net metering issues across the country?
Yes, I have been.
Okay. And how long have you been kind of involved with net metering issues?
Oh, gosh. Let's see. Probably going back, wait, let me just think for a second. I'm sure I've been aware of them for quite a long time. I've been extensively involved in net metering and so-called successor tariffs since I worked at Austin Energy in 2008.
Okay. And do you try to keep abreast of net metering issues across the country?
I try to stay on top of it. There's a lot of activity, but I try to.
And from your testimony that you filed in this case, it appears that you've had some involvement with net metering issues in California. Is that correct?
Yes, I have.
Okay. And on your resume, it says that you are chairman of the board, Center for Resource Solutions, from 1997 to present. Is that correct?
Yes.
Okay. And the location for the Center for Resource Solutions is based in Presidio, California. Is that correct?
That is correct.
Okay. Would you say that California is a state that has generally been thought of as on the forefront of solar and net metering issues?
Yeah, what did you say right before forefront? Could you repeat that?
Okay, yes, sir, I can. Would you say that California is a state that has been on the forefront generally on solar and net metering issues?
I would say they're a leading state, yes.
Okay. And California certainly has a lot of sunshine, doesn't it?
Yes, they do. I understand they do.
Yeah. A lot more in Kentucky. Sometimes we get jealous about that. Thing.
I suppose there might be reasons for jealousy to go both ways.
Is solar and net metering a big deal, a big issue in California, would you say?
It is, and it is especially so now with the so-called NEM 3.0 proceedings underway.
Okay. In your opinion, is California still on the forefront of solar and net metering?
Yes, I think they still are considered a leader among the states in dealing with these issues.
Okay. Have you ever been involved with solar and net metering legislation in California?
If legislation, very tangentially. I know I've worked with or talked to some advocacy people who do work and shared ideas perhaps, but I don't have any specific recollection, for example, of drafting legislation or certainly not any lobbying.
Right. But do you follow net metering legislation in California?
Yes, not as closely as regulation, but I generally stay aware of what's going on with legislation regarding net metering.
Okay. Do you know who Assemblywoman Lorena Gonzalez is?
Say that again?
Assemblywoman Lorena Gonzalez. Do you know who that is?
It's not ringing a bell, so I don't have any specific recollection of who that is.
Okay. Well, she is the chair of the Assembly Appropriations Committee. And this year, she sponsored a bill in the California Assembly, Assembly Bill number 1139, entitled Net Energy Metering. Are you familiar with that bill?
No, I'm not.
Okay. Well, that bill addresses payment of utilities to homeowners with rooftop solar. Would you say that is a hot issue in California?
I'd say it is definitely a hot issue. The compensation rate for exports from net metering facilities is a hot issue in California and other places.
Okay. Do you have any idea of the motivation behind Assemblywoman Gonzalez's reason for filing that bill?
No, I do not.
Okay. Mr. Robigo, thank you for your cooperation and answering my questions. You have a good evening. That's all I have, Mr. Chairman.
Mr. Spinard, do you have any questions for Mr. Robigo?
No, Mr. Chairman.
Mr. Miller, do you have any questions for Mr. Robigo?
This is Joe Childress. No questions, Joe.
All right, thank you, Mr. Childers. Are you taking over for Mr. Miller for the rest of the evening?
Yes, I am.
All right, thank you, Mr. Childers. Ms. Vinsel, do you have any questions for Mr. Robigo?
Yes, I do. Thank you, Chairman. Good evening, Mr. Robigo. Sorry, I said good evening, and I wasn't sure what time it was where you were.
Yes, no, it's already almost 6 p.m. here, so we're all in the evening time.
All right, thank you. Mr. Robigo, in your supplemental testimony, you both cited to and used information regarding the Minnesota value of solar methodology. Is that correct?
Yes, ma'am.
And you also, out of full disclosure, you also stated that you participated in the development of Minnesota's value of solar law and methodology. Is that correct?
Yes. Yeah, I helped draft and pass the legislation and helped Clean Power Research do the development of the methodology and some of the workshops. And then the commission got hold of it and implemented it and all that stuff, and I've mostly been something of a bystander since that time, but since I had an early involvement, I try to keep up with it.
You had stated in your testimony that you find the Minnesota's value of solar methodology and overall approach to be reasonable. Could you expand upon that?
Yes. Yes, several different ways. One was that I think the legislation did a good job of setting out what needed to be done. Second, it charged the Department of Commerce, which is where Minnesota houses its energy office, to conduct the study. Third, it gave the commission the job of reviewing the methodology and making any changes it saw appropriate for regulatory application. Fourth, there were numerous extensive, transparent opportunities for stakeholder involvement in all of those things. In fact, I think the commission ended up having 3 different shots at the value of solar methodology to get it on the books and in place, and then it is updated on a regular basis. Fifth, it has spawned continuous engagement by stakeholders who offer improvements to sub-methodologies, and so it's a living thing. I should say one of the good things was that when it was first created, it was created as an option to traditional net metering, and that was actually a reason why Xcel Energy was supportive of the legislation, that they could stick with net metering if they found that to be problematic, or that they could use the value-based approach for determining the compensation level for export credits. And it has shown itself to be capable of learning and improving, as I said, through this sort of continuous process. So, and I should say, finally, most importantly, it's worked. It has led to a robust community solar market being created in Minnesota once they work through things. By some counts, Minnesota leads in the development of community solar, which is something that I personally think is good, and meaning many more customers have access to competitively established and environmentally friendly renewable energy generation. So by pretty much all accounts, I think it's worked well.
Thank you. I'd like to circle back to something you said about the utilities working with the various agencies to update methodologies. Is it correct that the utilities that are subject to the Minnesota Public Utilities Commission jurisdiction are required to file updated spreadsheets and submit a value of solar calculation annually?
Yes, that's what I understand.
And sorry, my computer went to sleep mode. Let me bring it back up so I make sure I refer to the right document. In response to Commission staff's 4th request to the joint interveners, you were asked about your familiarity, in particular with Xcel Energy's value of solar filings, correct?
Yes, ma'am.
As a post-hearing data request, the staff would ask if you could provide us with a copy of Xcel Energy's September 2020 value of solar calculation spreadsheets and its compliance filing associated with those spreadsheets.
I remember looking at that material and answering a data request regarding that, yes.
And we will get those post-hearing data requests to you in written format.
Okay.
And we'll get them back to you as quickly as possible.
We'll hash that out shortly, Mr. Fitzgerald, I believe. Staff has no further questions.
Mr. Ricks, before, did I ask you if you had any questions?
You did not, and I do not.
Okay.
Vice Chair, do you have any questions?
No questions.
I have very few, Mr. Robigo. Good evening.
Good evening.
I just want to ask about, this is the second case that the commission has received regarding to net metering successor rates under our changed statutory scheme. The first case dealt with Kentucky Power that you're aware of. And, it's reasonably expected that Kentucky Power will be filing another rate case in the next couple of years. In addition to that, in this case, as part of the stipulation of this matter, the companies expect to stay out for a period of time, approximately 4 years, I think. But I think it's 4 years before the rates become effective. So it's one of those that I think they can file a certain amount of time, and knowing that there's a suspension period, and then, this case still has to get an order out. It'll be the end of next month. So, even if they're out only the minimum amount of time they can, that's still only going to be approximately 3 years between when the commission sets rates in this and when they propose additional, base rates moving forward. My question is, as additional background, historically under PURPA, my understanding is that there's an ongoing requirement that utilities subject to PURPA have to file updates for their cost information, for their avoided capacity and their avoided generation cost. And at least historically in Kentucky, that information has been provided about every 2 years. My question on net metering successor rates, for other states that have had net metering successor rates, this may be Minnesota, it may not be, with value of solar, whatever it is. In other states that have had successor rates that don't use 1-to-1 kilowatt hour netting, is there a time period in which they expect or require or demand that the inputs into those cost calculations be updated or amended?
Yes, and there's a range of approaches that a commission can do. And it really is about trying to find, as with so many decisions that you have to make, I'm sorry, that sweet spot where you meet sort of the maximum number of sort of stakeholder needs for just and reasonable rates. Let me explain. For example, when I enacted the value of solar tariff at Austin Energy as a utility executive, I originally said what we do is we'd update the rate every single year. That way we wouldn't have a regulatory lag problem, if you will. We had been, I created the value of solar rate at a time when we were coming in after 18 years of not having a base rate case. And so we sure didn't want to get into that situation. But shortly after I left Austin Energy, my former staff there actually said, well, the market needs a little more stability. So they used 5-year rolling averages of values. And so they collected the data with Austin had actually been doing value of solar analysis before I used it in the tariff. So they had spreadsheet data, and they said, well, we could do this, and that way you'll avoid you'll introduce an element of gradualism, another, so it's cost-based, but it's mitigated by gradualism. In some cases, like in New York, they basically said that with the beater transition into beater, the value of DER, they did kind of tranches. They said, yeah, the methodology stays the same. You'll get avoided energy, you'll get avoided capacity, et cetera, et cetera. But we might change the structure for subsequent cohorts or year groups. So 3 years down the line, the mix might be different. But, and in order to preserve the freedom to make changes in the methodology, the formula, if you will, New York has been pretty generous with adopting the idea of legacy rates. So if you had a rate, if you got on the rate, you'd be guaranteed that your structure would stay in place for 20 years or some period of time. but a subsequent adopter might get a different structure. And so you really, there's been a range of responses around it. You know, if you think about it, traditional net metering is just a structure that stays in place within which the values may change, right? So just like you described the PERPA rate, in that regard, net metering is very similar. Your avoided value of energy may change from year to year, and a new, the new compensation level will change when that rate changes. So it just depends on, I guess, frequency of rate cases and permanent rates. So I've blathered on to say there's a wide range, and you get to choose what you think is the most just, reasonable, and non-discriminatory.
All right, thank you very much, Mr. Robigo. Mr. Fitzgerald, do you have any redirect for Mr. Robigo?
I do not, Your Honor. And the only thing left to do in our presentation of our case is that I would like to enlist there's an objection.
We'll take 1 second, Mr. Fitzgerald. We lost you there at the end. We'll let it buffer.
Objection from one of the parties to move into evidence the joint interveners 20. I have sent that.
Okay, we'll take 1 second for everything to catch up. Mr. Fitzgerald, can you hear us okay?
I sure can.
Okay. All right. We'll see if anybody has any additional questions for Mr. Robigo first. Mr. Kurtz, do you have any additional questions? No. Mr. Horn?
No, sir.
Okay. Mr. Spinard?
Okay, sorry.
Mr. Riggs?
No.
Okay. Do you have any additional questions?
Nothing further.
Mr. Miller's gone. So, Mr. Childers, do you have any questions for Mr. Robigo? Mr. Childers may have gone home. I don't blame him, as late as it may be. Is there any reason that Mr. Robico can't be excused for the remaining portion of the hearing?
He can be excused.
Okay. All right. Thank you very much, Mr. Robigo. Mr. Fitzgerald, before we had an issue with the audio, I think you were going to move to introduce the exhibit that you discussed earlier. Is that correct?
Yes, that is correct, and I apologize. I didn't mean to cut short the possibility of anybody else doing redirect on Mr. Robigo. But yes, we'd like to move for admission of that exhibit as joint interveners 2, and have circulated a copy to everybody for their review.
Okay, so let's take a step back. What is joint interveners 2?
This is a copy of a PPL press release that was on their website. In 2020, we've discussed the international award that LGD and KU had received for their economic development efforts.
Okay, and that was joint interveners 1 was the near declaratory order. Is that correct?
That's right.
Okay. Is there any objection to Mr. Fitzgerald, the joint interveners hearing exhibit number 2?
No objection.
No objection.
All right. Well, we'll get you a copy, Candace, and mark that as number 2 for the record, please. All right, Mr. Fitzgerald, do you have an additional witness?
We do not, and I appreciate again everybody's indulgence in my interrupting Kendrick's Cross, and appreciate everybody allowing Mr. Owen to be excused.
Okay. At this point, as I have in my notes, everybody has moved all of their exhibits into the record. Is that correct?
Yes, sir.
Mm-hmm. Ms. Vinsel, I think you've moved all 11 of the staffs. Is that correct?
That's correct.
Okay. And then, Mr. Kurtz, you had 3?
Yes.
Okay. And I don't think the Attorney General had any,
No
you
exhibits.
can see it had no exhibits. Okay.
Yeah.
And the companies just had the single Barnes exhibit. Is that correct?
That's correct.
Okay. All right. We've got all the exhibits. We know the outstanding motions that some of which we did or didn't rule on at the beginning of the hearing, and we will get orders on the ones that we did rule on from the bench. I think those are
Your Honor, you granted the motion to leave to file the supplemental server rebuttal. You granted the motion for leave to file the amended Conroy testimony.
That's right.
And you indicated at the beginning of the hearing that you would have orders out on the various petitions for confidential protection in due order. So
I additionally have the granting the company's motion for deviation regarding the ProSim modeling as well.
Yes.
Okay.
We will be filing delivering the 4 thumb drives to staff by Friday of this week. They're already made and sitting on my desk, so they're ready to go.
And we'll enter an order, well, I don't think we need to enter an order, but we'll expect, I think, 6 or 7 days, sometime next week, before the end of the next week, the written motion for the documentation that was provided in camera to the commissioners and council.
Yeah, my thought at the moment is I'm simply going to confirm the submission of that in a formal letter to the commission.
So as I see it per our regulations, we may want something formal for the purposes of KRS Chapter 61 for the Kentucky Open Records Act, so that we can, should someone seek the documentation, I think we would prefer to have ruled on its confidentiality.
Okay, understand. Okay,
I know it's an extra step, but
no problem.
ounce of prevention kind of thing.
Yeah, okay, I understand.
All right. So I believe there will be outstanding, there are outstanding requests for information at post-hearing. I think, Mr. Riggs, you will have some. I know staff council, at least one.
Yes.
I know staff council will have some. Today is the 18th. Would everybody be able to submit the post-hearing data requests that they've indicated at the hearing that they intend to ask by the end of the day, Friday?
Yes.
The 20th?
Yes, staff can do that.
Okay. So those will be due out to be requested on the 20th. Is there anybody that believes that they won't be able to answer those responses within 7 days?
By the 27th?
By the end of the day on the 27th?
No, we can do that.
Okay. And as I understand it, I think we've discussed this a few times, that the statutory date is September the 24th. Of course, we'll get an order out prior to September the 24th. If the parties would like to file a brief, I'd like to provide everyone an opportunity to do so.
Your Honor, we would propose the filing of simultaneous briefs. We would propose, I've discussed the date, at least with the council here in the room, but not the council that are attending remotely. I've proposed, and I think there's an agreement, that we file simultaneous briefs on Tuesday, September 7th, the day after the Labor Day holiday.
I have no concern if council wants to file the briefs on September the 7th. That does, though, by necessity, I think, for the commission, in order to get an order by the 24th, that there would not be an opportunity for response briefs.
That's correct, Your Honor.
And that everyone is comfortable with that being the case.
Yes, so simultaneous briefs, no reply briefs.
Okay.
Now, I represent that, from the council here in attendance. I'm not,
That's why
I have not discussed that with the council that are appearing remotely.
That's why I was going to ask specifically, Mr. Fitzgerald, simultaneous
Yes, Your Honor.
briefs with no opportunity for a response brief, with the simultaneous brief being filed on the 7th. Are you okay with that?
I certainly am. That's fine. I just had to check my schedule for a minute because I've got a couple of Court of Appeals briefs due next week. Yeah, the 7th would work just fine.
Okay, no opportunity for a response. Mr. Childers,
Understood.
are you here? Mr. Kurtz, that's okay with you?
Yes.
Is that okay with the Attorney General's office? And Mr. Spinard, you're
Yes.
fine with that? Okay, so we'll do only simultaneous initial briefs due on the 7th of September.
Correct.
And the case will stand submitted 12/01 on the 8th. Okay. I do have a couple of requests. And it's not something that anybody has to do, but I think it would help the commission's determination of I was gonna say just and reasonable rates in this case, but Mr. Kirk may object to say some of them ought to be just not discriminatory. So, I would appreciate for at least the companies and any of the intervening parties that have proposed what they believe to be avoided cost rates on the QF front, for SQF and LQF, this is your choosing, but I think it will help our determination. The compliance of those proposed rates with the PURPA regulations and statutes, both the state and federal laws. The last thing the commission wants is to adopt a PURPA rate which runs afoul of statutory regulatory scheme.
So, Your Honor, you're suggesting this is an issue to be addressed in the briefs?
I would ask if you would address it, that's right.
Certainly.
The individual parties' position on their own proposals, and if you would like, this is obviously your choosing of the brief, whether someone else's proposals or some other proposal in the case would, your legal opinion or the party's position, run afoul of the PURPA statutes, the CFRs, state regulations.
Right. No, I just, versus a data response or something. I think it's
That's
appropriate, and that's what I would respectfully suggest, is that it be addressed in the brief.
That's my hope, is that as a portion of the brief.
Okay.
That's right. I think it's exclusively a
Chairman?
legal issue. Yes, Mr. Fitzgerald.
I'm sorry, I get a little dense this time of the day. Did you say that it would be okay for those of us who have not proposed a specific QF rate to comment on whether we believe the other parties' proposed rates would, which ones we believe are the non-discriminatory and fair, just, and reasonable, and whether those rates do comport with state and federal constraints?
I think that the answer basically to your question is yes, but I of course think that any party in this case ought to be able to brief any legal issue they'd like. But I think that would be helpful for the commission's determination as to the appropriate rates for LQF and SQF.
But we'll be happy to do that. Thank you, Your Honor.
Thank you. And then, Mr. Riggs will continue to entertain any motion the company's file for an informal conference on the outstanding issues of the case.
Yes, I
But in
expect to file
particular-
one tomorrow.
In particular, that issue around the liability, what it's called.
Joint account liability.
account liability.
I expect to file one tomorrow.
Okay. Is there anything else that we need to take up at this late hour?
Just to be clear, when you began your set of remarks, I thought we were going to list maybe 2 or 3 issues you wanted briefed. Is it just the one issue, or did you have another?
I don't want to give you any more work than you bargained for. I think as a legal issue, with what we need in front of us, that I think it would be helpful to just have that primarily as an issue.
hang on, it's.
Yeah, sure can.
The whole thing's got to load, I think, because I have nothing to start
Okay.
recording.
That's fine.
There, okay, hang on, now it's, okay, we've got everything back. Whoa, my heart was about to go crazy. Hang on, it's just got to load, it's got to load all the whole day's hearing again.
That's okay.
It's about 11 hours.
That's fine. Yeah, we're online.
Okay, sir, you're on.
Okay. So, Mr. Riggs, you'd asked if there's anything else, I think, before the record went off. Is there anything else that we explicitly wanted to brief? Is that correct?
That's correct.
Vice Chair?
No.
It could be it. Everything else is, there's a big record to write about, whatever else you all would like to brief.
I mean, and I think it's basically subsumed in what Chairman said, but just the applicability of that new purple reg to what we're talking about,
Okay, certainly.
whether it even is applicable.
Right.
And the line losses provision, the different things in our current regulation too.
Right.
So, okay. Is there anything else that needs to be taken up? Mr. Fitzgerald?
Now, for the joint interveners, Your Honor, again, I really appreciate everybody's indulgence regarding Mr. Owen, and we look forward to getting the supplemental data request and turning that around as quickly as we can, and to getting the briefs filed. So thank you.
Okay. So we will not be able to get the order in today, setting the schedule going forward, but we will get that in by the end of the day tomorrow. So, and if, of course, as always, if something should come up and you need additional time or relief or something else, or whatever it may be, we just ask that you timely file a motion. Okay. With nothing else, we'll adjourn the hearing. Thank you.
Thank you.
Thank you.